report dated 9th August 2024 to the present judgment. Right.
May please, Your Lordship. Lordship, this appeal is filed challenging the orders of the court below. Challenging the orders of the court below in a recovery suit, my lord, filed by respondent for claiming an amount of 51 lakhs for the fabrication work
It is
undertaken by
decreed against me. It is decreed against me.
Yes, my lord. It is decreed against me, my lord.
50%.
But I filed the appeal. 1 minute, my lord. If your lordships could appreciate, I filed the appeal on two grounds, my lord. One, with respect to jurisdiction, the court below lacked jurisdiction because the parties agreed to exclusively add jurisdiction of Secunderabad Court, my lord. But City Civil Court Hyderabad entertained the suit despite taking an objection with respect to the jurisdiction, my lord. The suit was not maintainable on that aspect itself. And second point with
How
respect to
that issue was considered with the
She not even framed.
yes, my lord. In fact, we have filed. Your lordship, that's my grievance, my lord. In fact, one of the grievances
like
that
that.
issue is not even framed.
So then you make the appeal.
Your lordship, the grievance is that issue is not even framed despite an objection being taken on maintainability.
You should have filed an application to frame an additional
Under
issue.
1401, you could file application.
Lordship, but if we have filed a written statement where exclusively we have mentioned
Maybe,
about,
madam, you knew that issue is not framed. That objection which you are trying to raise was never dealt with the trial court because you are not diligent enough to raise.
very well, my lord. Then one submission I may be permitted to make, my lord. With respect to second objection that we have taken is with interest, my lord. The court has granted interest over interest. When the suit itself is filed for 51 lakhs, the principal amount is of 30 lakhs, my lord. They have calculated interest at 24%, made it 51
We are not
lakhs.
asking to deposit 30 lakhs. We are asking you to deposit only 25 lakhs.
Your lordship may say that I am ready to deposit the principal amount, my lord.
Okay.
As far as interest is waived, then I am.
What is the principal amount?
Principal amount is 30 lakhs, my lord, which in the plaint itself, the plaintiff I mentioned.
No,
They
decree.
have admitted in the written statement and in the
No,
prosecution.
no, decree is for 50
It's an
lakhs.
admitted amount, my lord.
No. Decree is 51 lakhs.
Yes, sir.
She is willing to deposit more than 50%.
Yes.
Yes, sir. Why? Because it
That's
is.
the usual order.
It is more than.
I mean, that's the usual order.
More than 7 years interest is calculated coming up to 50 lakhs.
That's the reason.
One more 50.
Yes,
One
sir.
more.
Yes. sir.
Yes,
With
my lord.
business transaction,
When the plaint was
Interest
filed,
is
my
granted
lord,
only
they have
9%,
calculated
my lord.
interest.
9%.
18% they have awarded. 18%.
Your lordship may
Applied
kindly.
EP for 1,12,000.
1 lakh.
1 crore.
1 lakh, 1 crore 12 lakhs.
One submission, my lord, page 34, if your lordships could see in the plaint, my lord. Page 34 of the
They have
plaint.
intentionally withhold the amount.
I may be
I
permitted
will
to.
adjust the amount in the written statement, my lord.
I'll just point out one thing, my lord, and I'll leave it to you.
What is the transaction?
Business transaction.
Business
I
transaction.
did work for them, fabrication and steel
I'll
work,
explain
by
what I
investing my
forgot.
amount of 30 lakhs and having confirmed that under exhibit B6, A6,
Oh, entire
Invoices.
Himat
exhibit A3, A4 is the statement
Entire
prepared by
Himat
them.
Nagar is built by these persons.
Yes,
right?
my lord.
It is my amount.
Your lordship, ma'am, for the
Yeah,
petitioner, my
in fact,
friend may
this was
respond.
about
Once I
my
finish my submission, my friend will have an opportunity to respond. I will just make one submission with respect to interest, my lord. Your lordship may kindly take the plaint, page 34, my lord. The plaint itself, they have given a tabular form, my lord, at the bottom of the page. The calculation for particulars is given. Principal amount is 30 lakhs 19,000. They themselves have calculated interest at 24%, which is coming up to 21, my lord, and the total amount is 51 lakhs. The court below in the impugn order, despite interest already been added, my lord, they have now on interest added another 24%, my lord.
18%.
Yes, my lord. 18 plus 6%, my lord, which is 24%. So I'm being made to pay interest on interest. The Supreme Court have clearly stated as recent as March 2024 that is not acceptable.
That appears.
So I'm ready to pay the principal amount. If the lordship may direct me to pay within 1 week, I will make the payment.
So already the party has approached us for compromise for payment in installments, the entire fixed amount.
Then wait.
Making several.
Wait. Then sort out.
Okay. Admit.
Comparing to value of the money day to day, it is multiplying.
No, but-
Many.
What's your name, sir?
K. Praveen Kumar Reddy.
K. Praveen Kumar Reddy takes notice for the respondent. And orders passed by the second additional chief judge, City Civil Court, Hyderabad. Third additional chief judge, City Civil Court, Hyderabad. The orders passed by in OS number 287 of 2018. dated 12th June 2024, he stayed subject to the condition with deference deposit. The principal amount of rupees
30 lakhs,
31
19,000. 30 lakhs,
31
19,000.
lakhs.
31 lakhs,
30 lakhs, 19,000.
30 lakhs 19,754.
30 lakhs 19,754
54.
within a period of 2 weeks.
Cost
So
of what
50%
are
of the interest.
And
Interest
cost,
is not-
it is allowed with cost.
No, interest is allowed, my lord. 18 plus 6% interest is allowed.
50% interest. on
Lordship,
cost.
interest is not even contemplated in the agreement. Supreme Court judgments are there, my lord. I will place it before your lordship, which says that unless parties.
Any of
agree-
compromise talks are going now.
Yes,
We
ma'am.
try to resolve it.
Deeply.
Our complaint is 18% against 6% is bad. That we can straight away delete. Irrespective of 18%, it can go ahead with the compromise talk,
Achha.
whatever it is.
Achha.
That portion of 6% on interest can be removed and litigation can be resolved. Right. Make an attempt to resolve the issue, madam, because he's a worker, you are a builder.
Yes, sir.
You must understand he has worked for you.
Yes, yes.
In this case. Madam, I am for the appellant, my lord, the respondent died.
Because, right. See that it is resolved.
Deeply.
Yes,
Madam, I am for the appellant, my lord, the respondent died, my lord. As per my instructions, my lord, respondent died on 27/8/2020, my lord. All consequential benefits claimed by the respondent wife, my lord. With effect from 1/9/2020.
which case?
Item number 6, my lord.
6.
what about for 4?
4, 5.
Item number 4 is covered by item number 6 litigation, my lord. Item
Madam?
30 retirement, my lord. They are retiring 58 years, my lord. Instead of 60
2
years.
weeks time may be granted, my lord. We will file death certificate.
Wait, Mr. Naresh, 1 second.
Questioning retirement 58 years. Serial number 6 litigation by filed, my lord. They are allowed in the favor of the respondent is serial number 6, my lord. Questioning with the filed with the appeal, my lord. It is covered by
1 second.
Come on, cost it, docket in. 6 law.
Where is GP?
Yes.
AG?
You are also there, no?
Advocate
Yeah,
AG?
item 5, Miller.
What is it?
Mine is only repetition. Because unless recapit is heard, Miller, it has this. Recapit is-
So these two are 4 and 5 covered by the 6.
Yes.
Suppose recapitulate this way, then 4
Yes,
and 5
5
are
also
allowed.
6, Miller. It is covered by 6.
Madam, I am appearing in item number 6, my lord.
Same below.
There is no stay, no.
No, sir.
No stay, they retired.
So what remains? Everything has become infructuous.
Because only they get the
Right.
non-treated.
It has become infructuous, no stay. 2003, 21 years.
Yes. 20 years.
Yes, ma'am.
You are appearing for sports authority.
Yes, my lord. Present standing counsel representing Mr. Gudi Satish Reddy.
Correct. No question of adjourning. It has become infructuous, no stay.
Yes, my lord.
Yes, and I can.
Because it is, they will pay the benefits for 2 years.
My lord, the respondent wife claimed all consequential benefits from 1/2020, my lord.
So I would-
Right. item number 6, Rajpata, 34, writ appeal 34. The present writ appeal is filed,
Yes.
agreed by the orders filed with the Leonard Single Judge
493.
in writ petition number 493 of 2004, dated 30th September 2010. Heard. What's your name? MVS Prasada.
I'm returning Mr. Gudi Satish Reddy, my lord. Gudi Satish Reddy.
Gudi Satish Reddy, counsel for the appellant, and BG Ravindra Reddy for the respondent. It has been contended by the appellant that the respondent is working as a coach in gymnastics, and he was contending that he should be continued up to the age of 60 years. When the request of the respondent was not considered and he was made to retire at the age of 58, he has approached this honorable court by filing writ petition number 293 of 2004. And a learned single judge of this honorable court was pleased to allow the writ petition, with orders dated 30th September 2010 and directed the appellant to continue the respondent up to the age of 60 years without appreciating any of the contentions raised by the appellants. Counsel for the appellant had contended as per Sports Authority Rules 1993, as per Rule 25, every employee was entitled to be continued up to the age of 60 years. However, the said rule was amended with GMS number 171 dated 12/12/2003, wherein the age of superannuation has been fixed as 58 years uniformly to all the employees. When the rule itself is amended, the question of continuing the respondent up to the age of 60 years would not arise. Therefore, appropriate orders be passed in the writ appeal by setting aside the orders filed with the learned single judge in petition number 493 of 2004 dated 30th September 2010 and allow the writ appeal. The counsel appearing for the respondent contended that when the respondent was appointed as a coach, Rule 25, unamended Rule 25 was prevailing in the Sports Authority Rules 1993, and any subsequent amendment shall not affect the service conditions of the employees who are already in service. That too, without giving any notice and opportunity, rules cannot be amended to the detriment of the employees. Therefore, the learned single judge was justified in allowing the writ petition by allowing the writ petition, and the learned single judge has categorically held that the rules cannot be amended by way of a GO, by way of an executive instruction. On this ground, the learned single judge was justified in allowing the writ petition. Therefore, there are no merits. The counsel for the respondent has further contended there are no interim orders passed in the present writ appeal suspending the operation of the learned single judge order. And this is a case pertains to 2003. Now we are in the year 2024. The only issue is the appellants must pay the consequential benefits for 2 years. Therefore, interfering with orders of learned single judge at this point of time may not be feasible. Therefore, there are no merits. Writ appeal is liable to be dismissed. Okay. This court. Okay. The first the counsel for appellant had contended respondent. First are the argument. The counsel for the respondent had contended the respondent was initially appointed with the sports council, and the AP Sports Council rules contemplated that every employee should be continued up to the age of 60 years. Subsequently, after enactment of Sports Authority Act 1988, the services of the respondent was inducted into Sports Authority, and as per rules of Sports Authority 1993, the age of superannuation for all employees was 60 years. By way of an executive instructions, the appellants are trying to reduce the age of superannuation, which is not permissible. This court, having considered the relevant submissions made by the parties, they have considered it. The learned single judge has rightly allowed the writ petition in favor of the respondent, as admittedly the age of superannuation of employees of Sports Council was 60 years. Even after enactment of Sports Authority Act of 1988, the age of superannuation of all employees was 60 years. By way of an executive instructions, the appellants were trying to alter the service conditions by reducing age of superannuation. Moreover, a division bench of this honorable court has not suspended the operation of single judge's orders, and this writ appeal is of 2011, and the orders passed by a learned single judge are dated 30th September 2010, and the matter pertains to the year 2004. So the orders must have worked out on itself. Interfering with orders passed by the learned single judge at this point of time would not arise. Moreover, the respondent has already attained the age of superannuation. The only issue which has to be adjudicated is whether the appellants must pay 2 years benefits, service benefits to the respondents. Therefore, we are not inclined to interfere with orders filed with the learned single judge. Writ appeal is dismissed. In your the dismissal of writ appeal, no further orders need to be passed in writ petition number 161/85 of 2003 and 1745 of 2004.
Allowed. Petitions are may be allowed.
What's that?
Petitions may be allowed.
Your
May be allowed. Extending the same. Yes.
All these writ appeals, all these cases, there is 2 writ petitions and writ appeal are being disposed of by way of a common order. As the issue raised in all these cases is one and the same.
Yes.
For convenience of facts in writ appeal number 34 of 2011 are here under discussed, right? At the last note, in your the dismissal of writ appeal 34 of 2011, the consequently writ petitions 161/85 of 2003 and 174/5 of 2004 are liable to be allowed. Accordingly, they are allowed.
My lord, humble submission, my lord. Our submissions may be recorded, my lord. The respondent died on.
Elaborate.
Okay, Martin, if I know. After dictating the judgment, the counsel for the appellant in writ appeal number 34 of 2011 has informed the court that the sole respondent has expired. If the sole respondent has expired, and if no steps are taken by the appellant to bring the LRs of respondent on record, then the writ appeal stands abated. Accordingly, apart from merits, the writ appeal also stands abated as no LRs are brought on record. Right. Next.
Deeply obliged.
You have helped us, right? Thank you. Please argue the case. No question about it. Don't know anything. No, sir. No Mondays. Friday. What is the case?
With your lordship's permission, my lord.
Yes, ma'am.
My lords, Mr. D. Srinivas Prasad's name is printed. My lord, we have given up wakalat in this matter. Your lordship may kindly direct the registry to delete their name, my lord, and notice may have to go to the respondents. My lord.
Suppose if you are allowing this, otherwise,
Judgment. Yes, what is the case, Chapan, sir? What is the extent of land they have occupied?
The land grabbing case was filed by the respondent but got allowed. Challenging the land grabbing court order. The present petition is filed.
no extent, I think 447 square inch.
250 and 195. As a last indulgence, madam, as a last indulgence, case is adjourned by 2 weeks, in spite of the fact that the petition is listed on the caption of dismissal, so as to enable the counsel for the petitioner to appear and argue the case. If and it is made clear, no further time would be granted, and if the petitioners do not argue the case on the next date of hearing, orders will be passed accordingly. Next.
Sorry, my lord, the other day I was not there. So this petition is filed, my lord, questioning the order of the special court, my lord. Lord, allowing the, Lord, under the Land Grabbing Act, my lord, the applications were allowed, my lord, and the writ petition was, my lord, held, my lord, they are the land grabbers. Lord, the facts of the case is like this, my lord. But, my lord, around 2 acres of land, my lord, the respondent, the writ petitioner, one, my lord, said to have been, my lord, entered into an agreement of sale dated 1/11/1992. Thereafter, my lord, in 1/12/1993, my lord, he said to have been, my lord, executed, my lord, GPA, General Power of Patal. Lord, based on these two documents, my lord, the applicant, my lord, who is the respondent herein, my lord, first respondent, has executed the sale deeds, my lord, in favor of the other respondents, my lord. And, my lord, they says, my lord, that I have obtained the, my lord, the layout sanction plan and given to them. Thereafter, my lord, they have developed the roads and drainage. And then, my lord, while so, my lord, on somewhere in, my lord, 31/8/2002, my lord, I have grabbed the land by, my lord, bringing the tractor and removed all these things. My lord, then, my lord, the as statutory report has been called for, my lord, by the special court. My lord, the Mandal Revenue Officer has submitted its report, my lord, on 9/1, my lord, 1992. My lord, while so, my lord, the MRO's report clearly says, my lord, it is a joint family property of 28 acres land. And, my lord, this is within the, my lord, Hyderabad urban area. My lord, land sealing proceedings, my lord, filed. And, lord, the government has, my lord, said, my lord, that it is been surplus land. Then, my lord, I filed the appeal, obtained the stay. And these matters are pending. The documents filed by the, my lord, the MRO with along with the report, and Pahanis also filed shows, my lord, the entire, my lord, the respondent or family are in the possession of the property. Pahanis also have been filed. Lord, despite of this, my lord, the court, my lord, below has taken, my lord, cognizance of the case.
Whose land is it originally?
My lord, the land belongs to, my lord, the writ petitioners, my lord, their family members.
Correct.
My lord, then, my lord, they have, my lord, it is before on 1980
No,
itself.
how the applicants before the land grabbing court were claiming?
My lord?
How the applicants before land grabbing court were claiming the property?
No, they says, my lord, is on 1/11/1992 is the agreement of sale by the writ petition number 1 in favor of, my lord, the applicant 1.
Correct.
My lord, then, my lord, GPA was given to the second applicant's wife. But based on that, my lord, the first applicant has sold, my lord, property, my lord, plots, house plot, in favor of, my lord, the other applicant.
You have sold the land.
My lord?
You people have sold the land.
No. My submission is, my lord, these documents were brought into existence. And my lord, the funniest part is, my lord, that layout has been obtained by me from the Gram Panchayat. In fact, my lord, I never obtained any layout from the Gram Panchayat. And the Gram Panchayat is not there at the relevant time. Kaupur is the, my lord, is the municipality.
Correct, sir. 1 minute. You sold the land to the applicants.
My lord?
You sold the land to the applicants in the form of GPA,
Agreement
agreement
of
of sale. You have accepted
that
the
what
money.
I-
1
no.
minute, just listen. You have sold the land and trying to GPA everything.
No.
Now again trying to claim the land.
No, my
It is not
sub-
permissible, right?
Yes, no, my submission is this, my lord. My submission is this. I never executed, my lord, that the agreement of sale, as well, my lord, GPA. I specifically deny. My lord, the other thing is, my lord, the.
Denying is the easiest thing.
No, 1 minute, my lord. See, my lord, the agreement of sale contains, my lord, the signature. I said, my lord, the petitioner, the rich petitioner one, my lord, is an illiterate, is only thumb person. In spite of all these things, my lord, trial court records, yeah, my lord, finding that in an admitted fact that, my lord, I am the absolute owner. When I said it is a joint family property, you like may kindly say,
What is there in the land now as on today?
my lord,
What is
as
there?
on today, it is an agriculture land, we have been cultivating it. And my lord, urban land ceiling, my lord, act has been, my lord, repealed, my lord, therefore, my lord, position has not been taken, it is with us. And my lord, earlier,
It can't be with you. It has to be regularized in terms of some GO 455 or 4.
no, whatever it is, my lord, petitions are pending.
Whether those proceedings have you taken up, if it is surplus land, then it will go to the
No,
government.
my submission is, my lord, writ petitions are pending. I'll take your lordship for
What
evaluation.
are those petitions?
My lord,
What are those
your
petitions?
lordship, my lord, I filed the additional,
What petition is pending?
no, 1 minute. I filed the additional affidavit, my lord, your lordship may kindly see.
But the one fact in fact remains that you execute agreement of sale, GPA, basing on which they have taken layout from the Gram Panchayat.
No, they said, my lord, I have taken layout.
That will be taken your name only because you are the only GPA holder. You will be reprinted. Your name will be there. Reprinted by GPA holder.
So,
It will not be in their
no,
name.
my submission is 1 minute. My submission is, my lord, sir, whatever that layout is there, layout, my lord, they have not filed the layout
But
copy.
even the layout will be taken. Suppose if the owners by the raise will sell it, their name will be there. In the GPA holder, that your name will be there.
No, my submission is, my lord, my defense, and it is brought on record, is that, my lord, the layout has not been part of the record one. Second thing is, my lord, I obtained the RTA, my lord, from the relevant date, the Gram Panchayat is existing or not. They said, my lord, that 1987 onwards, my lord, it is Kaupur municipality, not there. Therefore, then, my lord, they said, my lord, they developed the roads and drainage. And, my lord, nothing has been, my lord, they have produced a piece of
1
paper.
minute, sir.
Yes,
Applicants 1 and 2 have sold the property to 3 and 13.
yes, ma'am.
Correct? Small extent of land.
No, my submission is, my lord,
You don't know applicant number 1 and 2?
no, I don't know about it.
Huh?
I don't know that. What my submission? My submission is, my lord, even otherwise you last can see with the threshold, the court below ought not to have been taken cognizance of the, my lord, the application because there is a statutory obligation, my lord, as per the rules, my lord, as per rule 6, specifically says, my lord, that report to be called for. And then, my lord, the MRO admittedly has submitted the report, enclosing all the things. It is a joint family property, and these family members are in possession of the property, and urban land sealing proceedings are pending, and writs are pending. All the documents also filed.
Where
My
are,
lord.
where are those writs?
My lord,
Where are those writs? Give those writ numbers.
Documents, what are the documents?
no,
However, implead petition is pending.
No,
my
no.
lord.
Who's in period of petition?
My lord, I am representing on behalf of the council who has filed the implead petition in this, my lord.
They weren't the.
My lord, I have no indent with regarding the same. my lord. There is an implead petition pending.
para 35 of
They are
the,
online.
Prasad Sanka, my lord.
IA 2 of 2023. Shobhanan. Who is Shobhanan?
Okay, we'll order this IA. What is 2016?
my lord.
WPMP is also there. In two implemented audit chain post after 2 weeks. Give those numbers, repetitions which are pending against.
Yes, I will file the document. I'll give.
You also place on the kind of whatever pending.
I filed the additional affidavit, my lord, with the RTI, my lord, statement where, my lord, this was mentioned.
Post after 2 weeks. Next.
Let me delete from the, my lord.
No.
No, because the other day, my lord, by the time I reached, my lord, this was
2007 matter.
No, doesn't matter, my lord. I will be, because many times I appear, my lord, but other side is not there. Therefore, this matter was underwent several jobs. Last time, my lord,
Delete from the capture of dismissal. Post after 2 weeks. Why, madam? What is the case? Okay. As the last indulgence, case is adjourned by 2 weeks, in spite of the fact that the writ petition is listed on the caption of dismissal. And it is made clear if the case is not argued by the petitioners on the next date of hearing, order should be passed accordingly. Next. Next. Yes, Balmohan Reddy. None appears for the petitioners, in spite of the fact that the writ petition is listed in the caption of dismissal. A perusal of the record further discloses that on several occasions, none appeared for the petitioners. And on 27/8/2024, on 27/8/2024, case was adjourned as a last indulgence, even though the writ petition was listed under the caption of dismissal. And today, when the case is listed again, none appear for the petitioners. This court has no other option except to dismiss the case for default and non-prosecution, according to the same English case. You are for?
No problem, don't worry.
Next.
Your Lordship, I'm a petitioner. We got this through NOC. We didn't receive any complete bundle of files. As such, we have filed CDs, yet it's not complied. So kindly, 2 weeks time will be granted. We'll get all the facts and documents and
But I'm informed that respondent number 2 also died by that. Because one of the, I just morning only I received information. Respondent number 2, my lord, it's died.
Applicant before the LGC.
Yes, my lord, LGC, because
You are applying for?
respondent number 2, my lord, it's Das Lakshmi, my lord.
You are successful before LGC.
Yes, my lord, I just, my counterpart informed me, my lord. Because in my absence, my lord, they have created a GPA and transferred the land, my lord. It's subsequently, because she had been to a US, my lord, but to see the children, my lord, during that period, my lord, they have created a GPA and they sold the property, sold the property.
That's also come up?
Yes, my lord.
Free of cost.
No. And then, my lord, she lodged a complaint to the Register of High Stamps, my lord. They catch.
When the matter is taken up for hearing, the counsel for the respondent has informed the court. The second respondent has expired, and we need to bring LRs on record. And the counsel for the petitioner is requesting time, in spite of the fact that the writ petition is listed in the caption of dismissal. As a last indulgence, case is adjourned by 4 weeks, so as to enable the counsel for the respondent to bring the LRs of second respondent on record and argue the case. Post after 4 weeks. 11 number. Yes. Huh?
Already 2 times dismissal.
And the last indulgence case is adjourned by 2 weeks, in spite of the fact the petition is listed at the caption of dismissal, and it is made clear. If the petitioners do not argue the case on the next date of hearing, the orders would be passed upon the request.
Respondents.
Yes, case Murthy. Yes.
Petitioner 192 has died. They filed LR petition.
That's already on record. That's already on record.
What is the case?
Land grabbing case filed by the petitioner period was dismissed. Because the father of the applicant who is the applicant for land grabbing court, he has already sold the property in 1955 itself to all the respondents. Thereafter, Miller's sons created a dispute as if the proper father has not divided the property amongst his sons. They obtained a collusive decree and sought to Miller their claim that they were in possession of the property.
Okay, we'll dismiss.
And the revenue records. And lastly, on the ground that they have mistaken accounts on the 21st August 2024.
No. You were refusing to hand over the record other day. Client was present in the court.
September 2024, the Supreme Court Millard, in fact, the party was also present.
He has taken the bundle in the court only.
And one or the other ground where this is going on. And the revenue record showed the name of the respondent since 1955.
Yes, you are paying for? Argue the matter. Last time you have counselor.
Okay, as the last indulgence case is adjourned by 2 weeks, in spite of the fact that the petition is listed in the caption of dismissal. And it is made clear, if the counsel for the petitioner doesn't argue on the next date of hearing, orders will be passed accordingly.
Item 14,
Matter, my friend has just now served the counter. And we know the figures which are shown in the counter and the figures which were.
Settlement happens where the settlement on the pretext that no inquiry will be taken out. But all the monies which were as per that amount were paid. Disputing certain portion. The first 8 lakhs was paid, then again further was 4.5 lakhs, 5 lakhs, then 8.75 lakhs.
Okay, first after 4 weeks, next.
Sure.
Lord, in this matter, Lord, they have stated that they have complained, Lord, but I got the instructions from my client as well as my senior that they have not complained since they have kept it in the blocklist.
What kept it in?
I have filed IA 1 and 2 Millard to leave, grant leave and to implead. It is coming up for counter Millard.
Contempt claim plead Mandi. What? Why?
I have filed, it is coming for counter. I will argue that also.
Where is the compliance?
The order of the division bench was to restore the entries, but it amounts to restoring the entries prior to the order of the Honorable Lopez. But prior to orders of the Honorable Lopez, whatever name was there is now restored. They say it should not
They
be
have
in
kept
block
it for
list, and
block
there is a
Millard.
litigation between parties, they have kept hold, but entries have been restored, that whatever entries were.
But they have kept it in blocklist, Lord. That is the reason.
Not the-
Let it be argued by my senior
There is no
Millard.
other petitions they are filed, there they have status quo orders and all the contest is going on, suit has been filed. But for all that reasons, some block list has been placed, but entries.
Until and unless there is no specific order, Millard, blocklist cannot be imposed in Lord. Just because of initiation of the suit, it cannot be kept in the blocklist.
Page 21, top para.
of the considered opinion of this court, as this court has set aside the order dated, all subsequent orders and.
Okay, when the matter is taken up for hearing, it is noticed that the respondents have corrected the entries in Dharani portal, which would mean that the orders passed by this honorable court have been complied. Contempt is accordingly disposed. Right. If the petitioners are still not satisfied, they are at liberty to pursue their remedies in accordance with law. Right?
The petitions I filed, yes, I filed.
Not necessary. Contempt is disposed. They are accordingly disposed.
Please, but yesterday there was some connectivity issue.
Yes.
Your lordships was wanting to allow IA3. Lordships may allow IA3, I'll file
That's
a
what
detail.
I told you yesterday.
Because I'm sorry, Manoj, what happened was I didn't understand and my instructing counsel clarified. Because I'll file a detailed reply to the CRP.
IA number
Because
As far as IA is concerned, of course, my friend said, as far as CRP is concerned, this CRP came twice earlier, and there is no question of any counter in CRPs. Your lordship is well aware.
No, there is some.
Let me submit, then you can submit.
Absolutely.
There is no procedure of filing any counter in CRP.
Yes, sir. We'll order this. We'll have it on.
And your lordship may post at the earliest. Yes. Much okay.
Because I have to come from Delhi and my learned friend is writing those judicial exams. Your lordship will have it immediately after 10th of November. We'll do it. Manoj, the 34 is listed today. I'm going to go and argue it. If my learned friend is there. Because 9th February 23, I didn't interrupt you, you'll be exact time to me. 9th February 2023 order, 1 year, 3 months, 4 months later, in June of 24, they filed this. 14 months later, and if I'm asking for 4 weeks, my learned friend is writing those exams.
What is 34?
Was the 34, the section 34 arbitration, Manoj, because this is a very peculiar
What
case.
happened to 34? That's still pending?
That's pending. It's listed today. I'm ready to argue it today, Manoj.
What is CRP now?
Milord,
The CRP, I will explain. Because
Milord, I have filed the CRP. It is my right to explain.
A question
There is
was
no question
asked
of
to me. My learned friend will be that kind.
Please, Raju. Okay. Please tell us.
Yes, Milord. They have filed a stay petition, Milord, in section 34 application. Stay was.
What is in their favor?
The award was in my favor, Milord. I am the claimant.
They have challenge.
Yes, Milord. I am the claimant. The learned arbitrator passed an award directing the respondent in the present CRP to pay an amount of rupees around 15 crores. Milord, this is a money decree, Milord, award. And they filed. And then, of course, they have sought stay. I have opposed it.
Right.
Then the learned commercial court judge passed an order directing them to deposit 3 crores.
On the 15 crores.
15 crores. Right. And for the remaining is in the form of immovable property.
Correct.
They have complied with the order.
Correct.
They have complied with the order. I prefer the present CRP because I am aggrieved. One is in granting stay, and the two on the conditions what was imposed, and third is no amount to be drawn by me. In fact, there are costs imposed by the learned arbitrator. Costs are not even deposited. If your lordship is aware, at least the costs are concerned, it has to be deposited in addition to the award amount.
So you are asking modification of that stay order?
Yes,
in the
Milord.
CRP.
Yes, Milord, that's all. Because
what is that modification you want?
Milord, there are two aspects. One is there is an admitted liability towards me.
What is it?
In the form of 2.34 crores.
But
towards the loan.
No.
Loan I have given.
No, 1 minute. Commercial court asked them to deposit 3 crores, no?
Yes, Milord.
Then?
No, Milord. What I am submitting is, Milord, the total award is 15 crores.
Correct.
20% of the amount was deposited in the form of money. And the balance is in the form of immovable property.
Hey, you can file a modification of that stay application.
No, Milord, I have sought it. I oppose
No,
it. It's on merits. Milord, it's on merits it has been. In my counter itself, I have stated so that if for any reason the stay is being granted, any amount is being deposited, I should be given a liberty to withdraw it. The learned judge did not deal with that particular issue.
Manoj, there are some facts.
One minute.
So sorry.
suppose he has complied that interim order, whatever stay has been granted in their favor. You want further modification of some orders, now that they have deposited 3 crores. Permit me to withdraw, you can file an application.
Yes.
There. Or now that it is more than 1.5 years have lapsed, the main 34 application is not being adjudicated. Now, in order to, in the interest of justice, you can say, make it 50% of the deposit of that original award. All these things can be adjudicated there only, no? Why come here?
That's an order of merits, it has been passed.
Correct, sir. One minute, sir. That was passed 1.5 years back. Now, with the changed circumstances, you are entitled to file additional applications seeking modification of that initial stay order. That would be more appropriate, I think, because 1.5 years back, some blanket stay, maybe not blanket stay, maybe on contest it was granted. Now, thinking that the commercial 34 itself will be adjudicated within 1 year or 6 months. Now it is more than 1.5 years. Now prejudice is being caused to you because of this stay order. And whereas you have got an award of 15 crores, not even 50% is deposited. You can, these are all subsequent events. You can go before the commercial court and apprise the court. Now that they have complied 3 crores, permit me to withdraw. They'll permit you.
Because in fact, may I just make 2 submissions? Because I am ready for a time-bound direction that the 34 be decided time-bound. Because this is a case where the claim petition was for 2.5 crores and 15 crores has been awarded.
We'll dispose of this CRP straight away, directing commercial court to entertain your applications seeking modification of that earlier stay which was granted 1.5 years back.
And decide it on merits.
And decide the entire 34 on merits as expeditiously as possible. That's all.
As far as 34 is
no,
concerned,
we cannot modify. No.
As far as 34 is concerned, there is no difficulty because, but there are 2019 section 34 applications which I filed itself are pending before that court, which I am appearing in as a respondent before the commercial court. 2019 matters. These are 2023. Court may be able to take, may not be able to take because of the work pressure and all that. Your lordship is aware. There is a statutory provision. There is no doubt about it.
Now that
it's listed today, I'll start arguing today. The court has given a date of today.
Your arguing will not resolve the entire issue. No?
Yes,
everything depends on the pendency of the
cases
before the commercial court.
Absolutely.
It is not that easy task. No. Deciding 34 is a Herculean task.
Yes.
The pendency of cases and all those things.
Yes.
Also, counsels from outside, they come and argue, so complicate the things and all those things. Not to say, but these are the things which happen.
I have inherited a record which is this big.
No, that's the reason, sir. So, what objection can you have if he is permitted to withdraw those 3 crores?
I'll just explain. Originally, he filed a section 11 before this court. The claim mentioned there was around 2.5 crores. When the statement of claim came to be filed, the claim mentioned was 3 crores. Because in his evidence affidavit, he raised a claim of 15 odd crores and that came to be awarded.
Section 11 application.
It is his claim I am defending. So, this is a very peculiar case.
In his claim?
In his claim, it was only 3 crores. And that file is not here today. The statement of claim is not before your lordship. Because every time I start speaking, my learned friend starts interrupting in panic. Because this panic is not fair. Because courtesy to let the court talk and then not interrupt the others.
Hey,
And Manoj, please see the impugned order.
Anyhow, you have complied with stay orders always 34 crores. Just listen.
Yes.
Now, what difficulty you will have if he is permitted to withdraw?
Because I will just explain that. This is a case where he is not entitled to any money, and I have made that good. The award, my lords, one of my arguments against the award is biased.
He'll furnish security and deposit that 3 crores. That will serve everybody's purpose.
With security?
Yes.
Because I'll have to take instructions on that then.
Who are you, sir? You are a bank or?
No. Private party.
I'm a private person. That generally appears for the bank. That's the reason we are analyzing.
I want to say one more sentence.
You furnish some security. We'll permit you to withdraw.
Before your lordship comes to any conclusion, I can.
We are just trying to explore.
That's what I'm telling you. There is an admitted liability of 2.34 crores, which I have given as a loan to the respondent in this, which has been admitted in their balance sheet as well as in the cross-examination of RW1. 2.34 crores only under the head of loan. I am a partner there. Other things, let be kept aside. What is the objection what they have raised is, my lord, your lordship is aware, they have said by section 16 application, my lord, that this is not an arbitrable.
What is this Saket?
Matter.
Both are Saket.
Both are
Yes,
Saket.
because
They are partners, my lord.
we were partners initially. Because he was one of my constituents.
Yeah.
Because he chose to resign from the LLP. Because if his interpretation is accepted, the entire LLP Act will come to an end. And because this is a very peculiar award and
What is LLP?
was limited liability.
Limited
partnership.
liability partnership.
Because may I say one sentence? The award says there's a continuing injunction against me from selling my properties till I pay him. There is no prayer made in the claim for a permanent injunction against me, and the learned arbitrator concludes that there will be a continuing interim injunction against me. The 34 court by detailed order has said that this award is very peculiar, and in the peculiar facts and circumstances, this stay has to be modified. Because it is not as simple as my learned friend is making it out.
1 minute, Raju, just try to understand. Are you in a position to furnish some security and withdraw? Is it possible?
As far as 3 crores is concerned, what I am trying to submit, my lord, it is an admitted liability. It is not that on merits it is adjudicated and given to me. On only objection they raised is, it is not arbitrable because it is a loan. It is not a dispute among the partners. As a partner in the capacity, I have advanced 2.34 crores.
No.
Even to take an admitted liability, after award is passed, if I am subjected to a security, my lord,
No,
it is my money.
No, can you do it is a question. In order to mitigate the.
My lord, your lordship is aware, as per the Supreme Court, one is a decree holder should be able to enjoy the fruits of it. And your lordship is also aware, prior to 2015, that is 23rd October 2015.
Just answer this question. Suppose if 34 application is allowed.
My entire money is here in my lord, block
No,
here,
just
my
listen.
lord.
If 34 application is allowed, how will you refund that amount of 3 crores or whatever you will be trying? That's the point.
I will give an undertaking. my lord. It is my own money, my lord. Anyhow, even I can claim set off also to.
Because for
Admitted
14
liability is
for
concerned.
14 crores, I have
Where
given
admitted
title
liability
deeds.
is concerned, why should I give?
Because for
undertaking,
14
my lord?
because
It is
then
only on a technical ground.
because
Their total objection is only on technical ground. I can understand, my lord, for the remaining amount, if your lordship is.
I will
directing
file
me
a reply,
on
I will
certain
place the
conditions, my
claim
lord,
and
there
the
is no
evidence on
difficulty about
record.
it.
Plus,
If-
all of this is not before your lordships, unfortunately, in the CRP file.
If they
I will
agree,
place all of that.
What she is trying to say that 2.34 crores is the admitted.
No, my lords,
liability,
it's not
also
admitted.
in
It's not
arbitration.
admitted.
Is also borne by the balance sheets.
Where exactly it is admitted?
It's not admitted.
yes,
Show us from the papers. Instead of
yes, my lord.
we saying it is admitted, show us from the papers.
Because it's highly contested, that is the entire basis of the impugned order. And one of the main points in my section 34 is that there was a bias. The arbitrator did not allow me to argue the case finally. No, no, for 15 crores, I have furnished security.
Able to show that 2.34 is admitted, the balance sheets are admission marked up and cross agreed.
Plus, let me place, Manoj, that is why I'm saying, let me place a reply if he has waited 14 months to file this petition, then let me file the statement of claim and his evidence also on the record of the court. And Manoj, with utmost respect, this kind of relief is not permissible under a 227 also, those judgments also I would like to place them.
This order passed on 34.5 application.
Yes, Manoj. In February 2023,
My lord,
I am suffering that deposit from Manoj that long.
Okay, get ready.
Question number 109, my lord. Otherwise, your lordship will post next week. I will file the cross-examination where he admitted
One
it.
minute. Next week may not be possible. Just try to understand. This order of stay was granted almost 14 months back. Just listen.
Now 20.
So we'll let him also get ready for this. When do you want?
Because my learned friend is giving those exams on 9th, 10th November. So 1 week after that, any date your lordship fixes, I'll be here.
This should Milord, there are two things.
Because if your lordships, if my learned friend is not willing to accommodate him, anytime after Diwali.
Even costs are not paid, Milord. Why after Diwali, Milord? This is a matter where.
The court said next week is not possible. After that is Diwali break.
Milord, your lordship may kindly take.
Second November working day, Nama. Second November.
Second is Saturday, my lords. I am all right, my lords. If your lordships are sitting on Saturday, then
No, you're not sitting.
4th November, your lordships.
4th November. IA 3 of 2024 for the reason stated therein it is ordered. Supposed to be 4th November.
Because will it be possible for your lordships to fix a time of 2 o'clock, my lords? Because
2 o'clock is our lunch time.
no, I mean after lunch, 2:15.
Is it okay?
As a lordship.
2:15.
I'm so grateful, my lords.
That's okay. Try to resolve the issues. Why complicate things?
Because, I'm sure my learned friend will buy me some coffee. I've come from Delhi. I'll talk to him.
Please, Your Lordship. The writ petitioner is the writ appellant before Your Lordship. If the writ petition was dismissed, the grievance of the writ petitioner was that he challenged the notification issued by the third respondent corporation in seeking to recruit junior technicians in the third respondent corporation, contrary to the standing order. The writ petition came to be dismissed on the primary ground that though the petitioner represents the interest of 400 workmen, the writ petition is in the nature of a public interest litigation. The petitioner is a registered trade union of the third respondent corporation, and he represents the
entire process is over.
The process, that is one aspect, but the writ petition is in fact during the pendency of the writ petition itself there was an interim order that the selections are subject to the result of the writ petition.
You forget, leave it.
Lordship may kindly say the standing orders say
Just
that
leave it.
Lordship may kindly, the
Entire process is over. Try to understand.
that in fact that during the pendency of the writ petition
Correct,
there is
sir.
a your
One
Lordship
minute,
may say the interim order passed.
1 minute, sir. Now, persons who are already recruited, we cannot set aside their appointments without hearing them. That's the point, right?
Just
leave it.
See the para 10 of the.
We can't just leave it. You have not implemented the selected candidates. Without hearing them, how can we set aside their appointments? Right?
Otherwise, your Lordship may at least remand back because the
What remand?
I'll take steps before the learned because the learned single judge dismissed it on the ground that it is a public interest litigation.
Don't know, sir.
No, the finding
Para 14 is very clear, right?
Para 11, your Lordship may see for a moment.
Para 14 will not allow us
This is
to.
filed, this petition is filed on behalf of 400 meter workers. That's what he is saying.
On behalf of the registered trade union, the writ petition
How
is.
many members? All are members. All are your members? Wait.
Yes.
I am the general secretary of the trade union, registered trade union.
Whether these 400 are members of your organization?
Yes, I have said so in the writ affidavit. Your Lordship is para 3 at page 28.
Individual grievance should be there. How can
The trade union, your Lordship, it's a majority trade union. It is representing the 400 workmen in the institution.
go and approach labor court? Raise a dispute. Raise a dispute
I
with
have
the conciliation officer.
The manner
The
in which
purpose for which you are established is to pursue your cases before. Correct? Idea Act.
that is
Not
when
filed writ petitions, right?
No, your Lordship, may kindly see that I.
Sir, 1 minute, sir. Selected candidates are not before us.
That selection itself is subject matter of the challenge before the writ petition. The interim order, your Lordship, may see any at para 10, your Lordship may see at page 20.
Srikanth,
I
1 minute, try to understand. అట్లాంటి ఇంటికి మనకు లేకపోయినా once writ petition is admitted means అది ఉన్నట్టే కదా. That is only advocate's order అది. Any appointment will be subject to that only to impress upon clients. Even if that order is not there, if the writ petition is admitted, that means everything will be subject to outcome of writ petition కదా. That goes without saying. You are projecting as though you got a great interim order. No.
No, I never projected that way. That's the order passed by the court.
That's what
All
we are
I'm
trying to
saying
tell
is
you.
because-
Whether there is order or no order, If the writ petition is admitted, that means everything will be subject to the
I am
result of.
not on that, Your Lord.
there?
I am only on the aspect
You
that
are
I have
projecting as though
my
you got
case
an excellent order of saying that anything will be subject to result of.
No, I am only trying to project that their action of going ahead with the appointments is subject to the result of the writ petition.
How the notification is contrary to standing order, please?
Yes,
Your
Your Lord.
Lordship.
The notification, the standing order, Your Lordship may see at page 56. It starts page 9, page 57, Your Lordship.
Oh, wait, sir.
Page 57.
Where is standing order?
The standing order, the original standing order starts at page 54. The neat typed copy is at page 57.
Right.
Rule 9. I challenge the notification as violation of Rule 9.
Read.
Recruitment to vacant posts shall be made by a selection of suitable candidates from the names submitted by the employment exchange. Preference shall, however, be given to retrenched workmen if submitted by employment exchange, and all retrenched workmen are advised to register their names with that organization. Now, the employment notification is from the open market.
Where is it?
You should see the employment notification is at page 45.
Yes.
With the above background,
Well, how many posts are notified?
30 posts are notified.
Just listen. I can understand if any retrenched employee is being denied, then that person can come and challenge. Right? How many retrenched employees are there? Those particulars are also, where is it particulars that their cases are not being
No,
considered?
that particulars are not there, but my grievance is the candidates had to be recommended by the employment exchange.
Okay. Right. You are a big litigant. That's it. Only for the purpose of litigating, you have challenged that notification. Just listen. In the affidavit, where you have said there are 400 retrenched employees and their cases are not being considered because of this, you must project the grievance. You cannot challenge any notification just because it is violative of Rule 9 of Standing Order. What is the prejudice which is likely to cause where you have projected?
Your Lordships may see at page para 5 of my writ affidavit. As per the said notification, the post of junior selection is by written test and trade test. This was objected to as is against the rules. Rule 6 of the Hyderabad Mint Industrial Workers Promotion Rules reads as under. I submit that the designation of tradesman was also changed to junior technician. While the above is a statutory requirement, both fourth respondents are proceeded to conduct a written test and interview.
If you further argue, you are taking a chance. Writ petition is not the answer for all illegalities which are happening all around. What is the prejudice it has been caused to you, you must tell. To the union or to the retrenched employees. If the government is not there, you are taking a chance. Take a call. Otherwise, we are asking you to stop. You must understand. Otherwise, we have understood your purpose of filing this case. We'll expose. Right. Not a single government is there. That so many retrenched employees of the union are there and their cases are not being considered. Even to this notification also, in view of Rule 9, they'll have to be given preference. That Rule 9 is not watered down. This Rule 9 is not watered down. If retrenched employees are there, Rule 9 says preference should be given to retrenched employees. 1 minute. 1 minute. There is no prohibition that retrenched employees should not respond to this. Is there any prohibition?
No, there is no. I am saying that. No,
okay, right, we have understood.
I'm not arguing on that. All I'm saying.
We are entitled to argue from that angle also. No, we are entitled to examine the case from all angles.
True enough.
Thank you.
Preference for employment for retrenched.
Is it your case? Because of this open competition notification, retrenched employees are not being considered?
No, my case is that the names had to be recommended by employment exchange. Preference to people from retrenched employees.
Sir, this is open. Is there any prevention from employment exchange not being sponsoring? It can sponsor. It can sponsor.
It's an open market notification. It's an open market recommended. But then
1 minute, sir. Is it your case 60 retrenched employees are there. Because of this open notification, they are being denied. That is not your case, no?
That is not my case.
Right. Thank you. There ends the issue.
All I am, that is
That is the only thing.
No, the
The
primary
advocate will
requirement
never
is-
think beyond that because client has instructed you only to argue on those lines.
No,
Correct.
Lordship may kindly see, it's the Rule 9 itself says that employment.
Yes. We are telling you again, 226 is not meant for all violations. Right? It's a discretionary jurisdiction.
Because I was ousted on the ground that only 400.
How you are ousted? You are not even ousted.
No, my writ petition was rejected on the ground that.
You are not even one of the contenders, right?
Only
Union.
No agreed party is there, no employee is there.
And agreed. How you are agreed is also not being projected. How many retrenched employees are there? That is also not there.
My only grievance, Your Lordship may remind the matter back
No
to the
question
level.
about
Trying to only just project yourself, that's all.
So that I will take steps.
You want to glorify yourself. Oh, I have done so much for the. Right. All feathers in your caps so that you can become a leader. Correct. Right. Writ appeal is filed. Agreed by the orders passed by the learned single judge in petition number 32046 of 2014, dated 29 September 2023. Sir, it is almost 10 years. There is a question of entertaining this writ appeal at this point of time after 10 years. They must have completed 10 years of service also. Persons are already recruited. Disturbing them just because of violation of equities also have to be looked into. And you have not implicated anyone.
I was under the impression the interim order says that the
Oh.
appointments are.
That is advocate's interim order. Any selection will be subject to outcome of no. Even if that order is not there. That is the meaning of if it is admitted. No.
The standing order prevails, Your Lordship. Standing order say that employment exchange has to recommend the.
You are arguing well, but not for the purpose. That's all difficult.
Only circumscribed by the
Correct.
order that
You
is
are
passed.
very limited scope.
Alright. Srikanth Hariharan, counsel for the appellant, Akhilesh for the respondent. It has been contended by the appellant that it is a registered Sangh who is espousing the cause of its members. And the grievance of the appellant is that the respondents have issued a employment notification on what is the date, sir?
4/4/2014.
4/4/2014, inviting applications for the post of junior technician in various trades, which is contrary to the standing orders number 9. As per standing order number 9, the recruitment to vacant posts shall be made by selection of suitable candidates from among the names submitted by employment exchange, comma, preference shall however be given to mint retrenched workmen if submitted by employment exchange, and all retrenched workmen are advised to register their names with that organization. The counsel for the appellant had contended that standing order 9 mandates that the vacant posts are liable to be filled up after through employment exchange, but the respondents have issued an open competition, thereby deprived of employment opportunities to the retrenched workmen. And when the appellants have approached this honorable court by filing writ petition number 32046 of 2014, challenging the notification, as it is contrary to standing order number 9. But the learned single judge of this honorable court was pleased to dismiss the writ petition as it is contrary to standing order number 9. But the learned single judge of this honorable court was pleased to dismiss the writ petition. Notification. Nowhere in the affidavit it was stated by the appellant that retrenched employees are being denied employment opportunities in pursuance to the notification. The respondents have issued a notification to fill up technical assistant. What is that post?
Junior technician.
Junior technician. Huh?
Yes.
Which permitted even the retrenched employees also to respond. Therefore, there are no merit. Rate appeal is liable to be dismissed. This court, having considered the rival submissions made by the parties here, by considering the learned single judge has rightly dismissed the writ petition, as the notification was issued way back in 4/4/2014, and now we are in the year 2024, and the entire recruitment process is over and all the posts were filled up and the persons who are recruited as junior technician are also not before us. In the absence of selected candidates, this court cannot adjudicate the case on merits. As far as the notification dated 4/4/2014 is concerned, it never denied any opportunity to the retrenched employees. It is a notification issued in the open market, which would mean everybody, including retrenched workmen, were also entitled to apply and participate in the selection process. Therefore, this court is not inclined to interfere with orders passed by the third single judge. Writ appeal is dismissed. More so, when the selection process was completed by 15/10/2014, and the selected candidates are not before us. Therefore, this court cannot entertain the appeal. Writ appeal is accordingly dismissed.
Meeting, CHO, Nagpur Ramesh.
Some transfer something. Huh?
Well, he is under suspension, let the.
Who is under suspension?
Petition.
You are for the appellant.
I am for appellant. By virtue of the interim order, I am continuing that. But he is claiming for in-charge arrangement, he is under suspension now.
What remains? We close the case.
Arrangement regard to the standard as against that the judgment was.
Okay, we'll close the writ appeal. We'll, on your reinstatement, they will give you appropriate posting.
Yes. Yes.
When the matter is taken up for hearing. Writ appeal is filed, agreed with the orders filed with the learned single judge in writ petition number 246/58 of 2023, dated 1st May 2024. Heard. What's your name? What is your name?
My name.
Yes.
My name. My name
Yeah,
is Mohan
please,
Chandra. I am B. Ashok.
B. Ashok. Counsel for the appellant. Vijay Prashant. Counsel for the standing counsel for the Telangana Vaidya Vidhan Parishad.
I am prefer respond number 1.
I and Cheppandi Pair. Nyakwadi Ramesh. Nyakwadi Ramesh for contesting respondent. It has been contended with appellant that he is working as a civil surgeon specialist and he was posted at
Superintendent District Hospital, Khammam.
posted at Superintendent
District Hospital, Khammam.
District Hospital Khammam, and the contesting respondent has challenged the posting of the appellant by filing writ petition number 24658 of 2023. And the learned single judge of this honorable court was pleased to set aside the posting orders of the appellant and directed that the contesting respondent be posted at Khammam without appreciating any of the contentions raised by the appellant. Agreed with the same. The appellant has approached this honorable court. Agreed with the same. The present appeal is filed, and this honorable court was pleased to suspend the operation of single judge's order on 28/6/2024, and by virtue of said interlocutory orders, the appellant is working at Khammam, and during the pendency of the present writ appeal, the contesting respondent was placed under suspension while proceedings dated
5/7/2024.
5/7/2024. 5/7/2024. And the question of posting the contesting respondent at Khammam area hospital would not arise since he is under suspension. Therefore, appropriate orders be passed in the writ appeal. The standing counsel appearing for the first respondent had contended it. Second respondent had contended it. The contesting respondent is placed under suspension. Therefore, Therefore, appropriate orders be passed in the writ appeal. The counsel appearing for the contesting respondent contended that he has been placed under suspension. If his suspension orders is revoked, let the second respondent give appropriate posting orders to the contesting respondent. In this court, having considered the rival submissions made by the parties, considered that the contesting the posting orders of the opponent were set aside at the instance of contesting respondent. Now that the contesting respondent is placed under suspension, therefore disturbing the opponent from command would not arise. And if the suspension orders of the contesting respondent is revoked, then the second respondent is directed to give appropriate posting orders to the contesting respondents. With these observations, writ appeal is disposed of. Next.
Lordship, I am for appellate representing Swaroop Porila, Your Lordship. It is coming for counter, my Lordship.
What is the case?
My Lordship, appellate hearing has been appointed.
Let the stay granted, I don't have any instruction from the respondent.
Okay. Post after 4 weeks next. Yes, Naresh Kumar.
Challenge the proceedings at page 34 with regard to the promotion of the writ appellant to the post of district medical and health officer. Whereas the writ petitioner is holding the post of additional.
Yesterday's case?
Yes. Page 34 is coming. This is the promotion order issued to the civil assistant surgeons who are promoted to the post of civil surgeon general line for the panel year 2022-23.
On what ground it was set aside, sir?
On the ground that the writ petitioner has been asked to report to the director. The proceedings are at page 36. Para 1 is with regard to the appellant before your lordship.
Uma Gauri is already working as?
She is already working additional public health officer on promotion. And I have been promoted.
No, she is being denied DMHO post on the ground that there is no.
She is not claiming for that. She is not in that channel of promotion. The grievance is I am
Para 11, just come back.
Para 11.
There are two parallel posts,
Parallel
DMHO
posts.
and public health.
Yes, ma'am.
It is abundantly clear, one AD PHO post has already been allotted to Medchal Malkajgiri, and no district health, this district medical and health officer has been allotted to Medchal district. Therefore, this code is of the view.
Yes, that finding is incorrect. My promotion order would show that I have to take charge from the in charge district medical and health officer. That you let me see page 30. Six.
Koncham, give us the details.
Yes. But the
Uma Gauri is working, channels చెప్పండి.
channel. Uma Gauri is also working as a civil assistant surgeon. She was promoted as a CS. And thereafter she
Civil
was...
assistant surgeon. You are working as?
I am also initially working as civil assistant surgeon. I was promoted as a as a civil surgeon general line. Civil surgeon general line. Once I become a civil surgeon, I am also eligible to be posted as a district medical and health officer. DPC was convened on
1 minute, sir. Civil surgeon. After civil assistant surgeon, you became civil surgeon.
Civil assistant, yes, sir.
Petitioner has become civil assistant surgeon to
Civil surgeon specialist.
she is having PG.
Both of us have.
Okay. Both are civil surgeon specialist.
No, I am the general line, she is in the special.
Right. Then
The post of the district medical and health officer was sanctioned about after the reorganization of the states and 38 posts are sanctioned.
38. The feeder category for DMHO is civil surgeon. Specialist as well as both.
Civil surgeon, general care. General
Estate surgeon.
Huh?
Civil
Civil
assistant
surgeon,
surgeon.
general line.
No, DMHO is in the category of civil surgeon. Civil assistant surgeon,
Civil surgeon and DMHO is same cadre.
same
The
category.
same cadre. The nature of duties change when they are posted as a district
medical health officer.
Right. They are equivalent cadre. Right. Okay. Then
But the writ petitioner was promoted and she has been posted.
promoted as what?
As a.
No, she was promoted as civil surgeon specialist, which is equivalent to DMHO cadre.
And on that, she was posted as additional public health officer.
But she was posted as additional public health officer, which is a separate category under 3F.
That is at page 96 for a moment.
District additional public health officer.
Additional district public health officer.
Additional district. Okay.
Additional district public health officer.
So that is also in the same cadre as civil surgeon. Nature of postings will change their designations.
It's an additional
When
qualification
when they
required.
hold the administrative posts, then not the administrative posts are district medical and health officer, additional district.
They are all in the equivalent cadres only. They are all in the equivalent cadres only.
But the streams are different. Streams of promotions are all different.
But everybody is civil surgeon. It is by
Not
promotion.
every civil surgeon is not eligible for all the both the categories. Only the civil surgeon in the general line is eligible for a district medical and health officer.
Okay.
Civil surgeons with specialization of 3 categories,
With
they are
that-
eligible for that channel.
ADP, ADP, HO.
Assistant divisional, additional district public health officer.
ADPHO.
Nice. We don't remember these names. Otherwise, you'll have to go around them to the hospitals and all those things. Correct.
No, they are all in the administration. These are all administration.
Correct.
Not in, they do not do the
Right.
health service.
Right.
But writ petitioner was promoted by proceeding dated 8/9/2023.
Writ petitioner.
Yes, sir.
Date?
8th September 2023.
Appellant?
That is at page 96.
Appellant, when he was promoted?
Appellant was, I'll give one more. Appellant was promoted by proceedings at page 34, dated 4/10/2023.
After her.
But the panel was prepared on the same day on 30/8/2023 for both. 30th August 2023.
Okay.
2 different streams, therefore panels were prepared, but giving the posting orders made a difference. And writ appellant is senior to the writ petitioner in initial category of civil assistants.
Correct.
Once the DM and HO post is sanctioned and I have been promoted, I was asked to take relief from the in charge district medical and health officer.
Who is that in charge?
That is one Mr. Putla Srinivas. Putla Srinivas.
Okay. Right.
Accordingly, I took the charge.
Correct. And you're working.
I'm working. Now the writ petitioner grievance is she was asked to report to the Director of Public Health and Family Welfare for further posting orders.
He was already promoted as district auditor. Oh.
But she was there at Malkajgiri at the relevant point of time. She was asked to report to the Director of Public Health for further orders.
When, by what proceedings?
By proceeding dated 6/10/2023.
6/10/2023.
Page 36. Then she made a representation on 9/10/2023. Saying that I may be retained
Malkajgiri.
at Malkajgiri, just a minute, which is nearer to her.
Right.
Then my interim order was granted on 12th.
Why she has approached the court? Why she has approached the court?
She has approached saying that I have dislodged her from Malkajgiri and she was asked to report to the director.
What is the post at Malkajgiri?
But the post at Malkajgiri, it seems that there is a post of a district medical and health officer for the Malkajgiri district.
And also this.
And there is also one more post of a
ADPH.
Yes.
Yes, Srikanth, what is your case?
But,
how can you become DMHO? You cannot.
No, in fact, that is what the DMHO, Lord, if your lordships would kindly see, ADPHO is a separate post, Lord, under the rules. Lord, the rules governing. No, I'll satisfy. Yeah.
First, listen to us, then you can.
Yes.
You are civil surgeon specialist. You cannot become DMHO.
No, that's what I will clarify. Lord, DMHO and ADPHO are Lord contemporaneous post. Lord, they are being posted as and when as per the requirement. Whether there is an ADPHO, is that posted as DMHO or
You are in a
DMHO?
promoted cadre of civil surgeon specialist.
No,
It is
that
only
is
a posting.
ADPHO. Lord, that is why I will clarify that. Lord, what has happened is, may take your lordships the confusion here.
ADPHO
Yes.
is in the substantive cadre of civil surgeon specialist, right?
Yes. No, if your lordships would kindly take page 98, the rules, only the rules. That is what that would clarify, my lord. Sir.
Yes, 98.
This is the amendment to the rules. Lord, 3F has been added. So lordships would kindly take note. This is in the said rules in rule 2 under class A. Lord, page 99 if your lordships gets.
Yes.
Additional district public health officer. Rule 3, method of appointment, appointing authority shall be added. Lord, this particular category was added. An extra the qualification was also prescribed. That is, diploma, page 100 note, the Roman 2, diploma in public health or MD, social and preventive medicine, Lord, has been prescribed. Lord, therefore, Lord, as per the said rules,
Sir,
Lord, this is
one
a
minute,
separate
sir.
post.
1 minute, sir.
Yes.
Your ADPHO. Right? Be there.
No, that is why I am saying that's the post of ADPHO. He has no qualification to be promoted to my post. Lord, that is what the learned
He
single.
promoted as DMHO.
No, Lord, there is no vacancy. Lord, if your lordships would see the counter filed by the government, there is
the
only
present
one post.
promotion order of contesting respondent shows?
My lords, may I take your lordships to my first.
Where is the posting order of contesting respondent as ADPHO?
No, my lord, but there is no such post in my district. That is what I am
Or
saying.
it is for the government.
Yes,
Who
government
are-
said there is no post. My lord, government said no post.
Yes.
If
You cannot become DMHO.
Lord, then I will not be needed to be transferred out. Lord, within 1 month, Lord, of my posting, I am posted because he said he is being posted in my place.
Where is 36?
Yes. may take your lordships to page 36. Lord, first may I take your lordships to what page 33 is where I have been promoted and posted.
Okay.
13th September 2023, I have joined.
You are promoted as ADPHO.
ADPHO.
In the office of DMHO.
Office of DMHO, Lord, there's only one vacancy, and that is the post of.
You are posted as ADCHO in DMHO.
Lord, I'll submit, Lord. What is this? Promotion and posting are two different things.
Correct.
What they are doing is promotion is only 10 vacancies of ADPHO are there. While promoting, Lord, to that vacancy, posting is being done, Lord, as per their convenience. That is, an ADPHO is being posted to DMHO post, and DMHO is being posted to ADPHO. Only as per posting. Now here, my lord, if your lordships would kindly take the vacancy and which is, yes.
Can you are posted as ADPHO in the office of DMHO.
Yes.
So you are not DMHO. You can never be DMHO. Correct?
No. In fact, Lord, that is what they are.
1 minute.
Yes.
Now contesting respondent is posted as DMHO.
Yes.
In that office where you are working. Correct?
Lord, may I take your lordships to what they are doing is, this is what the government is doing as per its convenience.
Malkajgiri has 2 posts or only 1 post?
Only 1.
That is
What is the ADPH? There's no other vacancy.
So
Lord.
without there being a DMHO, there is.
They've promoted him. In fact, I don't. Lord, as for the promotion, I have no grievance. Let him be promoted wherever he wants to. But he cannot. Within 1 month of my joining, Lord, I've been moved out.
In the office of DMHO. Yes, GP.
The government's counter, my lord, your lordships would.
Page number 33. You are posting the writ petitioner as ADPHO in the office of DMHO. And in reality, there is no DMHO post at all in Malkajgiri. Then, in a non-existent post, okay.
There is already a person holding the post of DMHO.
Yes.
In the Malkajgiri.
But look at your transfer order. You are posted in his place.
No minute. Let me see the. No, I am not posted in.
1 minute. 36. 36 చదవండి సార్ అదే ఉంది కదా.
He is posted as DMHO in place of.
Right. In place, ఆమె ప్లేస్ లో ఇస్తున్నారు. కాదంటున్నారు.
Then next paragraph. Who is working as in charge of DMHO? Orders of promotion and so and so. He is requested to hand over the complete charge of the post of DMHO.
Lord, there was no vacancy. Page 82, if your lordships would see, Putla Srinivas.
Putla Srinivas is holding the post of DMHO.
Only in charge. My lord, on the same order, page 82, if your lordships would kindly take. Page 82. Page 82, he got the promotion along with the respondent, Lord, appellant. Page 82, serial number 13, Dr. Putla Srinivas. Lord, he was promoted only on 4/10/2023.
1 minute, sir.
Yes.
He is posted as DMHO, Khairtabad.
Khairtabad.
1 minute, just listen.
Yes,
No,
yes.
You don't have any patience. First, listen.
I'm sorry.
He is posted to Khairtabad. He is also given in charge arrangement at Malkajgiri.
But the same, if your lordships would see, in this serial number 8 is the appellant. In the order, if your lordships would kindly see, serial number 8 is the appellant. This is the order in which the appellant has been promoted. Some in charge arrangement was made, Lord. He was deputy civil surgeon. He was not a district DMHO. Some arrangement was made because there was nobody there.
Yes, so much of confusion. 103. 106. Yes.
That the office of the DG is not restricted, because he was DCS, he is working as in charge of DMHO.
That Srinivas is also promoted on the same date, page number 82.
Because what is the in charge?
How can you hold? And serial number 8.
Because of decentralization, each district level they are in DMHO was look after the administrative office.
If you want, you can resolve. You can continue them both at Malkajgiri.
That's salary.
Hmm?
Salary is the nearest problem. We make a submission, not a political Tuesday. And we get to session for the HO.
Fair enough. Fair enough. Try to resolve it.
This also 24 for this one.
Where to say least, any proceedings of this type in my favor or his favor would be granted. This type of proceeding. That is how the departments are now functioning.
In olden days, UGC was doing like that. Whoever approaches them, they used to give one clarification.
Created. After that, there is no substantial cost of the
Not in fact, not the GMS.
Ultimately, what is so attractive in Malkajgiri? We are not able
No,
to
I came only 1 month after spouse grounds. Lord, my grievance is that page 66. If your largest would
any other vacant post, if another preference to the Chapman GP is so that.
That would be,
Huh?
if there is any post available to her within the city, because there are 5 posts in this city.
Yes. No, you tell us what is the post so that whenever
Out
you
of
getting.
38 which were sanctioned, 5 are specifically for the GHMs.
So GHMC, right, but already somebody must be already.
They have.
No, you tell us the preferences so that we'll ask the GP
For me,
to.
but I am posted as a district
No,
headquarters.
no.
He has to be
No.
accommodated in the post of an additional district.
I've been promoted, I've been appointed prior to her. Lord, why should I be centered out? In fact, in fact, there was no vacancy for him at all. His promotion order itself is in the cloud because he's been
Difficulty
promoted.
in page number 33 is.
Yes.
You are posted as ADPHO in the office of DMHO. That means DMHO office is there.
That's what this, but the government counter, my lord, says that there's no such post. We are posting them, my lord, contemporaneously. That is what the government says that we are utilizing for our in-charge basis. We are posting it for our convenience. Out of 38 DMHO posts,
One minute.
10 posts have been
The
marked
nature of
as
duties
ADP.
performed by ADPHO and DMHO is one and the same or?
Different. He is the head of the entire district.
DMH means complete head of administrative.
They only look at the public health. That is the sanitation and then epidemics which may come up. That is how it is.
Whatever is coming is 24 for 20.
Yes.
Because he says that both are equal.
Scale up.
No, but he
But-
say that is both are equal.
Scale is equal, but the nature.
No,
of
if your lordship would kindly take the government counter, my lord, that would clarify. Government counter at page 90. Lord,
Both are equal when nature of duties are different.
page 90, what they said.
Who is the disbursing officer?
Dispensing after
Is it DMHO?
DMH.
It would be DMH.
If DMHO is not there, how to distribute the salaries then?
Through ADPHO, that is what they're doing.
They are making in charge.
District head is the DMHO.
ADPHO is a disbursing officer? No.
No,
Then how can you distribute the salaries, sir?
no, it's those duties are being assigned. My lord, if your lordship would kindly not officiating, that's what they're utilizing. This is what the government has filed. Lord, they said out of the Lord 23 post sanction, Lord, the 38 post sanction, 10 posts of DMHO are converted to ADPHO and are being utilized out of 38 districts.
Okay, at the request of Ganan Peter, post on Tuesday. Okay, Thursday. Right. At the request of Ganan Peter, post on Thursday. Right. Next. Correct. Advocate General, other day we heard you. Yesterday she was also trying to argue. So we thought it would be better to advance your case also. Now, one thing we are not able to understand, other day also we told you the same thing. We have accepted that order of single judge and acted upon by rejecting our case on 22/4/2024. Now, where the question of writ appeal is a question we were trying to ask. That is one aspect. If you are not able to convince a single judge that there is no contempt, then your remedy is contempt appeal, not writ appeal. No. That's the point. we are trying to make. Already also we told you the same thing. Because you have accepted the judgment of a single judge and acted upon it and rejected the case of writ petitioner by orders dated 22/4/2024. Now, just because some judge is insisting for contempt and all those things, writ appeal is not the answer. You have complied, you have accepted the judgment. How you are agreed, we are not able to understand.
It doesn't preclude the respondents to say that the order passed by the learned single judge is wrong.
No, having complied the order, having accepted the order, having acted upon it and rejected the case of writ petitioner, if you are not able to convince a single judge, then your remedy is contempt appeal. When you have considered the case of so and so, because that order is also not that clear. What it says is contesting respondent's appointment is not set aside. If the writ petitioner is more meritorious than contesting respondent, then you must act accordingly.
Yes.
It never said that she should be considered in place of by replacing contesting respondent is also not there. And Shiva says he has also slept over the case for almost 1 year or 1.5 years. He's coming and trying to file a writ appeal.
Accordingly, she's not entitled.
Maybe. Now, in order to resolve, yesterday we have asked your standing counsel Kudus, how many vacancies of assistant registrar are there? He says there are 4 vacancies. If you can accommodate someone, or if you say that you are not going to disturb the contesting respondent, we'll close this writ appeal. As far as your writ appeal is concerned, your remedy is contempt appeal, not writ appeal. That's what we feel.
At least, my lord, I feel, my lord, that it does not preclude the respondents from contesting that the order of the learned single judge is wrong. Merely because, my lord, we passed an order pursuant to, my lord, out of due deference to the order passed by the learned single judge. My lord, out of due deference, we must have passed an order, my lord, saying that she is not entitled to. Here we will be able to satisfy your lordships legally also that the petitioner, writ petitioner is not entitled, my lord, to be considered even for assistant registrar at all. And my lord, I'll just pass on the sheet, my lord, the feeder category, my lord, according to us, is the superintendent. Your lordship will see the number of people who are above the petitioner. All these people have been appointed, my lord, in 1966 to 65, 67 and 85.
The problematic issue is like this.
Overleaf is the petitioner, my lord. Overleaf is the petitioner. She is appointed, my lord, in 2008.
Superintendent and technical assistant is one and the same or 2 different categories?
No,
Sudhir. Yes, Sudhir. Yes, Sudhir.
My lord, I have some technical, I can hear your lordships, but I cannot see your lordships.
No problem.
We are able to see you, Sudhir. Okay, no problem. Please proceed. When the contempt is coming, Sudhir? Today is there. What happened to the contempt?
Yes, to reach, my lord, to reach.
Yes, Sudhir. Yes, Sudhir. Sudhir.
May I try to place him on FaceTime call, my lord, if your lordship don't mind, because he is not there. A bigger one, your lordship also would be in a position to
try.
Grateful to your lordship.
In 20 years, so much of change. We are not allowed to carry phones in the court also. At one point.
And Supreme Court, now we are not going with papers at all, my lord. That's the change we have come.
Paperless.
One thing will be, I have forgotten my bundle will not be there if you go only by this. 1 second. Pass it on.
Yes, Sudhir. Yes, Sudhir. Able to hear us? Sudhir, able to hear us?
Volume mentioned.
Bandwidth is problem.
Sudhir. Okay.
Volume mentioned. Fine on that. Right hand.
Okay.
I think he has some
Advocate
problem.
General, if the case is adjourned, contempt case is adjourned, we'll just hear the case at a leisure time. Anyhow, you are not reverting the contesting respondent, no? Are you doing that?
You see, my lord, we have to merge ourselves, my lord, we'll have to do all those things. That's the reason, my lord. And, my lord, look at, my
No,
lord, just pass on the sheet to your lordships.
Or else do one thing.
Seniors are there, and my lord, the requisition also, where in the requisition of your lordship will please to see, where in the requisition at page 54 for once, my lordship is very sorry.
Yes.
Page 54, my lord, in the last, declare the action of the respondent 102 not considering the case of the petitioner for promotion appointment to the post of assistant registrar with effect from 9/11/2020 and further declare the proceedings dated 18/6/2021 appointing the respondent number 3 as assistant registrar as arbitrary and illegal and overly and the statutes and also contrary to the principle laid down in the WP number 794 of 2021. My lord, if you are actually pleased to take the order passed in 794 also for once, which may not still get at page 84. 84 is the writ petition filed by all the superintendents. Apprehensive, my lord, that the petitioner would be considered. Page 84. And my lord, this petitioner is item, my lord, petitioner number 3. There are altogether 9 people.
If your lordships are looking into my bundle, my lord, the one which my learned, but that 76, my lord. 76 is that 794 of 2021 is what the learned Advocate General is referring your lordships to. Because I understand.
All 9 people, my lord. All of them, my lord, in the sheet which I have passed on to your lordships. They are way ahead of the petitioner. And my lord, the court said it is for the authorities to take action and not love. I don't know what the principle they are trying to show here.
The petitioner is not equally placed, equally employed.
Nowhere near.
Sudhir, are you able to?
It's a different service.
Sudhir, are you able to hear? When is coming back? 27th of this October. 28 must
28 will be Monday, my lord.
Post on Monday. 28. 28 or 29?
29th your lordship may say, my lord, because he still would be having jet lag. 29th your lordship may call it.
29 or 30? 30 October.
30th perhaps Diwali, I believe.
31st onwards all this. 31st, 1st and 2nd.
29th your lordships are calling it, my lord. Grateful to you.
Request the single judge to adjourn the case in that context. By saying that the case is listed on 30th of October.
Grateful to your lord.
30th October 8. What is the case? GP for education. Advocate General, one more small issue. GPs are not appearing, that's all difficulty. GPs are not appearing. GP for education, GP for revenue.
1, 2, assignment.
Land grabbing cases. Revenue, I think.
Land grabbing cases. there's no-
Case was listed as the caption of dismissal. It was coming in your name, Advocate General, yesterday. I don't know. Obviously.
Nobody was there, in fact, we.
No, in fact, you are claiming 300 acres in Maratpalli. You have implemented some 2,047 respondents. I doubt whether 300 acres is vacant in Maratpalli area. I think it's.
See that
Right.
the
Please.
fact is most probably Mahindra is.
I don't know. Whatever.
Westmont.
Could be. Whether it is recoverable or not, let us give quite us. It is almost 20 years back, I think you filed all those cases. Pursuing them.
Maratpalli, I think there's some other proceeding for Maratpalli, I think. The complete.
Mahindra is was one of the issues.
Mahindra is there issue still pending there.
At least you can regularize and get some money instead of pursuing all these things, no? That would be a better option. Correct. Now, at least if you regularize the lands, plots, people will be willing to get it regularized and you will also get some money. Otherwise, this kind of litigation is, cannot.
Mahindra still there is issue. There's
Yes, post after 2 weeks next. Post after 8 weeks.
Lordship, sole respondent is died, your lordship. We filed LR petition today, your lordship.
Who has died?
Respondent number, sole respondent.
What is the case? You are for?
I'm referring only to
You are representing?
Respondent.
But you are expired. That sole respondent.
Yes.
And then?
I tried memo.
No.
Basically, they are for LR petition now. Now they only
So they have to file the registry, not here. Filing registry.
Post after 4 weeks next.
My lord, I appear in this matter, my lord. IA-1 is filed, my lord, to implead some of the legal heirs of the deceased father were not impleaded, my lord, in the trial court. Since it is a partition suit, my lord.
Who is your other side?
Other side, one Mr.
Has he got any objection?
Notice has to go to the proposed parties.
Okay, notice. Council, yeah, 1, 2.
2 and 3. The, 2 is for amendment, my lord, because of this.
One notice, Amma. One order.
One will take.
Council for the appellate is permitted to take out notice on the respondent.
Obliged.
Take the notice on the proposed respondent.
Obliged.
Post after 2 weeks.
2 weeks. Obliged.
As per the directions of your lordship, we deposited that the 50% of the amount on 23rd, 7, 24, your lordship.
Which case we have called, madam?
27.
A. Prabhakar Rao.
No, it is not a final memo, my lord.
Ready, madam?
LRs were to be bought, my lords. We are ready. He filed memo for LRs. We are ready with the matter.
What is the LR application? Huh?
Exponent number 34 is not the.
Where is that IA number? Post after 4 weeks. Next. This first case below. Lunch motion in first case. Yes.
May it please your lordships. My lord, this writ appeal is directed against the order passed by the learned single judge, my lord, in writ petition number 22320 of 2024 on 15th October 2024. My lord, two writ petitions have been filed, my lord. In one writ petition that is filed by my learned friend Mr. Sudhir, he has taken 2 or 3 grounds other than what I have taken. Insofar as my case is concerned, my lord, I concentrated only on the wrong key. We have raised, my lord, initially 15 questions have been raised saying that this has a wrong key that has been given, or questions were wrongly framed. And then, my lord, we have raised objections before the Public Service Commission also. And of the Public Service Commission, my lord, after this expert body was appointed, it deleted.
1 minute, sir. When that preliminary exams were conducted?
Preliminary examination was conducted in July 2024, my lord. 9th July 2024 it was.
Right. When the
Not 9th. 1 second, my lord. I will give the exact date. The preliminary key was released on 13/6/2024. And then, my lord, the final key was released on 7/7/2024. After two,
have you filed objections?
The first petitioner in the petition has filed objections. Second and third, other petitioners did not file in my case, my lord.
First petitioner, when he has filed?
My lord, he has filed within the period, and then the government also.
When the exam was conducted?
Preliminary examination for the third time was conducted, my lord, on. My lord, 1 second, I'll give the date, my lord. That's not.
Yes, Rajshekhar.
I just came.
Yeah.
June.
11th June. 9th June 2024, madam. 9th June 2024. That's contained in the judgment also, my lord, at page 29. Chronology is been given. At para 14, my lord, the relevant events are detailed by the learned single judge. At running page 44 of the paper book, my lord, of my paper book. Because your lordship may be looking into 1190, my lord, that is what I am referring to the pages from, my lord. Page number 44, para 14. This is how the learned judge, my lord, puts the chronological events at para 14. For better adjudication, my lord, got that? The relevant events are recorded here and there in a chronological order at the cost of repetition. Notification number 2 of 24 was issued on so and so. Preliminary examination was conducted on 9/6/2024. Preliminary key was published on 13/6/2024, inviting objections from the candidates through online from 13/6/24 to 17/6/2024. Here it is relevant to note that while calling for objections on the preliminary key, The candidates were asked to produce material and proper justification for their stand. In total, 6,147 objections were received through online from
Okay,
1721
then
candidates.
earlier case, right, then what happened? 15 questions. Right?
Yes, madam. Then we finally said, my lord, we are, some, as your lordships are aware, the judgments of the Supreme Court say one thing very clearly, that wherever the process of saying that the key is wrong by a long drawn argument, the benefit will go to the subject expert. Where it is palpably or demonstrably wrong, only those questions, my lord, we have concentrated on before the court, and we have zeroed down only on 6 questions, my lord, which are, I'll just give the numbers, my lord, for the purpose of demonstrating these questions, and I'll concentrate only on these questions. 41, 66, 79, 119, 119. And one more question, my lord, that was regarding that question number is 114. That means works out to, my lord, 41, 66, 79, 112, 114 and 119. These were the 6 questions, my lord, we concentrated before the learned single judge to say they were palpably and demonstrably wrong. Now, my lord, how the learned single judge deals with that, my lord, your lordship should get. So starting from page 47, I'll only read one way of dealing with the thing, and that repeats for all the 6 questions. I'll only take your lordship to page number 47, where, my lord, the learned single judge started dealing with the objections, etc. And this is what the learned single judge would say. We go to 41 at page 47. Match the following acts, rules in India with respect to their year of passing. Well, one question which I have to definitely tell at this stage is, my lord, there can't be a near answer for this. I will say why I said this sentence, my lord, while I go to the next thing. Forest Conservation Act, National Green Tribunal Act, Wildlife Protection Act, Hazardous Waste Management, Handling and Transboundary Movement First Amendment Rules, Biological Diversity Act. The petitioners raised an objection as it's found there. Learned Senior Counsel has contended that the question was about hazardous waste and not about hazardous and other waste management, handling and transboundary movement rules. And therefore the answer, that is the year of passing of the rules, should have been 2009 and not 2016 as claimed by the commission in the final key. This was our contention. Disputing the same, the learned special government leader has contended.
2009 is not there at all.
Not there at all. So we were trying to say it's a question which has been wrongly framed. I'll take your lordships to the subject expert and what material we have placed. Whether the manner in which it is liable to be considered or not is what I try to demonstrate.
So whether you have attempted this or not.
Well, according to the Public Service Commission, they have given marks for this also. For the first petitioner got a mark for this.
How many appellants are here in all?
5, my lord. So far as my case is concerned, 5. So far as the other appeal is concerned, it's 3.
5 and 3.
Yes.
8.
Yes.
So how many of you are qualified now?
2 of the petitioners in J. Sudhir's matter are qualified people. Rest of the people are not qualified.
Qualified for mains, in spite of that.
Concentrate on exam, no? Why all this?
Well, I am a person who is anyhow not qualified. And even qualified people are saying you can't say Telangana, what is the capital of Telangana is Rangareddy district cannot be an answer.
Huh?
Telangana, what is the capital of Telangana? If one were to be asked the question, however much I am a group 1 officer or a probable group 1 officer, I can't say nearest point is Rangareddy. The learned single judge, the question will be twisted. So that what happens is instead of Hyderabad, it could be anything. Kaitabad also, because it is in Hyderabad, therefore Kaitabad will become the capital. If this is the understanding of the Public Service Commission and that has the approval of the court, in my humble submission, merit is zeroed. A person who writes a wrong answer will be meritorious person and he will rule the country for next 30 years.
1 minute. Hazardous waste management, handling, transboundary movement, First Amendment rules. When they have come?
My lord, I request your lordship, grateful to your lordship for putting the question straight. 3 documents will demonstrate that the answer is palpably wrong. First one is page 92, your lordship, 192 may kindly be looked into for 1 second, my lord. That was the material which we have filed to demonstrate that
How
the
many
question is
lakhs
wrong.
of students are writing this? Tomorrow is
32,008, subject to what my learned friend would say.
31,000 approximately are writing for them.
31,000?
Yes, I'll give the exact figure, approximately
32,000.
31,000
31,000.
out of 3 lakhs, 31,000.
$130 is the material.
When is the exam?
Monday onwards.
Huh?
Monday.
How many centers? Entire administration must have been
Yes, my lord. It's
set
all-
in process.
My lord, it's a attack after attack, attack after attack. My lord, situation is, I don't even know which case I am arguing. That is situation that's happening.
That can come from my learned friend who is an expert in everything.
Trained by my friend.
He is an expert in everything. He can't say that only to save the Public Service Commission, however new he may have been appointed for that.
No, what Mr. Rajశేఖర్ is saying that trained by you, but you are not
Well,
properly
who
trained.
am I to train and who is he to get trained? He is a Swayambhu. I respect him for that.
2011, after 2011, after formation of the state until now,
Not even
not a single notification.
Not a single notification.
13 years.
I am grateful to that.
Attack after attack.
No, actually, Shiva, one second.
Matter
Shiva, one
goes
second.
right up to Supreme Court and conducted the second mains, first in the history. And we have borrowed the tradition, and the new Telangana Public Service Commission doesn't seem to be an exception. 3 preliminaries conducted from 1950 first time. And we take pride in saying the 32,000 people. What about the 3 lakh people who have been thrown out because of your wrong key? No answer for that. And you keep saying merit will have to be. What is merit? If a person writes Kailatabad and he is selected, he is meritorious who can govern the country for the next 30 years.
How many marks you have got? On the
My lord, let me not go. I have not gone into the nitty-gritties because I have missed by bus by 2 or 3 marks. Let us take, my lord.
No, let us take means you must also be clear. No? How many marks? How many?
My lord, they don't have the, I don't think, subject again to what my learned friend may say, they don't have the habit of giving the merit list at this stage. At this stage, I don't think they will give, to the best of my knowledge of the Public Service Commission. Whether the procedure is modified after the new regime, I do not know. But marks are normally given after the final examinations are there.
No, for this preliminary, this thing.
Cutoff, they are not specified. 1 is to 5,000, God knows what's happening.
1 is to 50.
1 is to 50, I mean, 1 is to 50. You have several things, the battle elsewhere.
How many posts are notified?
503 originally.
No, 560.
After 22 multiple, that has been cancelled and 560 given. Because again, there is a change in the society. 22 was the original notification. This court said, reconduct the preliminary. Fairness demands they will have to do that. They went up to Supreme Court because this court specifically said, you are incapable of conducting the examination. Quote unquote, what the Honorable said, you, in spite of the importance, you do not know how to conduct the examination, is what the learned single judge said. This Honorable Court affirmed it without even modifying that. Being aggrieved by that, the erstwhile government went to Supreme Court. After the new government came, request SLP withdrawn, notification cancelled. And they had before the single judge to say, we followed the judgment very meticulously. This is the following. And your lordships are also aware, to 503 posts originally given.
This time there is no leakage, nothing. At least this time there is no leakage.
There is a leakage in the system of the Public Service Commission.
No, but last time in fact cancelled only because of paper leakage something.
No, paper leakage one thing. Then biometric I have not conducted.
That we have now.
Probable impersonation could be there. Or it was not there. One of the standing council said before this Honorable Court saying that last time it was cancelled just because they are not given biometric. This is the attitude of the Public Service Commission. When we were trying to argue about some other matter, we commend the Public Service Commission for consistently misconducting the examinations. 2009 matter went up to Supreme Court, 2011 2 mains, 2022 3 sub-preliminaries, and they are very keen to get a second mains also written because
in total there are 8, only 8 are there now applicants. Out of which 2 already qualified.
My lord, one person comes and tells this court that you have played a mischief on the entire selection process. Begging a question to myself, Will 226 say, since you are only one person, your lordships are aware.
Shiva,
because-
just listen. Come concentrate on this page number, question number 41. Right?
Yeah, I am grateful to your lordships. My lord, since your lordship said right on the examination, my lord, I had to say it. Otherwise, I was only doing. Kindly go to 130 for one moment. My lord. Page 130. This is the material which we have created before them.
130.
Yes, my lord. There are two different rules. Hazardous waste rule. This is from the Central Pollution Bureau, not any Tom, Dick, Harry.
It is 2016, no Shiva. First amendment.
One minute, my lord. We will have to see the short title and the long title also. This is exactly what the subject experts were trying to do. Kindly see the first one. Hazardous and other waste management and transboundary movement rules 2016. Then go to the next one, my lord, at the bottom. After 21/7/22, your lordship should get another one. Hazardous waste management, handling and transboundary movement rules 2008. Now juxtapose this with the question, and the First Amendment rules have come in 2009. How do you call the question to be right at all?
Maybe that handling and all those things is more appropriate. Just listen. One minute, sir. Maybe handling and all those things appropriate is 2009. But handling is missing.
My lord, may I just give an example, my lord? I gave the same example before the court, single judge also. Who wrote Merchant of Venice is a question. William Shakespeare is not available. Serena Williams is available. Could they say, anyhow William is there, therefore it is Serena Williams who wrote Merchant of Venice? Is that the right answer? Pardon me for using this example. Other two sets of rules are prepared. One saying X plus Y, one saying only X. You ask X, why don't you write Y, X plus Y answer? How is it?
If this kind of things are to be challenged, then no recruitment process will ever take place.
And again obliged to your lordship. Consistency, last of the thing being the latest, what is it, B.R. Ambedkar University, Agra versus Devarsnath, they never said this court doesn't have jurisdiction. They said you will have to do. Only thing is palpably wrong. Right from Samir Gupta.
How these objections were dealt by the expert?
No need of dealing it. Kindly see subject experts how they dealt with. Well, that your lordship should get it. Page 192. Yes. And let me also share this, my lord, because my anguish will have to be shared with the court at least. What the respondent said before the court was, you will have to use your conscious head. This is what the predecessor of my learned friend said. I did not understand that. I went and checked up all things, whether an unconscious head will work at all. A group 1 officer must use conscious head, then how does others use their head? One thing. And second thing startling was, because you are a group 1 officer, 1 plus 1, if 2 is not available in the answer, you can't crib about it. So, if I am a group 1 officer or a prospective 1 attack, 1 plus 1 will become 3, or it can also become minus 1. Now, kindly see the subject expert, my lord, at 192. In supersession of hazardous waste management handling transboundary movement rules 2008, hazardous other waste management and transboundary rules 2006 have been issued by the Government of India. Therefore, question relates to hazardous and other waste rules. But the question doesn't talk about that. Then, hence the option 2016 has been correctly shown in the question. Since 2008 and 2009 are not mentioned as any of the options, there is absolutely no ambiguity for the candidate to answer the question. How? If I know Constitution of India was passed on 1950, and you talk about Constitution 101st Amendment, there is no confusion in the subject expert. God save the subject expert. Then kindly see what he says. Moreover, when the given options are examined, only fourth option is correct. You have an act with a specific title, otherwise there is no need
Shiva,
to
issue is like this, Shiva. Now this is nothing but match the following.
Yes, madam.
If you answer A to D correctly, the fifth one option which is not answered will automatically have to apply for E.
That is why I gave that Kattabat example.
1 minute, sir. Just listen. In match the following,
Correct.
5 questions are there.
Correct.
If you are able to match 4 correctly,
Fifth one will
automatically get matched.
Because matches the following questions, almost it will be either all right or two wrong. Two will be wrong.
So suppose if you are confident of first 4 answers, if you match them correctly, the 5th is bound to
Fall into place.
fall into place. Whether you attempt it or you don't attempt it, that is automatic.
I'll say this, in an match the following question.
Correct.
Patna.
Fifth one it did not match.
No,
That is
Patna, Bihar. No, that's not. You are
that is-
asking a specific question.
no, that is divine matching. 5th one will be divine matching.
No, if divinity is what we need.
Yeah.
We don't need exam. We will throw a big ball. Wherever it goes, we'll pick up that one.
No,
Why
no.
have
No,
to
what-
start exam?
Shiva, can I answer this, my lord?
Yes, you are. Oh, sorry.
My lord, I'm sorry, my lord. Your lordships are right in saying that 4 are matching. The 5th one automatically gets matched. So that is a divine. But actually, my lord, your lordship may also kindly have a look at when 5th one is doubtful or something wrong with it. Then we'll get a doubt about all the 4 whether we have matched it or right or wrong. My lord,
Next-
what is required? What is required?
Next, move on to the next question.
And
This
there
is
are
over.
6 options.
Let us not waste our time in this hazardous waste. Okay, move to next question.
Malad, if that waste is proved to be waste, there will be a wholesale thing in the waste list prepared by the Public Service Commission.
We'll come back to move on to 66, right?
No, my lord,
Do I
before.
think that the lordships are not convinced with what we have been saying in
No,
spite
no.
of specific act?
No, what we said. We have not expressed any opinion. We are asking you to move on to the next question.
No, then in that case, my lord, let me take 2 other things and then I'll move on, my lord. Kindly see, we have as a rejoinder, we have filed reply and rejoinder, we have filed 2 things. The Public Service Commission has filed the modified one. Kindly go to my reply at page 297 for one moment. What is the existing rule if they have asked? You will have to know what is supersession. What is the constitution? When was it passed? I am supposed to say only 1950. Kindly see page 297, my lord.
Yes.
We filed this. This rule was in fact available. This was superseded at a later point of time as by the subject. As a person who read the papers properly and the person who understood the short title properly, if he comes before the court and says, you do not know, this rule specifically says this and what you have done is wrong. Juxtapose 216 with 200 this thing, my lord. This is 216 is what they have filed. This is what I have filed. 220, your lordship may kindly see. This is what they said to prove me wrong. This is what I said to prove them wrong. Kindly examine both of them.
220.
Yes, my lord. 216, my lord. I'm really sorry for that. 216. This is the material to support that the subject expert was more than right. According to us, no. Kindly see short title preliminary. We are not concerned about that being superseded, etc. We are concerned about the short title. These rules may be called Hazardous and Other Waste Management Transboundary Movement Rules 2016. Now juxtapose it with 297. These rules may be called Hazardous Waste Management, Handling and Transboundary Movement Amendment Rules 2009. Now the question is, what is contained at 297 and not what is contained at 216? Then how do we call this to be a right answer at all?
No, this 297 is a amendment rules.
My lord, kindly see the question once again, my lord. I am sorry. Kindly see the question once again, my lord, which your lordship will get at 191. Subject expert's question. Question has been extracted in the counter. 191 may kindly be looked into, my lord. I will deal only with D. Your lordship may see the question. I will read 297. If this is right, the answer given by them is wrong. These rules may be called Hazardous Waste Management, Handling and Transboundary Amendment Rules 2009. This is exactly in the question. Now, what you are trying to say is superseded, etc. Have you ever written that this is the exact one which is binding now? Kindly see the question. Match the following Act rules in India with respect to their year of passing.
Maybe Shiva, you might be having a case or no case. All those things will come later. But we are in the 11th hour. If we cancel the selection,
We got the judgment on 15th.
So that is right. But you must not know. You must also understand how the unemployed youth are so frustrated. 1 minute. 1 minute. So many lakhs of people are on the streets. The entire unemployed youth are suffering with so. There is no recruitment since last 10 years. You must also understand.
Madam, I just respond to your lordship's observation.
So let this go on.
Madam, I'll only say this. In 2011, why I am trying to
Because
do this has got
lakhs of rupees have to be spent for conducting these type of examinations, because they'll have to take again biometrics and so many issues are there. It's not that simple. And
I'm not unaware of the difficulties.
no, that just listen. At the instance of 8 petitioners or repellents, of the 8, 2 are already qualified. At the instance of 6 people, can the recruitment be solved? Is a question. Try to
I
understand.
respond to your lordship's query in two aspects. Madam. First one is, there are a lot of unemployed youth.
Correct.
After 11
Sir,
years,
one
we are
minute,
now
sir.
having a
Some
recruitment.
small issues will keep on happening. This is human error. Some leverage has to be given when recruitment to such large extent is being undertaken. Lakhs of people are writing, 3 lakhs, 4 lakhs. Because look, first group 1 exam, 5 lakhs people have written. Now second, it was cancelled on account of paper leakage. Look at lack of interest. So many unemployed youth have not even responded to the second time.
They found out the truth that this is not a true recruitment
Correct,
agency.
correct.
They have become biased.
Correct. Now 5 lakhs have not written. Only 3 lakhs have written. So look at the number of people getting attracted to this. Is
Madam, may I just-
because of so many frustrations are there in the society. You must also understand. The toughest part is it is unemployed youth who are hard hit. You must understand recruitment process should go on. The question of stalling recruitment process would not arise.
Now your lordship may permit me to respond to 3 queries which your lordship
Maybe whatever you are saying is, if we had time, we would have gone into all those things. But there is no time, Shiva. The
I
question
also
of
say
stalling.
this, madam. Your lordship may also say this.
Suppose if you succeed or something, at a later point of time, something can be done, saying that you create supernumerary post or conduct some special recruitment drive or something like that. Otherwise, impossible to postpone these exams.
My lord, I now permit me to make
Just listen, sir. By just on the first time when the papers were cancelled and the exams were cancelled, so many people have committed suicides. You must understand. Again, biometrics. There is every possibility because Public Service Commission published this many number of candidates have appeared on the date of examination. Suddenly, after 14 days or 15 days, there
600 numbers more.
Then there was every possibility of impersonation or something. That's the reason we had to cancel, because 258 candidates were found to be more. When in a recruitment process of 503 vacancies, if 50% candidates, if they play fraud or whatever it is in the form of impersonation by not following biometrics, the purpose of recruiting 500 posts itself is defeated. That's the reason we had to cancel that. You must also understand that.
My lord, now let me say this. While your lordship's views on the matter may be absolutely correct from the broader perspective,
Naturally.
where your lordship
Because
are sitting. But kindly see this also, my lord. Your lordship cannot see only one view.
Correct.
Kindly see this also.
Correct.
Pardon me for using 2011 expression, because this plays a very crucial role here.
Correct.
In 2011, the examination took place, went right up to the main examination, interviews were conducted. Day after tomorrow, they were to get the appointment orders. At that stage, AP Administrative Tribunal passed an order saying, let the questions, doubtful questions be examined by the court, let the selections go on. Perhaps your lordship's thought process was we should not thwart the recruitment process. Matters came before this court. When the matters came up before this court passed an interim order in one of the 2 petitions. Blissfully, unfortunately, myself and Sudhir were there. In my case, the court passed an interim order that since the matter needs to be looked into, no selection shall go on. Then the Honorable Court, as His Lordship Justice Subhash Reddy J. then was, he said that the matter, 6 questions are definitely doubtful. Let the matter be placed before the UPSC. Till such time, hold your hands on. Not satisfied with this order, the Public Service Commission, persons who ought to have got the appointment but for the interim order passed by this, all went to the Supreme Court. The persons who in the judicial, in the legal profession appeared for those selection people under the Public Service Commission. His Lordship Justice J. Chalmeshwar and Hemant Bhotiye on 7/10/2013 said this is not the way in which you will have to conduct. and directed the entire 146 questions, you will have 144 questions, prepare a merit list and reconduct the main examination. They conducted the main examination, and in the conducted main examination, 46% of the marks in history paper was wrong admittedly by the Public Service Commission itself. Again, we said that this is bad. Then the tribunal said we will delete that 46 marks and conduct. My learned friend Sudhir came before this court because Public Service Commission again came. We both were there again. My learned friend Sudhir said if the
if your theory is to be accepted, or whatever has transpired in 2011 is to be accepted, then Public Service Commission can never conclude the recruitment process at all.
It can conclude proper care. Question is, your Lordship's order on the last occasion, what have your Lordship confirmed? Your Lordship may kindly see Lordship Justice Madhavi Devi's order for one moment, and your Lordship confirmed it. Kindly see that. In light of this, we don't need to give an extra mileage for Public Service Commission after the specific finding of this honorable court in this court, which your Lordship affirmed it. Kindly look at 1 second, my lord, of the judgment rendered by Her Ladyship Madhavi Devi for one moment, my lord. That's filed along with the material papers immediately after your Lordship's order. But I'll take your Lordship first to learned single judge order, which starts at 111, but straight go to.
Shiva, I think you must stop somewhere because we have to also dictate. 1 minute, just listen. 1 minute. We must dictate also. No? Suppose we don't know what is. 1 minute, sir. What is passing through our mind? We have not made up our mind. We are open to everything. So suppose if you stop, then you must permit us to dictate. Maybe in your favor or may not be in favor.
No, I have to.
The judges thinking aloud. Is that
Suppose,
cannot be maybe something
no,
else
no,
what your Lordship are
1
thinking
minute,
aloud.
1 minute. If you write a judgment, then only whether it will be postponed or not postponed will come out. No, if you continue to argue up to Monday, then what is that we can do? You must also understand. Sudhir is here to commence his arguments, and our bench is only up to 1:30. They again from 2:15 onwards, different benches, different combinations.
Normally, we will not argue to our heart's content. We will argue to the fact that.
You must also. We are just reminding. We are reminding you the time constraints. That's it.
Another 5 minutes at least I can get it, subject to the Lordship's kindly.
Then Rajshekhar also has to reply. No.
No, for him the job is now looking very easy, man.
No.
He will have to just get up and sit down.
No.
At least as per thinking aloud system which is going on, my learned friend is blessed by appearing there. I wish I would be there, but nobody appoints me for that because I am not that privileged.
I would not have
System of we are all there.
I don't know how.
Let me just put this, now that we are able to understand the concern of the court towards those who got selected.
No.
I'm only saying, I'm not trying to say your Lordship are judged it. I am using the word concern. I never said your Lordship decided it. I use my phrases very, very, very guardedly. I understand, my lord, appearing for any one of those persons among the 32,228, I would exactly think the way in which your Lordships are thinking. But I will only say one thing, my lord. If you have shut down people who otherwise should have been in, how is it a fair selection? That's the only thing I will say. And then I leave it at that. Now, on the basis of it, my lord, also one more thing. You have a name. Can there be an airness to the name? And kindly see the learned single judge says it is after all a preliminary. If it is after all a preliminary, leakage need not have cancelled, biometric need not have cancelled. The learned single judge says it's after all a preliminary, there is other rounds of qualification. Who will get into the qualification? You throw me out at the beginning. Kindly see what the learned single judge says on that point, my lord. Can you call this to be after all a preliminary? It's mere make or mark. You don't allow me to enter into the college and you say what is there, you can go and join another college. While your admission policy is what I am questioning, the learned single judge says it's not the be all and end all of the matter. If preliminary is not the be all and end all of the matter, what is that? Questioning myself. I will have to participate and prove my merit. You don't even open the gate. And the learned single judge says judicial review is not permissible. After all, it is preliminary. The learned judge did not use after all. Pardon me for adding that. But the meaning is only that.
Sir, when did you find the repetition date?
14th August. I mean, 1 minute. 14th August. 11th August 2024. Matter came up on 14th. If I remember right. I argued the matter on 14th. my lord.
Nice day.
My lord, I don't think I need to trouble your lordship. Your lordship will dictate the order after hearing my friends and the esteemed counsel for the standing here for this public service commission. But kindly see only this sentence I will read it.
May make my submission.
1 minute, just 1 minute. I will only read this sentence to say the seriousness with which preliminary is likely to be looked into. That's all. Nothing more, nothing less. Kindly go to page 53, madam. This cannot be the manner of deciding the fate of the people. That's the only last sentence I would say. Kindly go from 10 lines from the bottom, which says, in referred Supra and being satisfied. 5 lines from the top, your lordship will get a sentence which starts with, with the line which begins with satisfied with the same. This court is of the view that contention of the commission that in an examination for recruitment to the top executive post, the candidates cannot expect a direct question. Not even a correct question. Direct question is what the court says, but our endeavor is it's a wrong question. Cannot be brushed aside. And the action of the respondents in posing twisted questions for making the most qualified persons, Serena Williams, William Shakespeare, to be eligible for further selection cannot be faulted with. Further, it is to be noted that preliminary examination is not the only criteria. So, if I have not failed, if I have failed in the preliminary examination, could I make it to the group 1 services? And this is how the learned single judge says, not the only criteria to group 1 services. Rather, it is only qualifying in nature. At the qualification stage, you test on a wrong paper. We have a public service commission who tests biology person with the economics keyboard, and they say it's after all only a preliminary examination, therefore you don't need to worry about it. How do I participate in the further selection process?
Shiva, what do you say about this? Run Vijay Singh.
Run Vijay Singh, everything. If your lordship says argue on that, I will say. Every judgment says it does not mean that the power of the court is ousted. If they say Hyderabad is the capital of Telangana, we have not fortunately come to a stage that whatever they say, William Serena is the person who wrote Merchant of Venice, that's the last word. Fortunately, no Supreme Court said that. Ran Vijay Singh, Vikesh Kumar Gupta, everything talks in one sentence. If you are able to demonstrate that the answering of the subject expert is wrong, this court is not precluded from judiciary review.
1 minute, Shiva. Final key was published on 7/7/2024. It took almost 1 year for you to. Why?
24 to August will be only 30 days.
That's 1 month.
Yes, 1 month.
Why? You must be diligent enough.
Other day, my lord, I quote your lordship's expression. These unemployed youth may not be easy for them to come to the court. 4 years, your lordships have been benevolent in saying, this is how we will have to look at it. 1 month, your lordship may have to say that they at the earliest.
They have to reach only up to Shiva's house. That's all.
Reaching Shiva according to them may be difficult. It may be easy to reach other persons. Because Shiva doesn't have a name board also on his office. It took time for them to come. Maybe 1 month, my lord, is not such a bad thing.
No.
They will have to collect material, try to pursue their
1 minute, Shiva. They don't have to collect anything. In the objections itself, they must be available with them.
They need not know mathematics.
No, 1
They
minute.
need not know history.
No, 1 minute, sir. This notification, which is published on 19/2/2024, has earmarked entire selection process when preliminary key will be published, when the preliminary examination will be conducted, when final exam will be conducted, and everything will be set out in that notification.
In 22 also it was set out.
Huh?
In 22 also it was set out. October 22.
What do it is?
There has been a change in the
So-
government. There is a new notification.
Correct, sir. Suppose you knew as on the date of notification that 19/2/2024, that is the second latest notification, that final examination is likely to be commenced from 21st October, no?
I don't think the notification has specified that. No. I will best of my knowledge, no. If they work with clockwork precision, why would we be troubling your lordship, my lord?
Rajshekhar, what is happening? UPSC follows so meticulously the
They don't
everything.
believe in anything, my lord. They are constitutional bodies. My lord, I think this is the last thing, my lord. At this stage, Anyhow, your lordships are not of the view that this case will need to be dismissed. At best, it will be subject to final outcome. That's what your lordships are thinking aloud.
No,
For
we
the
have
purpose
not,
of
we have
Indian
not explained anything, sir.
law, thinking aloud is not. Thinking aloud means it is not yet finalized. Your lordships have decided the only dictation is something else.
Thinking will not produce any noise. It is a question of allowed.
My lord, your lordship's thinking will produce noise from this side. Whose thinking, your lordship's thinking is which paper, my lord, will decide who will make the noise.
One.
So Sudeep Bandu at 177 it is.
Lord, may I
Yes,
make
Sudeep.
submission before
Yes.
Rashid?
No, I'm only answering Sudeep. I'm only answering the letter. Page 177.
Yes.
There are 1.2.
Para?
There are 1.2 at 177. Last date, application, edit option, downloading all tickets, schedule of preliminary, and schedule of meetings.
Yes.
We knew that the time is.
Yes, Sudeep, then. Please
Lord,
proceed.
may. Well, I'll try to be as brief as possible.
Yes.
My Lord, first of all, my Lord, let me dispel the suggestion or view of your lordships, my Lord, that a lot of money is spent there. And so just my Lord, not that your lordships are not aware about that. My Lord, amount of money, my Lord, this court will never be carried away, number one.
Nee,
Number
not in
two,
the money in the sense. In the form
no,
of making
spending
arrangement, conduct, no.
lot of
The money
manpower.
context, the money expression context was used in such a way that they'll have to make arrangements for
Correct.
conducting examinations
I
by
understand.
making
That's
so
what
many, right.
lot of manpower, money, and all that will have to
Yes.
be
Yes,
arranged. Now your lordships are view, not even finalized. View is that it's better to go ahead with the process rather than wasting manpower and the finances taken out by the public service. In that case, Lord, I'm only trying to say that a thing has to be done in a particular manner, my Lord, or not at all. My Lord, just because they are doing a particular thing or in a wrong and illegal manner, my Lord, the lordships will not give the judicial approval of that. Just because of they are doing it. My Lord, the reason why we come to lordships, my Lord, is because
Sudeep,
yes,
Sudeep,
my Lord.
when did you file the writ petition? Date?
I filed on 31/7. Therefore, my Lord, your lordships may, I'm not lordships are carried away, but your lordship may not get swayed away on the ground that everything is done. And then, as a matter of fact, my Lord, it is at the fag end we understand, as your lordships have seen, my Lord, vacation intervened. It was directed to be posted on 14th, matter came up on 15th, the very got the order.
No, one minute,
And
Sudeep. 1 minute, Sudeep.
Yes.
Of the three, two are qualified, right?
Two are qualified.
Okay. When did you file your objections to this preliminary key?
My Lord, immediately, within time we filed, Lord. There is no dispute about that.
We means all of three of you or only one?
No,
Like,
only one person.
huh? How many
My Lord,
persons?
in both the cases, but only one person filed objections.
Only one person. Okay.
Two persons. In one case, in Shiva's case, and one person in my case.
Okay.
My Lord, point for
what was,
consideration.
Sudhir, what was the order when the case has come up for the first time before the single judge? Has he referred the cases to any expert or not?
No, not at all. That my Lord, matter was adjourned at the behest of the Public Service Commission at least 2 to 3 times. Matter was heard when we insisted about vacancy. Matter was heard finally on the last day.
One
Matter was
minute,
reserved.
one minute, Sudhir.
Yes, Lord.
Such type of cases on the first day itself, single judge ought to have referred these questions to the expert body, correct?
Correct.
And called for a report within a period of 2 weeks, correct? When such interim orders are not passed, then you must file appeals and see that record is straight. Because 1 minute, just
it was
listen.
just adjourned.
1 minute.
Yes.
1 minute, Sudhir. Just listen. Have patience. Just listen.
Yes.
Page number 177, notification is issued specifying the preliminary examination, followed up by main examinations also in the month of September and October. Correct? Suppose if these issues are not addressed immediately, then the entire recruitment process will be stalled, no sir. So some effort should be done.
It has
No.
to be stalled either 1 month before, 2 months before, or 1 day before, because a thing that has to be done in a particular manner, but just your lordships also knows
Rajshekhar,
there was
it should have been like this. The single judge should have referred these cases to some university, the disputed questions, and called for a report. Then entire issue would have been resolved within then and there itself.
That is
So
exactly
people
what
just keep on asking time for counters, and judges are
Yes.
not able to decide cases.
That's
And this is
correct.
the problem. The entire recruitment
However,
process.
absolutely, Barot. Now, Barot, matter is
No, it is
adjourned
not.
for-
It is not. It is not for the courts to say whether this answer is correct or that answer is correct. It is a body of, because we are not.
It is not in thin air, my lord. Total 6,147 objections were received. So kindly appreciate
Suppose
this
if someone-
situation.
no, when
Kindly
somebody is-
appreciate.
1 minute, just listen. If somebody is doubting those things, then the only thing is it should be referred to independent body of experts.
Doubting at a person who is qualified, they kindly appreciate this. 1 and 3 in Mr. Sudhir's matter, they qualified. And 3 made objections, it is of no relevance. 1 and 2 did not make objections. See, kindly see the situation. And Mr. Siva's case, only one of them made objections. And challenge after participation.
No, please don't argue, Rajshekhar. I have not completed.
Yes, Sudhir, please proceed. Another 5
So
3
I'm
minutes are there.
sorry, my lord. I need some time, my lord, because it's not that I've just only challenged the key issue. Your lordships are till now, my lord, Shiva discussed about it, and lordships are looking at it only from the key issue.
Correct.
I'm only trying to dispel your lordship's view in the beginning stage that, my lord, that so many things have happened. Your lordship, my lord, there hua magar durust hua. Everything has to be done in a proper manner.
Correct.
And my lord, because 2 times they have not done it properly, kindly appreciate, my lord, kindly take my note, this thing, by my booklet. My lord, kindly take that. And then in that, it was issued in 2022, it was cancelled because they should have conducted. Why have they not conducted is they have cancelled first preliminary examination because it was not properly done. Similar issue, my lord, just because it is a second or third, it doesn't mean that it has to happen. My lord, whether 10 times or 15 times, what is to be done has to be done in a proper manner. If your lordship sees that it is not being done properly, lordships will definitely interfere. My lord, learned single judge permitted the Public Service Commission to file counters and then gave 2-3 times, my lord, adjournment. My lord, if we challenge, as your lordships rightly said, my lord, if we come for writ appeal, lordships will definitely say, obviously say, my lord, may not be saying, but obviously, my lord, our experience is, matter is seized of the learned single judge, why don't you go back?
No.
And no interim directions are rejected. It's not as if, my lord, interim directions are rejected, therefore we can come.
Okay, what is the other point? What is
No,
the
no.
other-
Now, therefore, my lord, just 30 seconds, I'll come to my actual ground. Money, my lord, aspirants, your lordships have said, my lord, now 3 lakh people are outside. We are also aspirants, my lord. Persons who are fighting, my lord, are 3 lakhs or 4 lakhs. Now only 30,000 people are writing. My lord, according to me, 30,000 or 20,000 who should write are those who are entitled in law. Those who are not entitled in law just because they are there because of a wrong procedure cannot be, my lord, the only aspirants. We are also aspirants. And my lord, lordships also.
What is the other issue?
No, other issue, my lord, I have raised is that first of all, cancellation, your lordships may kindly see, your lordships, the judgment of Justice Madhavi Devi was to reconduct. Kindly appreciate one was cancelled by Public Service Commission. The second preliminary examination was cancelled.
When
by
it was cancelled? When it was cancelled?
Second was cancelled first was cancelled, my lord, on 17/3/2023 because of the
17?
leakage.
17?
2023.
17/3?
2023 on their own, Public Service Commission at page 130.
Right, next.
Then second examination was conducted. They have not cancelled the notification. They have conducted a fresh second preliminary examination. That was found to be incorrect, my lord, at page 134. It says at page 150, Justice Madhavi Devi, what she said, Lord Spekalisi. Can they go beyond the judgment of this honorable court?
Second preliminary examination was conducted when? Date?
second preliminary examination.
That is 19 June. 19 June 23.
23.
Yes.
That was cancelled when by way of a judgment.
By way of a judgment, page 134.
Then
On
that
20
notification when you have cancelled?
No, 1 second, my lord. 1 second, my lord. The Justice Madhavi Devi's judgment was 23/9/2023. For a
Sudhir,
minute.
you must conclude, otherwise our time is over. Suppose if we walk away without dictating
Lord,
anything, your reputation will become infectious.
Mine is first case, my lord. Today, I had the opportunity of the whole of the day, but because of the other matter to be taken.
You
up,
agreed
Lord,
for that, no, Sudhir. You have agreed for that.
I have agreed. That doesn't mean, my lord, that your lordships would cut me
Again,
out on grounds.
Just because you have entertained a lunch motion, it doesn't mean that we should forego our lunch, no?
No, I'm not. None of us should, my lord. I can understand that, but because of the urgency and the enormity of the matter, my
No
lord,
problem. No problem. We can forego our lunch also. Please proceed. Right.
No. What I'm saying, my lord, is that your lordships may rejoin, my lord, at 2:15. I've done.
No.
You know,
We have got some other bench. That's the reason. Today being
no,
a
that
Friday.
my lord, your lordships knows, my lord, your lordships can accommodate that. Your
No
lordships can
problem. You can proceed, Sudhir. No issues. We are willing to
No.
sit and hear you. Right.
Correct,
You
Lord.
want to
I do not want a hungry judge or to keep on, my lord. I think it would be appropriate, my lord. By request
No,
would be.
no. 1 minute. Sudhir, you can't force us to eat, right?
Anyhow, my lord, it's not possible at all.
Anyhow, you people are eating us.
And your lordships have the habit of not eating regularly also. He doesn't know it, my lord.
Please.
My lord, if your lordships gives me at least, my lord, we need at least 10 minutes, my lord, if it's okay.
No problem, Sudhir. Please proceed.
Yes, my lord. Now, my lord, I'm obliged, deeply obliged. My lord, the order passed by Justice Madhavi Devi is to reconduct the examination, not to cancel the notification.
Correct.
That was affirmed by lordships, my lord, by a judgment, my lord, rendered on 27/9/2023.
Correct.
Not satisfied with that, because they wanted to sustain the second preliminary examination and the notification, they went before the Supreme Court. And Supreme Court did not obviously grant an interim direction or anything, or directions, and found that there will be in the soup. Therefore, my lord, on 19/2/2024, matter was withdrawn. SLP was withdrawn, making your lordship's judgment, my lord, final, which is nothing but affirming the judgment of Justice Madhavi Devi, which says conduct examination,
Correct.
not cancellation. But
Then
on
what
19
happened? Then what happened?
On 19/2/24, my lord, not only they have withdrawn the the SLP, on the same day, new notification is issued.
Have you challenged that new notification?
That is exactly. Now, what I'm saying is that cancellation, my lord, has no power. It goes to the root of the matter.
But having
Where is the-
participated in the 1 minute, sir. Having participated in the preliminary examination, how can you challenge that notification now? Just
That's
because you have
exact-
not qualified. That will,
Correct.
Ashok Kumar will apply, no?
My lord, the judgments have been cited before the learned single judge, saying that appropriate, reprobate will not apply in matters where it goes to the root of the matter. And I relied upon Mita Sai's case, my lord, that was not considered. The judgments, my lord, unless and until you participate, you cannot. My lord, once the matter goes to the root of the matter about the cancellation, where is the question of, my lord, when it is, there is no estoppel. The concept of hot and cold and estoppel will not arise in a matters where the matter is constitutionally invalid. The whole, but they have, when the court says reconduct the examination, what right they have to cancel the examination, my lord? And what is the basis? Kindly see the cancellation. What is the reason given? Kindly see the cancellation, my lord, at page 176.
Sudhir, it could be like this. Earlier, 503 vacancies were notified. Now 560 posts have notified. That's the reason they have to issue a fresh notification. Perhaps that could
No,
be one
they
of
don't. No. When the court says conduct examination, you have to confine it only to 503, or you can add 60. My lord, the reason they say is that
No.
my lord, every day, one second, my
service.
lord.
1 minute, Sudhir. You are
Yes.
also appearing for service commission, right? Just listen. Service Commission can increase or decrease the
Correct.
number of
They
posts. Power they have got.
Even cancel.
Cancel on.
That is my case. That is my case. They can increase. There is no necessity for cancellation. They can add this 60. They could have added this 60 because what the reason for cancellation, my lord, the reason for cancellation as mentioned in the counted affidavits is 60 more vacancies came. Every 1 month, my lord, there will be vacancies. That doesn't mean that you cancel. You can add addendum.
Very
You
well.
can add addendum. Or you can say that we have right to add. They have been adding or deleting.
Any other
So therefore,
Any other
now,
country?
and most important thing is the reason for cancellation, Lord Speaker, kindly see 176 page. They are not saying that we want to add some more vacancies. If they want to add some more vacancies, that is not the ground.
Correct.
What they say is in public interest. At page 176, what public interest is involved? Lord, is it public interest to cancel a validly given notification? Lord, just because preliminary examination is not properly being conducted, there is no need for cancellation. More so when the court directed to conduct examination. It amounts to contempt actually. Is it not contemptuous having taken, my lord, the matter to Supreme Court, withdrawing it?
One minute, Sudhir.
Yes.
Just because High Court has said, they have got inherent power of cancelling it.
Yes.
As long
There
as
is
they
no
have got-
power. Correct, Lord. First of all, there is no power because you are only an agent. Lord, government has not mentioned. Government never gave which rule, which provision of the regulations, Lord, provide them to cancel a notification. Notification is not on their own. No, 1 second, my lord. Notification is not issued on their own. It is notification is not issued for Public Service Commission employees. Issued by the at the indent of the government. When the government asks you to do a particular thing and you have started it, you cannot
18.1.
stop it. You cannot stop it. You have no right. Government has not told you, nor you have taken concurrence or ratification. And the reason, my lord, there is no reason, contrary to the directions of this court. Number 3, you have no power. There is no power at all. And the reason given, my lord, for any administrative action to do, there has to be a proper reason material. What is the material? Are you, my lord, is it not a political thing? Because there is a change of government, you want to cancel it. Supreme Court has said this cannot be done. Cancellation, I filed a judgment, my lord, which is before lordships. Cancellation cannot be done at the whims and fancies of the authorities.
Where is
Without
it? Which page?
My lord,
Which
the
page is-
judgment of the Supreme Court is before lordships, my lord, at page 481. I have given several judgments, my lord. I have given a note saying that the cancellation cannot be done by the recruiting agency, just like at the drop of a hat.
81.
4. Amarnath Singh, my lord, 481.
Read, Sudhir. Yes.
My lord, I don't want trouble, your lordships. Kindly go to page 494. My lord, after discussing about various judgments, about the right of
Yes.
the right of authority to cancel.
Where you are reading, Sudhir?
In the almost similar circumstances, the court has set aside the order of cancellation of the recruitment by order dated so and so, in so and so, so and so, so and so. I have taken a view after discussing all the rulings of the point that the action of the respondents in that case cancelling the selection process was contrary to the provisions of the particular law. Both these authorities fortified by me in this judgment. In view of the findings that so and so has grabbed the entire recruitment process in light vein without realizing the implications of his orders, and that the order was passed on no founded and in unreasonable and irrational manner. The impeding order of cancellation of the entire recruitment process must therefore perish on the above ground. Since the order of the scrapping of the recruitment process...
Sudhir, 1 minute. They were cancelled on 19/2. 1 minute.
Yes.
And issued the next fresh recruitment on 19/2 itself. So what is the
Same
prejudice cost to you?
Same day, my lord.
Hey, what is
No,
the
no.
prejudice? No, 1 minute. What is the prejudice it has been cost to you? The same
My lord,
certification
I'll
was-
come. I'll answer.
Is there any selection process different in the first notification and second notification?
No,
Nothing.
no, there is. I'll come to that. That's my second point. But before that, bro, the prejudice is, bro, you cannot keep on making us to write examination after examinations and cancellation, my lord. You cannot play with our lives. Bro, this is what has happened in 2011. 2011, bro, they are trying to say 10 years you have not conducted. 10 years you have not conducted is the reason for you to conduct it properly. 2011, you failed it utterly. Now also you failed it twice. Court says conduct preliminary examination. You want to say always, I'll go back to square one. Not a prejudice, bro. It's not a prejudice for me. Now the prejudice is you have added, kindly see, my lord, second notification, persons who are eligible on 1/7/2024, 1st July 24, are also made eligible for 503 vacancies. Who must have been only in the degree first year. Those who are not eligible as on the date of notification for the earlier notification, 1/7/2022, they are all made eligible now. Making unequal.
One minute, please. Whenever public employment is taken up, it should be the interest of employer or selecting authority that more number of people are attracted so that the best of best talent is recruited. Right?
Correct. Let them cancel. Let them give once again in 2025 more number of candidates will come. My lord, matter of the issue, my lord, is that when 503 vacancies were notified, there will be millions of graduates in the state, but only, my lord, 3 lakhs or 4 lakhs applied. So
just try to understand. Just because at the instance of 8 persons, of 8 who are qualified, just listen, Sudhir.
Yeah,
6 persons at the instance of 6 persons. The group 1, which is a jinx kind of an examination, which is sought to be conducted from so many years. Every time some legal flaw or something, it has been cancelled, it has been rectified. So somewhere we must stop, Sudhir. Otherwise, what happens is,
no, exactly.
1 minute, Sudhir. 1 minute, Sudhir. 7/7/2024 is the final key which was published. Then I can understand, because the notification itself said so, that final exam will be conducted in the month of September and October. That means if you come to the courts, then you must get the remedy immediately. If you don't get the remedy, then recruitment process cannot be stalled. That's the point.
My lord, the query that the issue that your lordships are laying only 2 persons or 1 person. My lord, even in 2011, the matter that went up to Supreme Court and we fought. I went before the Supreme Court and my lord, we fought before the Justice Subhash Reddy said, what is all this? Give it to UPSC. APPSC carried the matter to the Honorable Supreme Court. Supreme Court said no tribunal, no High Court. We are dealing it under 142. 6 questions were found to be basically wrong. Delete them.
That is Supreme Court 141. It can do anything. We can't do that.
That's no. What I'm saying, my lord, is that the High Court has referred the matter to expert committee. They gave a committee report, my lord, saying this is all correct.
That is the reason we have. That is the reason we are telling you.
One second, my lord. Your lordships can still now do it. Now, my lord, it's not, my lord, it's a matter of 1 day or 1 month or 2 months. 10 years are over. So within 1 month or 2 months, my lord, you cannot blame, we cannot blame you lordships. I cannot be blamed if the Public Service Commission, which is a constitutional body, which is expected to do properly, my lord, every time, my lord, they cannot pick up 150 questions and give proper answers. Now, that is about the key. My lord, your lordships, I had only one case. There are so many cases, my lord, we will not also be bringing, my lord, baseless and useless issues before lordships. We have seen several questions, all of them we have rendered them not good enough. And then where there is an issue of consideration, where your lordships can look into and then refer the matter to experts only we brought. Your lordships have heard only about that acts and matching. There are other questions also which are palpably wrong. No, matter should have been referred to experts.
We never prevented anybody from arguing any case.
Correct.
He was argued only one question.
No, I know that.
Ready to argue 66, your lordship said we'll have to dictate. I thought the first case would be sufficient to say they did not even know and understand about the short title. 6 questions I have raised. Since your lordship said we'll dictate judgment, why should I come in the way? I sat down.
No,
All
Shiva,
these
one second.
questions are
My lord,
probably
you know,
wrong. But
one
your
second,
lordship said we will have to dictate. I said okay.
my lord, there is
And
one
I
thing-
only said 15 questions. I have raised
Shiva.
6. I am ready to argue.
Yes.
My lord, as a matter of fact, my lord, this requires your lordship, my lord, just because of the time lag or just because one or two, your lordship's rose, my lord, this I said before the single judge also, I am repeating it. My lord, Keshwananda Bharate judgment was rendered by only one person, my lord, Keshwananda Bharate.
Yes,
But
yes.
your lordship, my lord, it's not a question of how many. It's not a question of quantity, my lord, it's a question of quality.
One person
My lord,
can
if
become a class.
So
This is what
therefore-
Supreme Court said in Re-Special Court Bill Act.
In that case, constitutional points were raised. Sudhir. Here, this is only
Conducting a selection for 30 long years of bureaucracy. This is not a constitutional crisis with the public.
my lord, public service commission.
What else could be a constitutional question? My lord?
Shiva,
From
you
tomorrow
had-
onwards, they will pass acts,
Shiva,
they will
please.
pass rules,
Shiva,
they
please.
will assist the government, they will try to implement the policies. These people will do it. That this is
Shiva,
more
please.
important than a constitutional question because 30 years they are going to be the safeguards of the constitution. These people.
One must also understand, Shiva. How many people will be becoming aged but that also
So what about your lordships have taken one thing? What about the petitioners who have come before? What about those persons who have suffered a wrong key? They are also belonging to the same society. They have not come from an alien society. But for your action, I would have been there. These are also persons unemployed. These are also persons attempting for the past over 5 to 6 years.
Shiva,
We will
Shiva,
answer.
please.
Merely because I have come, they will have to be protected. May not be the right way of looking at it.
Yes, Sudhir.
Shiva, please don't eat up in my time, please. Please.
I think we both are going together, Sujay. I'm not
I know,
sure
but-
we are not eating each other.
You had your mouth full, let me have mine. My lord, I'm only trying to say, my lord, your lordships may not get swayed away by the number of people. Your lordships may not get swayed away by the time lag because we are not concerned. My lord, your lordships will have to see the legal, this is the only court where I feel legal points only will be seen, not other points. My lord, legally I'm saying, how can they cancel it? How can they cancel it? On what ground?
Yes, any other contingent, Sudhir?
And this your lordships have said was, I have raised the second issue, my lord. Your lordships may for a minute have a look at that the first ground is cancellation cannot be done contrary to the judgment and without any basis and without any power. So it goes to the root of the matter.
Correct.
Now, my lord, the question of approbate, reprobate will not arise. I have filed that also. Meeta Sai also I have filed before lordship. There are several judgments I cited before. The law and single judge did not non-suit me on the ground of approbate, reprobate because I have cited so many. Meeta Sai also of the Supreme Court judgment I filed. Supreme
Which
Court
page?
said,
Which
in
page?
my lord, I'll take your lordships, my lord. That is page 503.
Yes. Vedanand will we can go and have Vedanand replacement.
503, my lord.
Yes, please proceed.
But Supreme Court said, Lord, I don't want to trouble your lordships at this time. The issue raised was also hot and cold there. But the Honorable Supreme Court said, in matters of this nature, you have to participate. If you do not participate, what right you will have, first of all.
Right. Any other contention?
Now, in that view of the matter, the learned single judge did not go into the matter of that, but went into the matter, my lord. None of my contentions, other than my lord, looking into the 6 questions, were considered, and they were simply set aside on the ground of delay. But the question of delay, the learned single judge also says the matter was issued 6 months back. It is not absolutely delay, but in the matters of this nature, it is a delay. But the question of delay would not arise in the matter of once the question goes to the root of the matter about the cancellation and the power. My lord, in the counter also they have not mentioned about what power they have.
Any other points?
There, the next issue, my lord. Because of this, the second issue I've raised, my lord, is assuming that the cancellation is valid. You should have made 503 vacancies only for the earlier candidates. You should not have expanded the competition. It should have been notified as an addendum or separately, or even now you can do it, because persons who are not eligible as on the date of earlier notification, who had tried twice, their rights are taken away, and then some 2 lakhs people have joined now.
Correct.
They cannot join, my lord. They have to compete only with for that 60 because they are added now. So therefore, unequals are made equals. You can still do it now. You have to do that, even if the examination is going ahead. Can be gone ahead. Now the third issue, my lord. ST reservation is increased from 6% to 10% in between the two notifications, just before cancellation.
No, that is the submitted before the other court case. Second court case.
No. I'm not saying that it is wrong. I'm only trying to say you cannot make it applicable to 503 vacancies. I'm not challenging that GO. The GO challenge is before another bench. I am not on that. I'm only trying to say this GO 33 was issued just before the second notification could be made applicable only for the 60 vacancies, not for all the vacancies. The vacancies that are there earlier.
33 is dated?
Not
39, 2022. 30th September 2022.
2022.
1-3.
And between the this is between the two examinations.
13th September 2022. 13/9/2022. No, I stand corrected. 30th September.
30th September.
30th September 2022.
No, therefore, my lord, on the ground of allowing 60 persons or this persons for that, and then also extending 33 GO for all the 503 vacancies which were already issued, you should have. There is no necessity for fresh notification. You have added an addendum and then called for applications for the 60. This has not been done. Fourth issue, my lord. Fourth issue.
Yes.
The notification says no extension of time will be given for applications beyond the time. At page 189, 7.12, specifically says we will not entertain even a minute. That's what they are trying to say. But then they have extended by 2 more days. They themselves they are also page 180, which is part of the notification.
189.
Yes, bro. Which is page 189, para 7.12.
Yes.
This is their own notification. They have no respect for their own notification. They have no respect for merit, no respect for procedure. No correspondence will be entertained to accept applications, extend the date after closing the date of submission of applications.
Correct.
Now, whereas they have extended it at page 230, by which 30 to 40,000 people who have joined. Is it I can do whatever I like? Is it just because they are a constitutional body? Is there no end for their illegalities? 230 extension, and the reason now given, my lord, kindly see, my lord, people have requested. Well, so I am requesting tomorrow. I'll ask for the post of deputy collector. Why can't you give? If requests are accepted, 230. What is the reason given, my lord? There is no reason. And now they come up with the reason saying that some people have had some technical glitch. Therefore, we have entertained.
Yes. Any other issue? That's all.
My lord, on this extension itself, my lord, would show that the persons who have applied after that extension time, after the time, are not entitled to participate. They are now not only participated, they are also part of the selection process.
Correct. Any other
Now,
point?
but my lord, all these things would go to show that this is not the way that the whole process should be conducted. And my lord, had it been conducted fairly, my lord, there is no necessity for so many litigations. They themselves have demonstrated from their conduct that twice they failed in their thing. My lord, one more time doesn't make a difference. Let them reconduct the examination by excluding by making it correct, my lord, as to these vacancies. 60 vacancies have to be treated separately because they have come subsequently.
Very well, sir. They will consider.
And then, my lord, only one key answer, my lord, one answer, your lordship, I take. my lord, that is with regard to constitutional clause, that will be very easy for lordships to, because that is dealing with our own subject, not we don't have to even go for the experts or my lord, kindly go to the judgment, my lord. One question with regard to page 36 of the internal page, my lord, judgment, learned single judges judgment. Question number 119. Question number 119. The question is, which of the following articles of Indian Constitution is not related to economic safeguards provided to the scheduled caste? So not related to. My lord, whereas learned single constitution contended that as Article 23 and 24 never speak of economic safeguards provided to the scheduled caste, the question itself suffers from ambiguity. Disputing the same, learned government trader has contended that as per the subject expert committee, Article 23, my lord, if your lordship sees 23-24, that is not pertaining to specific caste. It is pertaining to general. So how can the 23-24 also 23, 24 and 46 from part of the economic safeguard? 46 is understandable. 23-24 has no connection with the safeguards of the economic status of scheduled caste. But therefore, my lord, the answer is wrongly given. According to them, all three, 23, 24 and 46. Now it should have been not. Which of the following article of the Indian Constitution is not related to? Then, my lord, there would have been only one.
Right.
Now, my lord, in view of that, this is, my lord, glaring and then palpable reasons or questions. My lord, your lordships, with respect, my lord, may not get swayed away by the time or the number. I am only trying to say, my lord, what has to be done properly has to be done. Your lordship knows the Taylor versus Taylor, a thing has to be done in a particular manner, has to be done in that manner or not at all. Just because you are going ahead, my lord, the lordships are also concerned, the lordships may also show the concern for the people who are otherwise entitled to be in the fray. And it's not a case, my lord, of blowing hot and cold, because persons who are qualified and who are not qualified, all of them are before lordships. And we are not responsible for the delay because we filed it in July. I filed it in July. And my lord, the matter was dragged on by the Public Service Commission. This is the trick of the Public Service Commission. Every time they do all sorts of mistakes and mischiefs. And then my lord, come forward and then say that we need time and all that. Finally get it to the close. And then now everything is arranged. People are writing. My lord, this has to be stopped, and lordship may kindly see, my lord. The history also speaks by itself. They have done it earlier. They are doing it now. I'm only trying to say, refer the matter to experts. Hold it on.
Please consider that, Sudhir. Yes.
But while I may not match the eloquence and volume of my friends, my lord, I'll be very brief, my lord, in my submissions. My lord, Mr. Sudhir's clients, my lord, petitioner 1 and 3, they have qualified. My respectful submission is, having qualified, my lord, to say the notification to be set aside in my respectful submission is not maintainable at all. And my lord, the only third petitioner had made objections, and none of Mr. Siva's clients, my lord, have made objections. No. I'm sorry, I stand corrected. Petition number 1, except him. And that gentleman answered question number 41 correctly, got a mark for it. Kindly see the situation in which we are placed. So much is argued on 41, one petitioner got a mark for that. But my respectful submission is that, having participated in the process, challenge after participation, as your lordship has rightly pointed out, my lord, is impermissible in law. My lord, I will not trouble with the judgments. Your lordship has only said, my lord, the citation order. Sorry. JP, where is that? That is Ranjan Kumar, 2014, 16 SCC 187, paragraphs 14 and 15.
What does it say?
What it says, well, having participated with your eyes open, well, it says, the next submission which has been presented before us is, when the respondents had appeared in interview knowing fully well the process, they could not have resigned later on, taking a somersault, saying that the procedure as adopted by the department was vitiated. then my lord, Madan Lal is extracted. It is now well settled that if a candidate takes a calculated chance and appears at the interview, then only because the result of the interview is not palatable to him, he cannot turn around and subsequently contend that the process of interview was unfair or the selection committee was not properly constituted. Lord, I'll just pass on this judgment.
Ashok Kumar is sufficient. One judgment is sufficient.
Yes, my lord. Ashok Kumar also, my lord, is there. The learned judge has extracted that, my lord.
Page 54, I think.
Page 43, my lord, of the judgment. Internal page 43 of the judgment. Paragraphs 11 at page 43. The basic issue that was addressed by the division bench was that the appellants, having participated in the fresh round of selection, could not be permitted to assail the process once they were page 40, internal page 43 of the judgment, my lord.
Yes.
Okay, right. Any other point?
My lord, secondly, my lord, the question, my lord, whether which answer is right, how the question should have been framed, my lord, my reciprocal submission is a classic case where the examinee wants to examine the examiner. My lord, they want to lay down how the question paper should be framed. They want to lay down who is to be selected. My lord, the terms of selection, the process of selection, answers, everything is dictated by them. Unfortunately, the constitution doesn't provide for such a thing. Lordship may kindly appreciate the Public Service Commission is vested with the responsibility of recruitment, not the examinees. They cannot come forward and say, you conduct the exam in this particular way. You have to declare the key in this particular way. This is the right answer to this question. But my reciprocal submission is Ranvijay Singh, which the learned single judge has extracted in the judgment. They said, hands off, courts cannot go into this question at all. And neither myself or your lordships are, my lord, equipped to answer such questions. As, for example, Mr. Sudhir argued, my lord, the question with respect to economic safeguards of scheduled caste and scheduled tribes. Kindly see, my lord, Article 23 talks about prohibition of traffic in human beings. Well, it applies to all human beings, including scheduled tribes, and forced labor and bonded labor of children in factories. It applies to everybody.
Question is specifically for.
Please, Sudhir, allow me to complete. So therefore, my lord, there will be no end, as your lordship have said, that if we go on dissecting every question, my lord, out of 3 lakhs, we could get 31,000 people. Now, at the instance of 6 people, we go on dissecting each question. There will be, my lord, 2,70,000 more different answers to these questions who did not get qualified at all. And we found out, my lord, these 6,175 objections have been considered. The expert committee gave its recommendations. 2 questions were deleted. 2 marks were added to everybody.
How many objections?
If commission is above all, why ask for objections at all?
No, number of 6,175, my lord, objections in all.
6,000?
6,175. And my lord, 1 petitioner in Mr. Siva's matter and petitioners 1 and 3 and 3rd petitioner in Mr. Sudhir's matter alone made objections. They did not make objections at all before the expert committee. They had an option of doing that. Only 2 of them made. And they both got, my lord, the correct answer to 41. They got both got marks also. Yes, my lord. Secondly, my lord, the cancellation, my lord, is challenged. My lord, 3 things occurred, my lord, between the cancellation of the previous examination. One, my lord, is, yes, your lordship has pointed out, GMS number 33 dated 39/2022, increasing the reservation for scheduled tribes from 6 to 10%, which necessitated, my lord, change of the situation. Secondly, my lord, GMS 29 dated 8/2/2024 was issued. GMS number 29 dated 8/2/2024 was issued.
8/2/2024.
8 February 2024 was issued, but amending the process of selection from preliminary to mains. But following the rule of reservation under 2222A, my lord, we have specifically said that 1:50 shall be called with respect to each category. My lord, that is also subject matter of challenge before the revision bench. Yesterday that was refused. My lord, they said we are not going to interfere. And matter is at that stage, my lord, no interim orders are passed with respect to challenge in GMS number 29.
50?
GMS number 29, my lord, was challenged in a batch of writ petitions before the revision bench.
1:50
1:50
in each category.
in each category. What we said was that, my lord, that we will first of all take 1:50 from the entire pool, and then, my lord, we will see whether each category is satisfied. If it is not satisfied, we'll go down below and then collect for that particular category. That process, my lord, was challenged.
We are ensuring that the 1:50.
We were ensuring in all categories, we wanted to ensure. My lord, this necessitated, and also the fact that new posts were, my lord, required to be filled up.
Anything else?
These three aspects, my lord, necessitated cancellation. Therefore, my lord, I respectfully pray the Honorable Court to dismiss the application for grant of stay. Yes, my lord, only one thing, my lord, more than 90% people have downloaded the hall tickets, my lord. Exam, it's all ready, my lord, to start from Monday for a whole week. It's not a case for interference, my lord. This is my respectful submission.
Yes, that's all.
Okay, just add, my lord, in 30 seconds or 1 minute. My lord, GO 29 aspect has nothing to do with the present issue. Now the issue is, my lord, my friends cannot trivialize, my lord, the issue saying that the constitutional body and then we are dictating. My lord, we are not dictating. If you do it properly, where is the necessity and why is that your lordships will interfere? Your lordships have interfered also. So just because they are a constitutional body, my lord, if I have a right to fix the question and answers, then why are you asking for objections? There is no necessity for objection. That means there is a participation of us, citizens. And then a constitutional body cannot be unconstitutional to say that I'll do whatever I like and every other constitutional body like you have to keep quiet. And then other thing, my lord, only 1%, 2%, my lord, it's not a
1 minute.
One aspect.
You have received objections in respect of how many questions?
Yes, my lord,
Total.
that's also, yes,
Total.
yes.
6,175 objections you have received.
Yes, yes.
Pertaining to, what is the total?
I'll just know.
Which were there in the examination?
Yes, yes. My lord, from 1,721 candidates, objections were received. 6,147 objections were received.
In respect of how
In
many
respect of
questions?
number of questions, Lord, I'll just know. I'll just know. Let my friend complete, Lord, I'll just know.
As admitted by them, two of them are, three of the one, but 2 or 3 have been deleted. But that itself shows, Lord, that they are not doing it properly. Lord, what about the experts, Lord? Can they not properly frame questions and answers? Where is the necessity for every time to delete 10 questions, 5 questions, 20 questions? My lord, is it not a failure on the part of the constitutional body? Should it not be properly done? And my lord, 1 mark will make or mar a candidate's future. As I was explaining the other day before the single judge, my lord, he will become a deputy collector ultimately, or he might have to do some small business, my lord, or open a pawn shop. My lord, it's all 1 mark. It's a rat race. And then you cannot take questions and answers in such a light manner. But if there is no process of objections, that means those 3 questions would have been continued. That means you would have called persons who are not eligible and excluded persons who are eligible. But 1 mark makes all the difference. Now, Lordship can appreciate, Lord, it's not a question of whether how many raised, how many objections, whether it is right or wrong. Your Lordships will see the legality of the question and whether it should be referred to an expert committee. Their experts committee, my lord, are expertised in bungling the whole thing. That is what is the expertise they have developed in. That is what has been proved, my lord, not in this case. You Lordships have seen not only group 1 is cancelled, the preliminary was cancelled, so many examinations were cancelled, and every examination is before Lordships. And they have the audacity to say we are constitutional body, we can do whatever we like. No, nobody can do whatever we like in this country when there is a rule of law. The Lordships will be guardians. Lordships will be the guardians of constitutional law. Our constitutional right to be selected properly under Article 14 and 16 has been violated.
Okay,
Not one, hundreds.
I'll give only 2 sentences reply.
Anyhow, good night, Sudhir.
My lord?
Good night. Yes, please.
What good
No,
time,
Your
but
Honor, I don't-
my is now, my lord, it is almost 5 o'clock in the morning.
Then good
AJ,
morning.
good morning.
Good morning.
Go for a walk.
And
My lord,
two-
I cannot go for a walk. It's too chilly. It's too cold. Anyway, my lord, I'm deeply obliged, my lord. Your lordships delayed your lordship's lunch, and we only request, my lord, request lordships to do justice, and then we are only.
Just conclude, Shiva. There are two benches. There are two benches, maybe small benches. After that, we'll
I
assemble
only
and try to
made one
dictate order.
sentence in reply, madam, not more than that. So, statement made by my learned friend was, Constitution does not provide for an examinee to examine the examiner. This is quote unquote my learned friend, subject to corrections which he may do at the appropriate time. Question is, a constitution says, Constitution was prepared in 70, nobody should question it. I don't think that's constitution. This is number one. Second thing is, my learned friend, in his busy schedule, perhaps he did not read Ranvijay Singh itself. For his convenience and for convenience of the court, let me say this. Para 18 says this. A complete hands-off or no interference approach was neither suggested in Mukesh Thakur, nor has it been suggested in any other decision.
Where you are reading, sir? Which page?
Ranvijay Singh, para 18.
Which page?
That is the Ranvijay Singh citation is, my lord, 2018, volume 2 SEC, volume 2 SEC, page number, ఇంకొకటి ఉంది, 2 కాపీలు తీసుకున్నాం. Judgment of Ranvijay Singh.
Which page?
That page number will be 363, my lord.
Which paragraph?
Para 18. I'll read only these 4 sentences, nothing more, my lord.
What basis is it?
It says this, my lord.
Which
paragraph? Para 18. 363, it starts placetum G. A complete hands-off or no interference approach. May I read on, my lord?
Yes.
Was neither suggested in Mukesh Thakur, nor has it been suggested in any other decision of this court. The case law developed over the years admit of interference in the results of an examination, but in rare and exceptional situations and to a very limited extent. This limited extent is, if you do not know that the capital of Hyderabad is Telangana is not Hyderabad, this court will only have to say Hyderabad is the right answer. If that is the understanding of the constitutional body, God save the merit which they pick up. We are not dissecting the answer. We are saying the examiner doesn't know what is the capital of Telangana. That's all, my lord. To dismiss the SLP on 15th, 14th, they knew that the judgment was being delivered on 14th. They forced the hall tickets on 14th in such a way that people out of anxiety, we understand the students also. And then they come up, 90 people and 90% have already downloaded. Yes, you have forced it that way. It doesn't lie in the mouth of the person who does a wrong. Still say I am a constitutional body, nobody can correct me. Fortunately, Ranvijay, which my learned friend referred, itself says not a hands-off policy. And it was reiterated in 2023, SCC Online 970, B.R. Ambedkar versus Devarsanath.
Sir,
That's all, my lord.
preliminary examination consisted of 2 papers? 2 papers or 1 paper?
Only one paper. 150. Entire 150 were objected. Everybody made objections.
In respect of all
All questions, objections were made. Though petitioners, majority of them did not avail of that opportunity, they wanted a different forum though.
Along with the application, you must also ask for question paper. What kind of questions you must ask? That would be
In fact, what should be given is an option should be given to the examinee. Please tell us how to conduct exam.
No, because when you do not know, we have to tell you, no? Because you are not able to conduct, which is your history, we have to tell you or the court has to tell. If only, and then keep on saying, let me just say this, if 2 plus 2 is equal to 4 and nobody has raised objection, and then they say 2 plus 2 is equal to 5, can it not be raised?
Sorry for keeping you waiting.
Can this court not look into?
I am grateful for your lordships for extending your lunch time, my lord. I am deeply obliged for the patient audience and bearing with order.
Obliged.
We'll continue to assemble after those 2 benches and dictate the order.
Grateful, your lordship. Original scheme of para 3 and 4 is vice versa, my lord.
Right.
From this to that and from that to that, provided they return the money along with interest.
What kind of prejudice it will cost you?
Yes.
Nothing.
That's what the scheme itself
Right.
says.
Next.
Obliged.
Raman Gaud, services 1, post after 2 weeks, right? Who is appearing? Who is appearing? Who is your other side? Post after 4 weeks, right? Inta Gundigar 4 weeks apart. Next. Post after 4 weeks. Next.
My lordship, I'm appearing to the petitioner, my lord. It's coming for compliance, my lord.
Post after 4 weeks. Next. Yes. Agriculture University. Who is the standing council? Last time standing council appeared, no? Have they disposed of your representation, sir? Have they disposed of your representation?
No, they have not. And in the meantime, my lords, the second respondent has filed the counter affidavit with so many untruths. And they have stated
What is
that
untruth? What is untruth?
The petitioner only retired from the first respondent. Generally, because of the bifurcation of two universities, according to section 3 of the Bifurcation Act 2014,
Bring other side.
58% is due by the second respondent and 42% is due by the first respondent. First respondent, of course, it has paid. But the second respondent has been stating that it is not
Who is the second respondent?
Acharya Engineering Agricultural University.
Bring your other side. Post after 4 weeks.
And for the last time hearing also, she was not present.
But with change in government federation, I don't know, standing cost, right? Next. What happened to SLP?
Because they have showed their intention that they are not ready.
1 minute, madam. If you order any presence, then they'll obtain stay from the Supreme Court. That will not be in your own interest. Just wait.
Let them also run from pillar to post. We've been running from pillar to post since years. Let them also do so.
No, suppose if you order their presence, they are, because our judgment is not suspended by Supreme Court, it is not stayed. Suppose if we order their presence, then they'll go and request the Supreme Court, appearance is ordered, please stay.
Let them do your lordship. Let them try that. Because in fact, the SLP is challenging their writ petition, not our writ appeal. Our appeal, which was allowed, is unchallenged.
Yeah,
And we have filed the contempt.
But
of that writ
it's a
appeal.
common order, no, madam.
It's a common order, your lordship. But
We forced you to file appeal, right? We forced you to file appeal, correct?
yes,
Otherwise, it was very difficult to sustain the order of single judge.
take appropriate action, your lordship.
What is this, Ganesh? No, 1 minute, sir. That's the reason we told you during the pendency of writ appeal, because other counsel was appearing, to sort it out, enter into some settlement. You refused to do that, no? Then go and sit in the jail. That's the best thing, I think. If you are not able to comply the order, then go and sit in the jail then. That is only a part of it.
And now he's claiming further amount under the award. Any amount which is due under the award, it can be recovered through execution proceedings. Wherever execution proceedings are available, contempt proceedings cannot be entertained.
There is no bar as such, your lordship. Your lordships are well aware and not.
Okay, conclude, pursue your SLP, then we'll see, right?
Your lordship may
Post after 4 weeks, right? Next.
form one, your lordships.
I'm trying to understand. We'll-
I really don't want to beg you for your lordship, but I'm obligated to.
No, it's not like that. It's a question. It's not a question of begging or something. Why should anybody beg? One must understand. in your own interest, we are telling you, suppose if you order Form 1, then they'll have a chance of getting suspended this judgment. Try to understand. Just wait for 4 weeks. In the meantime, see that the SLP is adjudicated with this.
At least direct them to release a gratuity which is available.
Have you not heard him? His entire accounts are freezed.
Gratuity is with the LIC department, Your Lordships. That has not been
Huh?
that neither the Supreme Court has the authority.
Okay. Our case is adjourned by 4 weeks, and the interregnum, the respondent shall take steps to release the gratuity of the petitioner. Right. Next. First time, Amma, Vanni? Yes. Right. All notice before admission, post after 4 weeks, all 3 cases.
My lord, this matter has been going on against since 20 adjournments. Your lordship may kindly see the
He's not
docket, my
asking
lord.
adjournment. He's
Your
not
lordship, your lordship may hear, my lord, because 2013 notification
Madam,
will.
He's saying case to be taken up along with item number 130. Wait, no?
Up to 130.
You don't do cases along 130. Right, next. Huh? So what is second contempt? Chapamas, what is second contempt? Where is that review? Okay, Chapan, are you joining my review? Review, Amma. Next case now. What is the case here? Sir, 1 minute. Tribunal has set aside the charge memo. You have came here and filed writ petition. Got suspended the tribunal's order. That means charge memo is revived. You should have concluded in disciplinary proceeding. Then? Huh? What review? Ramarao garu, just follow the case. Charge memo is issued. For the same allegations, he was tried in a criminal case. He was acquitted in a criminal case. So charge memo was pending after acquittal. That person came and challenged that charge memo before tribunal. Tribunal has set aside the charge memo, saying that once he is acquitted in a criminal case, the question of keeping these disciplinary proceedings is bad. Allowed the way. You came and challenged that orders by way of a writ petition. Got suspended the tribunal's order. That means charge memo gets revived. So that suspension took place in 2004. We are in 24. For 20 long years, you could not conclude the charge memo. What is it now you will do? That's what we said. Understood or not? Correct. Thank you. మరి ఇంకా రివ్యూ ఏముంటుంది దీంట్లో we are not able to understand. Senior, got the point? Maybe, sir. Who refused? I mean, who asked you to not to conduct charge memo? Wait, after 20 years of suspension of.
It's impersonation. We got certificate of underlady and joining the department. That's what we got even on the last day of retirement also we can take action. Only underground probably the review is right. Because what we should.
But opportunity given to you in the form of suspension of tribunal judgment.
Only is what we should everything is right. The delay cannot be attributed to government. It is important. That's the only issue.
Okay.
If it is some other misconduct, as Rochelle pointed out, this delay may come in the way of teacher sale for the response.
Is it your case you are likely to conclude that this is a charge memo? No.
In fact, inquiry is concluded because of some reason it was.
No charge memo is, no inquiry is concluded. No. Huh?
I vaguely remember the case. It's a case of absolute fraud.
But one submission, my lord, as your lordship has rightly stated, what made them to not conclude in all these 20 years, my lord, 20 long years they were silent. And now after my lord, filing the contempt application, they come up with the review application. After filing the contempt application, they came up with the review, my lord. After 20 long years, they could have done it earlier only. When your lordship has suspended the orders, then itself they could have taken the action.
Okay. Review I8 1 of 2023 is filed to review the orders passed by this court in writ petition number 10730 of 2004 dated 22/10/2022. Third, GP for Home and Umarani, counsel for the respondent. Yes, Chapani, what are the grounds? Huh? What is it only? Adher Japal, counsel for the review petition had contended that the respondent has indulged in grave misconduct and criminal proceedings were also initiated. Though the respondent was acquitted of the criminal charge, but the inquiry and though the departmental proceedings were also initiated by issuing a charge memo, and the respondent has approved the administrative tribunal by filing OA number 7861 of 1998 challenging the charge memo, and the tribunal by orders dated 22/1/2004 was pleased to set aside the charge memo on the ground that the respondent is acquitted of the criminal charge. Agreed by the same, the present agreed by the same, a writ petition was preferred, and this honorable court was pleased to dismiss the writ petition by the orders dated. Agreed by the same, the review petitioners have preferred writ petition number 10730 of 2004, and this honorable court was pleased to dismiss the writ petition by the orders dated 20th October 2022 without appreciating any of the contentions raised by the review petition. Counsel for the review petition has contended as the respondent has impersonated, that's the allegation, impersonated Para 3 of impersonated one K Aruna whereas the respondent's real name is Parala Narsamma, and on a impersonation secured employment. And the inquiry was also concluded, and the inquiry report, and an inquiry officer has submitted an inquiry report and held the charge as proof. It is only the disciplinary authority was about to pass the orders. And this court has not properly appreciated the fact that the tribunal was not justified in setting aside the charge memo only on the ground that the respondent was acquitted in a criminal case. Therefore, appropriate orders will be passed in the review petition by reviewing the orders passed in writ petition number 10730 of 2004 dated 2010-2022. Counsel for the respondent had contended that the review petitioners have challenged the orders passed by the administrative tribunal in OA number 7861 of 1998 dated 22/1/2004 and this honorable court was pleased to suspend the judgment of administrative tribunal on 29/6/2004 and thereafterwards the disciplinary proceedings were not concluded and the same were kept pending for 18 long years. And the age of the respondent, what is the age of the respondent? Well?
She's supposed to retire next year, I think. She's next year.
And when the tribunal judgment was suspended by this honorable court, the review petitioners ought to have concluded the disciplinary proceedings so as to enable the respondent to take appropriate remedies against such conclusion of disciplinary proceedings. Admittedly, no effort was made by the review petitioners to conclude the disciplinary inquiry. Now, after nearly 18 years, the question of directing the review petitioners to permitting the review petitioners to conclude the disciplinary proceedings would not arise. Therefore, this court has rightly dismissed the writ petition. Therefore, there are no merits. Their review petition is liable to be dismissed. This court, having considered the rival submissions made by the parties here, the considered, this court has dismissed the writ petition on the ground that the orders of the administrative tribunal were suspended by this honorable court on 29/6/2004, which would mean that the charge memo, including disciplinary proceedings, stands revived. And for 18 long years, the review petitioners have not concluded the disciplinary proceedings. Therefore, permitting the review petitioners to conclude the disciplinary proceedings after 18 years of suspension of tribunal orders is not feasible. Therefore, this court has rightly dismissed the writ petition. Therefore, there are no grounds made out. More so, any grounds as contemplated under Order 47, Rule 1. Therefore, review petition is accordingly dismissed. Contempt, post after 4 weeks for compliance. Right. Compliance, you are in service, so why contempt?
Well, she has to get the benefits, my lordship. Since then, she is a constable. Every her batch mates has been
contempt.
Contempt.
We have filed contempt.
Yes, my lordship.
What is the contempt?
Contempt is not after the dismissal of the writ petition, my lord. She has to be promoted, my lordship.
That is not the subject matter, no. Contempt is not maintainable, right? Contempt is filed contending that the petitioner should be promoted to the post of head constable after dismissal of the writ petition. This court never adjudicated the issue whether the petitioner is entitled for promotion or not. If the petitioner intends to claim any relief for promotion, she has to file independent. Yes. Right. She has to pursue her remedies independently. Contempt is totally misconceived. Contempt is accordingly closed. Right. Thank you. Yes. Why? Post after 4 weeks. Next. Both cases are complete. Complaint.
This matter relates to compassionate appointment, but your lordship, your lordship, can you see the judgment of your lordship, para 6 page 2.
Okay.
Your lordship,
appear physically and 1 minute. Appear physically and argue. First after 4 weeks. Next.
Not complained, Miller.
Who is appearing? GP for services 1. Post after 4 weeks for compliance. Next.
May I please, ma'am? This Honorable Court was pleased to dispose of the writ petition filed by the government.
Post after 4 weeks. Next.
That is already adjudicated, relying upon N. Venkaya and Srinivasan, this Honorable Court disposed of. Last July, the batch of cases already in this case, they have, I don't know whether they have, but batch of cases already disposed of, confirming these Srinivasan as well as Venkaya.
Next. Post after 4 weeks. Kalyan Singh, post after 4 weeks.
Not complained, Miller.
Yes, who is appearing? Post after 4 weeks for compliance.
Much of this.
Yes. Post after 4 weeks. What is the content?
Allegedly, I have violated the order passed by this honorable court.
You have violated.
This was the allegation, madam.
Okay.
I have filed complaint.
Okay. Post after 4 weeks. Yes, you are appearing. Which case?
Yeah, it's come.
1161. Until 1161.
Which item?
99. It's not this matter. Next matter is not.
M1 93 number. MV Rajaram. Yes. Post after 4 weeks. Next.
Order is not complied with Miller.
Who is appearing? Post after 4 weeks for compliance. Next. Post after 4 weeks. Next. Yes.
Filed my resigned or Miller to the counter. They filed not.
Yes, Anurag.
$100.
Huh? You have complied. That 3%.
3% plus 3% plus one fixation has been done.
They have not fixed me the promotional grade pay and promotional post also. They only did what they did earlier, with which I approached this court. This court has observed that you have only given 3%
Okay,
increment.
post after
Not
4,
observed the order.
post after 4 weeks, right? We'll see next.
We are filing contrary in this case.
Post after 4 weeks, next. What happened in the contempt appeal?
That is pending, they sought time for counter on the last two occasions also. Let the counter be filed.
I have filed for expedite for dismissal. It will take it up on a regular basis.
So counters in this has to be filed.
Post after 4 weeks, next. Nothing be considered or rejected? Given relief. When the matter is taken up for hearing. R. Anurag has informed the court that the orders passed by this honorable court have been complied, and the case of the petitioner was considered for promotion, and he was promoted by proceedings dated 17/10/2024. In view of the same, this court is of the considered view that the orders passed by this honorable court have been complied. Contempt is accordingly closed. Next.
These are complied, my lord, by proceedings dated 21st August 24. My lord, I'll place them on record by next week, my lord. Your lordships may.
Post after 4 weeks.
My lord, yeah.
Next. Yes, DL Pandu. Post after 4 weeks. Yes, youngster. Yes.
Appearing for the petitioner counsel, your lordships. Despite there being specific directions from your lordships, the respondent has rejected my application. If I have to file a fresh writ petition, I have to go back to square one, your lordships. If I may just encapsulate the facts of the case before your lordships.
I will close the contempt. Anyhow, you are pursuing your remedies in the form of a petition.
Ultimately, your lordships have given a specific directions and your lordships order has attained finality.
Scope of a contempt is very limited. When it is deliberate, wanton, then only contempt. Then their understanding is incorrect. You must
Malad, if I may
make
only,
them understand.
If I may only try convincing your lordships by referring your lordships.
When they have rejected.
On
When the matter is
31st
taken up for hearing,
of May 2020.
We were informed by the counsel for the respondents that the orders passed by this honorable court have been complied and the case of the petition was considered and the same was rejected by proceedings dated 31/5/2024 and the petitioner has also taken steps to challenge the said rejection orders. This court is of the considered view. When the case of the petition was considered and the same was rejected, then this court is of the considered view that the orders passed by this honorable court are complied, contempt is closed. Since petition is already taken steps to challenge the rejection orders in accordance with law. Right, next. Yes.
Yeah, APSRTC.
Yes.
You have complied with the order, my lord, both APSRTC as well as TSRTC.
Complied. When the matter is taken up for hearing, the counsel for the respondent, standing counsel for the respondent had informed the court that the orders passed by this honorable court have been complied. And the case of the, what was the case?
Money, my lord, retirement benefits.
The corporation has paid gratuity amount and earned leave to the petitioners. While proceedings dated 21/8/2024. Counsel for the petitioner has also not disputed about the said facts. In view of the same, this court is of the considered view. The orders passed by this honorable court have been complied. Contempt is closed. Next. Krishna, yes.
May I please, your lordship?
Yes.
That the order is not complied with. But your lordship set aside the reversion order passed by incompetent authority on that ground that was set aside. After
Yes,
that, my lord, they restored, but with
When the appointment was given, my lord, as a food safety officer. What the reversion at the time of termination, my lord, was food safety officer. Again, my lord, food safety pursuant to my lordship direction, food safety officer he was appointed as food safety officer. Now, my friend is asking consequential benefit as seniority and other benefits.
once it is set aside, I have maintained that is the issue.
Counters, my lord, formal counter. First respondent is not competent.
Some competent authority should implement. One, they are not saying anything in the counter.
Okay, go on. For consequential benefits, you have a remedy, sir, not this contempt, right?
My lord, once my lord, your lordship, my lord, aware, my lord, your lordship, my lord, even at the time of my lord disposing,
No, there is
your
no
lordship,
direction. No, 1 minute.
No,
There is
no,
direction
the-
to- 1 minute, just listen.
yes,
There is no direction to grant any consequential benefits, right?
my lord, your lordship may kindly recollect, when my lord, I asked that, your lordship observed that, my lord, it is, once it is set aside, it is there deemed that they should give entire thing. Once it is set aside, that your lordship, my lord, made observation in that court, my lord, this thing. Once
No,
it's
we
set
don't-
aside,
No, we
my lord,
don't
once
remember.
I can't go, my lord, other court. Other, they are not. My grievance is that they never said anything, my lord, in the counter. Suppose your lordship may kindly see, they are saying something in the counter regarding my lord consequential benefits. I can understand. Nothing in the counter. My contempt is filed only for that purpose. Your lordship may kindly see the counter anywhere that I should approach other court and all these things. They said just we issued the order of promotion order. Other things never. My para 6 of my affidavit is
Okay,
that.
reserved.
Your Lordship may kindly see, my lord, counter.
Reserve.
Otherwise, my lord, there is no use at all. If they are implementing the order, they should say something.
Reserve.
Please.
Amar, share kiya tha. Which item? 104. What is the case?
My lord, dispose of the writ petition with direction to consider for wages for the date of removal to reinstatement.
First after 4 weeks. Next. Yes. Yes, Krishna.
My lord, your Lordship, with a great argument, so my lord, lengthy argument, your Lordship passed interim order directing to continue as village revenue assistants. My lord, subsequently, your Lordship also directed to pay the salary. Neither of the order they are implemented, my lord, the revenue authorities. No counter is filed.
First after 4 weeks, right? Next.
My lord, your Lordship posting, my lord, I said, my lord, not implemented. Nothing is there, did not file counter.
They are asking time. They are asking
My lord,
time.
already time is given, my lord. Already time earlier granted.
Right. Okay. Right.
See
Next.
that, my lord, the fate of the, my lord, petition approach, despite getting order, your Lordship may kindly consider this aspect, my lord.
Right. Next.
May I please, my lord?
For the first respondent, my lord, request to 2 weeks time for filing counter in this matter, my
There is
lord.
an urgency in the matter.
What is the case?
Second contempt, your lordships have directed my seat to be lifted from MNR and shifted to Medicity. That's first contempt I filed because 6 months they were not doing it. Then Millets, after contempt, they have transferred and they have permitted me to attend those classes. Now, Millets, the examination is scheduled. They are saying you go back to MNR and submit your dissertation and write examinations from MNR. They are saying they are not accepting my dissertation.
What is?
Lordship, today we have filed wakalat for R2, my lord.
No question.
R2 is the principal.
Where is the Pujita? Gurantla Pujita.
Well, it's
She's not made a party, my lord. Only.
No, she undertook that you pass orders. I'll see that this child is shifted from NMR to. She was appearing for.
The university doesn't prefer any SLP minutes. They are not agreed by the.
What happened to the SLP?
SLP minutes, there are no interim orders. I am appearing there regularly. Only for the ground, they wanted to, Honorable Supreme Court wanted to
Who
examine.
has gone to SLP?
The NMC has gone, not the university. Now, minutes after I file this content, minutes they do minutes. What they do is MNR gives me a notice asking me to pay fees. It's after filing content. They get it done, minutes. It's the SLP only seat blocking issue their lordships wanted to examine, but they have not interfered with your lordship's judgment. They sought stay was not granted at all. I was on caveat prince. All those proceedings also I have filed.
When are the exams?
Exams are scheduled in January. Dissertation I have to submit 6 months prior. That time is running. They say go back to MNR.
Lordship may
Accept the dissertation.
2 weeks time, my lord, we'll file counter, my lord. In fact,
Yes,
my lord,
special bench. What is?
no, in fact, my lord, as per NM, as long as NMC doesn't give
Yes,
permission to the
students,
university,
my
my
lord.
lord, we are handicapped, my lord.
Who must accept the
NMC has to take decision, my lord.
Not NMC. Well, it's the college have to accept it.
Who
College
is the
is
college?
Medicity. Respond number 2. They are saying university directed us not to accept.
We'll
And
file-
university issues a
Why you have
proceeding.
given such a direction?
No, we'll file counter, my lord. because
Why
I
you
have
have
to
given
also-
such a direction?
I have to get instruction, my lord.
What instruction?
When I issue a legal notice, minutes, they respond to it saying that you go back to MNR.
Right. The respondent university and second respondent college should accept the dissertation. What is it? Dissertation? Work or report?
Dissertation.
Dissertation of the petitioner.
And
So as to enable the petitioner to pursue her, what is it course?
PG.
Post graduation course in?
DVL.
What is DVL?
Dermatology, venereology, and laparoscopy.
Dermatology,
Venereology and laparoscopy.
Laparoscopy. course.
From your lordship may say from Medicity.
From second respondent college, right?
Obliged.
Right. Next.
Your lordship has said dissertation as well as examination.
My lord, this is, my lord.
You said only dissertation.
My lord, we don't have any objection, my
I
lord,
filed
as long as NMC.
dissertation and examination also.
He
Because
said
again
so.
I have to
Right,
come
so
back.
as to enable her to pursue her. So he said so. Right. Next.
Obliged.
Yes.
97 and 107 are connected, my lord. They-
Post after 4 weeks. Next.
Millard not complete Millard.
Post after 4 weeks. Who is appearing? Rachna Vaddepalli. GP for services 2. Okay, next. Post after 4 weeks. Next. We'll take up some other time. Post after 4 weeks. Kate case any sal interim senior. Go to Supreme Court. No?
There are actual errors. If the lordship corrected, even then the lordship feels that people will circle. There are factual errors. I don't know how it corrected. There are factual.
What are then you list it as for being mentioned? We'll correct them. Why review?
So release the proper application to be filed.
Then for being mentioned, we ourselves will correct and give you.
It makes no difference whether on for being mentioned at all.
Review means rehearing. That
Yes.
disturbs us.
Yes. The
For being mentioned, no problem.
Your lordship sent the impression saying the qualification which has been removed has been taken into consideration. It is not so. The qualification prescribed and the power of the chairman to relax and appoint.
78 amendment or something.
That is for the joint director. That stage has gone. Now it's a promotion as senior joint director. We
Okay,
can't have
right.
objection at this.
Right, next. All 3 cases, Amma. Right.
111.
They are not in 111.
Image this.
Right, next. Rammohan Reddy.
Yes. Review is not maintainable. They filed a review note in my appeal, it was dismissed before this started.
That the order of the learned stage is absolutely valid. Why we file review there? We also file review there before the learned.
What happened to that review?
That review is also pending, because we can't file a review before the learned.
First finalize it and come back here. Right, post after 4 weeks.
The observations of the government leader start saying that the order of the learned stage is valid is before your lordship.
If you file a count,
Let me file a review here to not there. Do those.
Who is it advocate counsel? Then
That we file because now, my lord, the review is also filed before the learned civil judge. He is taking, and my lord, writ petition is allowed in his favor. He filed a writ appeal. We didn't file a writ appeal. That's another
Appeal
problem.
is
We filed a
filed,
review. We filed a review. He files a writ appeal against his own order.
The appeal is filed here
Therefore, my lord,
for the positive direction and consequential benefits.
the lordships may only, my lord,
This review mirror itself is not maintainable. Who the officer has passed, because they have no appeal from the government. In my appeal, which was dismissed before the Honorable Court, they filed review. They want to allow my writ appeal.
may I say this, my lord, the lordships may, my lord,
you want us to allow the writ appeal?
your lordships may clarify, my lord, that
No,
this
one minute.
observation-
You have filed a review to allow the writ appeal?
review, my lord, that observations of the act, my lord, of the state, my lord, saying that the order of the learned civil judge is valid, my lord.
It is all you are making, Rahul. What kind of law?
Lordships may only, my lord, observe, my lord, that the review may be independent, because now we file a review then.
We have dismissed the writ petition, writ appeal. What is the question of?
But because now once the observations of the government.
Alright, sir, 1 minute. Your government pleader has appeared before us and he has said so. We have recorded in the open court. It's not that we
Yes, sir.
not,
But the concession is wrong.
and don't tell us that my voice is not audible. Every judgment I'll dictate in the open court. What is?
Concession, my lord, is,
No, he must have made. What is wrong with that? He must have made. Otherwise, why would you record? What personal interest we have got?
no, lord, I am not saying that.
Then?
I am saying that he must have made, my lord. I am
Then?
not saying he did not.
So once he makes, how can you?
I'm saying that concession, my lord, complete law, my lord, when the counter itself, we have been contesting before the learned civil judge, and our order has been.
Sir, it is very difficult to work, sir, as a judge. We will have to stop believing advocates there. You can't expect us to go to each and every line and just check what is right, what is wrong. How is it possible, humanly impossible for us to work? Don't know whatever it is.
Mirror is a compassionate appointment. He has not getting strongly mirror since 2005. He is suffering a lot. He has undergone operation, heart operation.
Yes, post after 4 weeks. Don't worry.
Mirror, lordship may. Because
What
they
is
filed
it?
dismissal with petition, mirror, review is pending before this honorable court.
Next,
Mirror, post next week, mirror.
4 weeks.
Mirror,
Why 4 weeks not?
This is a special bench. You can't ask questions like this, right? This is a special bench.
Because he is suffering not.
Maybe.
They filed dismissal petition.
Maybe.
But the review is pending
Sir,
before this honorable
special
court.
benches are not constituted by me, by the Chief Justice, no?
Not like that.
What not like that?
Not like, now the lordships may decide whether it is maintainable or not.
Right. Next.
I entered Wakalat for respondent in this matter, my lord. They filed review.
First after 4 weeks. Next.
Obliged.
May please. Yes, it has been called, no? 115.
I entered Wakalat, my lord. I have filed Wakalat. Due to appointment of the earlier council as GP, my lord, I'm for
First after 4
respondent.
weeks. Next.
The writ appeal was dismissed on the sole ground, my lord. The appellant was promoted in a direct recruit vacancy, which is not factually incorrect, my lord.
We'll see after 4 weeks. Next. Who is the other side? Okay, bring other side. First after 4 weeks. Yes, post after 4 weeks. Next.
Lordship counsel for the respondent.
Post after 4 weeks. Next.
This is a case where, my lord, that medical invalidation, medical disability, my lord, your lordships have directed me to produce a copy of medical board opinion. Incapacitated for further service, my lords, it has been interpreted as incapacitated for even life. That is the only point. Your lordships may kindly see
Who is
page.
the other side?
My lord, they are pressing for contempt, my lord. I am informed that she gave up the wakalat.
Who gave up the wakal?
The respondent.
Then who is appearing pressing for the contempt?
There they are pressing for the contempt.
Who is which
Mr.
counsel?
Narinder Pal Singh has filed contempt.
Okay, inform the court that review is pending.
Very short point, my lord. Very only one
Are you
line.
in their absence? How can I review?
At least suspension, my lord, still that
I
time.
cannot. Like, post after 4 weeks.
Blessed.
They also the respondent in this case.
May it please your worships. Let's review is filed by the respondents. Let's.
He is appearing for respondents, it seems.
No,
Respondents in the writ petition.
In the review, my
In
lord.
the review, we are the review petitioners, my lords.
Okay.
Respondents in the main writ appeal and writ petition.
Now, what is the case?
My lords, disciplinary proceedings were issued as against the delinquent, my lord, challenging which the writ petition was filed. On the ground that the inquiry was not conducted properly, the writ petition was dismissed. As against which the writ appeal was filed. Writ appeal is also dismissed by this honorable bench, my lord, with an observation that the punishment is without cumulative effect, my lord. That is the only point to be considered before your lordships. The observation made by this honorable bench, my lord, I'd like to make some submissions because that will have an effect. Lordships
You are
will
for the
permit me to-
employer?
Yes, my lords. Review petitioners, my lords. I am for the management, my lords.
Where is?
My lords, for a moment, if your lordships. My lords, my lords, my first submission, my lords, is at the threshold. First of all, no particular ground has been raised with regard to this cumulative, non-cumulative effect, my lords. That was not at all the ground taken in the writ petition nor in the writ appeal. All through, the ground has only been that the inquiry was not conducted properly, and that is how the case had been prosecuted in both the writ petition and writ appeal, my lords.
So what is the punishment here?
The punishment imposed is reduction of basic pay by initially 3 stages, my lord. In appeal, it was reduced to 1 stage. Now, the only thing to that, my lord, is with cumulative effect or without cumulative effect. For a moment, if your lordships
How
will
you are
please,
treating it as with?
my lords, for that only, my lords, lordships may kindly see the.
Where is the modified punishment order? Which page?
No, my lords, there is no modified punishment order, my lords. Lordships may kindly permit me to make one submission to the extent of this contribution. My lords, lordships may kindly take the writ appeal, my lords.
Where is 19/7/2013, madam? 19/7/2013 proceeding. There is a modified punishment order.
Yes.
And you say there is no modification of
No, no, my lords, I was
Page number
referring
90,
to.
Page number 90 in the writ appeal.
Page number?
90. 19th July 2013. Now therefore, the undersigned in exercise of the past conferred on rule 40 of the
Page number 90.
90, my lords, operative portions and 91.
Correct.
reduction of basic pay by 3 stages to the penalty of reduction of basic pay by 1 stage.
What does your regulation contemplate, madam?
My lords, it's at page 185, my lords. Writ appeal, page 185.
23.
My lords, the punishment was imposed under major penalties, clause G, my lords.
G doesn't say
Yes.
with cumulative effect.
Yes, yes, my lords. To that, my lords, my submission is, for a moment, your lordships may kindly see minor penalties, clause D, my lords. In minor penalties, it is given as reduction to a lower stage in time scale for a period not exceeding 3 years without cumulative effect. It is specifically given.
In
The
G, G with cumulative effect is also missing, no?
Yes, my lords.
So
I
how
agree.
it should be understood?
My lords, I'm only trying to make
No,
a...
please answer that.
Yes,
If
my
it
lords.
is not with cumulative effect, how it should be understood?
My lords, it is not specifically stated,
Then-
so I admit, my
So
lords.
then,
But
then that benefit should be given to that person, no?
my lords, the only thing I'm trying to say is same punishment will not be stated as minor penalties and major penalties
know.
at the same time.
You are
My
not-
lords,
no,
I have
no,
filed.
1 minute. You are all the creator of confusion. G you should have framed in such a way, with cumulative effect you should have added. If you have not added, can we permit you to add is the question now?
My lords, one submission. I have filed a memo with certain citations, my lords. The citation states that the entire, any statute whatsoever has to be read in a whole.
Yes.
The entire thing, my
We are
lords.
reading whole only. We
My lord,
but
the
you are
entire
trying to-
penalties,
No,
my
1 minute,
lords.
madam. We are reading as it is with naked eyes, but you want to add with cumulative effect in that, which is not permissible.
My lords, I understand, but if your
Correct, thank
lordships
you.
may kindly
At least be
appreciate.
wise. At least be wise now. Amend your regulations. Make it with cumulative effect. At least from here in afterwards, you can plug that loophole.
My lords, I only like to request your lordships may kindly consider this contention, my lords, if the whole penalties point is taken as a whole. The same punishment will not be enumerated in minor
know.
and major.
Don't know. It is all your making, no, madam. It is all your making, no.
Your lordships may just kindly consider that one. That is the only issue involved in this.
So whether you have conducted inquiry or not,
My lord, inquiry has been conducted.
according to you.
Yes, yes. No, my
According to
lord,
you?
even according to them also, inquiry has been conducted, and the very point is that the inquiry is not conducted properly. That was not considered, and the writ petition was dismissed. Every procedure has been done as per major penalties, my lords. Considering that, in fact, even in the initial award
Madam,
which was
trying to
done,
understand. A regulation which will not permit you to make it with cumulative effect, you want to make this court to add that. Can we do that? Is a question now.
my lords, I'm only trying to say that perhaps the court has an authority. It is interpretation of
We
the
cannot legislate law.
interpretation
No,
of the
madam.
rules put as a
No,
whole,
we
my
cannot,
lords.
no, we cannot legislate. No, we can't incorporate with cumulative effect to G regulation. Can we do that?
My lords, if your lordship will just permit me to read the citations which I have put place before your
Please, what is
lordship.
that citation, please?
Lords, I have filed by way of memo, my lords.
Right, please. Yes, madam.
My lords, the first citation is, my lords, AR 1955, Supreme Court 376, my lords. I'm only reading the
Yes.
operative portion, my lords. Paragraph 6, the cardinal rule of construction of statutes is to read like statute literally, that is by giving to the words used by the legislature their ordinary, natural and grammatical meaning. However, if however such a reading leads to absurdity and the words are susceptible of another meaning, the court may adopt a same. But if no such alternative construction is possible, the courts must adopt the ordinary rule of literal interpretation. My lords, in this case, I do understand that the language does not speak about it being cumulative in nature. I admit. But my lords, if the entire rule
1 minute, madam. G, according to your interpretation, it should be read as with cumulative effect in the absence of it, right?
Yes.
Another punishment possible in this type of punishments is for a period of some fixed period also will be there.
Yes, ma'am,
1
that's
minute,
what is
1 minute.
stated in the minor.
Another punishment is possible as permanently, is also permissible. So which word you want us to add? That's the point. You got the point? Reduction by 3 stages for a period of 2 years. That is missing.
Yes,
Correct?
my lords. Yes, my lords.
For a period of 5 years. That is also missing. Right? Just listen. Cumulative permanently.
Yes, my lords.
So how many combinations you want us to add? Please answer that.
My lords, because this honorable court was pleased to observe
No,
that it is
no, no.
specifically without
Madam,
cumulative.
CCA rules, central CCA rules or our state rules, disciplinary CCA rules, they contemplate reduction to various combinations
Yes,
and
my lords.
permutations.
Yes, my lords.
Reduction, initially, no time limit was prescribed.
Yes, my
Now,
lords.
CCA rules, central CCA rules, they were amended. Now, you must say for what period. Correct?
Yes,
Reduction
my
by 3 stages, you must also specify the period.
Yes, my lords.
For 5 years, 10 years, or permanently. Some things must be used, no, madam. Suppose if it is made as 5 years,
Yes,
then whether it is cumulative effect or not, it loses its significance.
Yes, my lords.
Got the point? Suppose if you are saying reduction by 3 stages for a period of 5 years, the question of incorporating with cumulative effect will lose its significance because that will be having effect of only for 5 years.
Yes, my lords.
Suppose it is 3 years, then the question of incorporating 3 years would not arise
My
with
lord-
cumulative effect.
My lords, my only submission to that is, my lords,
So
we are not,
if your
I'm not,
argument, no, if your argument is to be accepted, whether with cumulative effect should be inserted or for a period of 3 years should be inserted or 5 years or permanently.
no,
These
my lords,
very-
my only submission is, my lords, is only to the effect of it being cumulative or non-cumulative, my lords, because as your lordships have rightly
you are
stated,
assuming
if a time period is induced, my lords, then it automatically, it doesn't become major, there is a specific time period which is prescribed.
No, where your regulation doesn't.
My lord,
speak
in the
of-
minor penalties at clause D, a time period has been prescribed and it is specifically stated without cumulative
So
effect.
5 years
Both the-
also can be done, no?
Pardon me, my
5
lords?
years also can be done, no?
Yes, my lords.
That you can do in G, according to you.
Yes, my lords. But my lord, my only problem is because this court was pleased to give a clarification without regarding the point that it is not cumulative in nature. So
Because-
I'm only talking about
Because
that. aspect.
91 page,
Yes,
it
my lord.
stops there. That's the reason we have to clarify that.
My lords, I
Exactly,
understand, my
right.
lords. I'm only trying to.
Exactly.
My lord, it will only have
On the
a
last
huge.
occasion also what deeply we have argued the matter and without cumulative or cumulative. Then it is deemed not without cumulative. And moreover, the crux of the
What
case
is
is
the
that.
allegation, madam?
My lords, the allegation is that there was some misappropriation of
What
funds.
is-
No, nothing.
1 minute.
It is merely.
Senior, youngster is arguing, no? Please, you'll get your turn, right? What is it?
I'm sorry, my lords. It is not regarding misappropriation, my lords. It is with regard to misbehavior to the superior, my lords, with the superior. And there was a complaint even previously
What is
also.
the kind of misbehavior?
My lords, they were rudely talking and little bit of foul language, well, nothing related to any other thing. It was just rude behavior and
Leave him. Right? Just leave him.
On that day, what happened, my lord, is in fact he had
You
been
did a
to the
wonderful
hospital.
job. 1 minute. You did a wonderful job, but just leave it. Punishment is a punishment, whether it is this or that.
I can only say if your lordships may consider, my lords. Because it
Because
is just,
that-
my lord, I do understand there is a gap. I do admit. But definitely, my lords, if your
But-
lordships may
But
see
you are
the.
not opening up. Just go and plug that loophole. Amend the service regulations, there ends the issue. That's it. You want to incorporate permanently, you can. With cumulative effect, you can. For 10 years, you can. All those things.
My lord,
All is in your court.
My only submission is, my lords, by virtue of the citations which I have put before your lordships,
No,
this court has
citations-
the
no,
power
wait.
to
Citations will
imply.
not- 1 minute, madam. Citations will not fill up the gaps in the regulations. That is too fundamental. And law says enumerated punishments only can be imposed.
Yes, yes, I'm aware. Yes, please. I get it. I understand.
You can't impose some fancy punishments. Removal, dismissal is there. You can't say you are discharged. You can't use that.
My lord, it's only for the fact that it is already stated in the minor punishments as without cumulative effect. It is implied that it is with cumulative effect in the major punishments. That is my contention, my lords, because the same punishment cannot repeat
Because
as minor
kind of-
and major. And even the procedure for major punishment has been followed. Inquiry was conducted in
Madam,
detail.
Why we are not agreeing is, look at F.
Withholding of one or more increments permanently, my lords.
That
Same,
is,
yes.
that is cumulative effect.
Yes, my lords.
So if you have understood correctly, how can you omit G, madam? Now read G.
Reduction to a lower service or
No.
post or to a lower time scale or to a
That-
lower stage in a time scale.
Distance between F and G is only next line.
Yes.
So it's not that you are not aware. The consequences of F. F you said with cumulative effect, permanently, right? So
Yes,
same expression you could not have missed in G. That's the point.
My lords, and another thing is this aspect, this ground at all was not taken both in the writ petition nor in the writ appeal, my lords. Nowhere this ground was
And
raised.
here we have dismissed both the cases.
Yes, my lords.
You want us to allow the writ appeal?
No, that's not.
By filing a writ appeal?
No, my lords, that is not my.
Then in a dismissed case, you want to file a review. Next course will be left to allow the appeal.
It's only to the extent of this observation of the court, my lords. That is my issue.
If you want us to seriously review the order, we'll review and allow the appeal. Better thing is to withdraw.
His lordships may dismiss the review, my lords, but perhaps if I have to withdraw, I have to take instructions, my lords. I will not be able to immediately tell before your lordships. Lordships
your
may
own
grant. I'll take instructions, my lords.
Post
I'll
after
take
4
instructions.
weeks. But did a wonderful job, good job. Keep it up.
Much obliged.
Work hard.
In this case, one submission, my lord. My lord,
ఇంకా అయిపోయింది కదండి 4 weeks next.
No, it has happened back in the 2011, and by then, my lord, 1975 rules are prevailing by then. And the punishment award is 2012 rules.
Sir, 1 minute. While dismissing, we have thrown some life in your case, right? You must also understand that.
Very well.
Obliged, my lords.
Next. 122. Post after 4 weeks. Next. Yes, post after 4 weeks. Ready? Who is your other side, madam? He is not there. Post after 4 weeks. Next.
Kindly have it after 3 weeks. KRK Prasad, I am representing council.
Post after 4 weeks. Next.
125, 126.
Huh?
Senior is requesting.
Post after 4 weeks. Yes, post after 4 weeks. Post after 4 weeks. Who has filed review?
Kindly have it after.
Post after 4 weeks. Okay, sir, 131 P. Mohammed Andrade is in now.
Kavita Yadav requesting next week, will you?
Post after 4 weeks, right? Below 80-20. 130. Yes.
This is with reference to limited recruitment of the notification issued in 2012, my lord. All the posts are limited to only local candidates, in Hyderabad and Cyberabad and Rangareddy. The petitioners applied for the posts claiming to be local.
Recruitment, but SC/STs ఉంటాయి కదా, ఇట్లా కూడా ఉంటుందా? Local candidates.
No, because unfilled vacancies of, I don't know what circumstance notification was issued, my lord, but it was only
How
to
can it be limited to local?
notification says, my lord, it's only for locals.
Review is not maintained.
No, on that, not on that aspect.
We are entitled to ask everything.
No, the review, the issue is not on that. Only just a matter of fact I am mentioning, my lord. But here in this case, my lord, the petitioners applied as the local candidates of Hyderabad, my lord. They were provisionally selected. On verification, my lord, it's found that the schools in which they were studied from 1st to 10th class falls under the Rangareddy district area. Therefore, their selection was cancelled in 2014. They filed OA, and OA was allowed, my lords, as against which writ petition is filed by the government. While dismissing the writ petition, my lord, this court, your lordship may kindly see the order starts at page 8, page 12, my lord. This court, having considered rival submission, para 7, made by the parties of the considered view that the response were claiming as local candidates of Hyderabad city limits and the education institute in which they have studied are falling within the Cyberabad police state limits, and as admittedly the response are residents of Hyderabad city limits, the tribunal was justified in allowing the way in favor of the respondents. With respect to the fact that the education institute they have studied.
Hyderabad, it is all over.
No, issue is not. My submission is only, I say one point and leave it at that, my lord. Admittedly, my lord, the schools, local candidate state has to decide based on school study. Even otherwise, my lord, in the applications of the petition stated they are addressed in Rangareddy district. This observation that they are residents of Hyderabad is also not correct.
Sir, try to understand. There is a lot of confusion in demarcating between Hyderabad and Rangareddy, because Rangareddy was earlier part of entire Hyderabad
No,
district.
their applications itself say that, their address is, they say that Uppal Rangareddy district.
Correct, sir. Just listen now. When we studied, when we were young, the entire Hyderabad state was one. Subsequently, at the instance of somebody, that Rangareddy was carved out. So which road comes under Rangareddy, which road comes under Hyderabad is a confusion. Right or wrong? Please answer
No,
that.
but the
Just listen, sir.
Yes, sir.
That kind of problem is very much there, no? In city, right or wrong? If you
That is true,
if you
but
cross Hyderabad city limits, which is part of Rangareddy, nobody knows. No? Which is part of, is there any demarcation of some lines that this is Rangareddy and this is Hyderabad city?
No,
No.
my
So that
only,
benefit should be given.
no, my only submission this, Milord, recruitment has to be done only as per presidential order, Milord. The revenue district area is clearly demarcated. In fact, the DEO certificate also shows that, this recorded in the, it's school, the DEO has to give permission to establish a school. Rangareddy district DEO given permission to establish these schools.
I'll tell you, sir.
No, I leave it at that, Milord. Only review is only filed on that.
Review petition is filed, agreed with orders passed by the.
Because this observation, Milord,
This honorable court.
as per 37020,
Number 29803 of 2015 dated 29th December 2022. Heard. M.V. Ramarao, special government pleader for the state level recruitment, state level police recruitment board, and
Umarani Malad.
Umarani, counsel for the respondent. It has been contended by the review petitioners that the respondents have responded to a notification for the post of stipendary cadet training police constable, and they were provisionally selected. However, on verification of their educational certificates, it was found that they were hailing from Cyberabad police station limits and not forming part of Hyderabad city. Accordingly, the provisional selection of the response was cancelled by proceedings dated 22/12/2024. Agreed by the same, the response have approached the administrative tribunal by filing OA number 3229 of 2014 dated 14, and the tribunal was pleased to allow the OA in favor of the respondents on 1/5/2015 and set aside the cancellation of provisional selection. Agreed by the orders passed by the administrative tribunal. The review petitioners have approached this honorable court by filing writ petition number 29803 of 2015, and this honorable court was pleased to dismiss the writ petition by orders dated 29 December 2022 without appreciating any of the contentions raised by the review petitioner. Counsel for the review petitioner contended that the notification was issued for limited recruitment to fill up unfilled local vacancies of Hyderabad city, when once the respondents are not forming part of Hyderabad city limits, the question of considering these cases for appointment as police constables would not arise. Therefore, appropriate orders be passed in the review petition by setting aside the orders passed by this honorable court in writ petition number 29803 of 2015 dated 29th December 2022 and allow the review petitions. The counsel appearing for the response had contended.
Yes. Their residential address is also from Rangareddy district, it's not Hyderabad.
May I make one submission, my lord? At para 4, they themselves have stated that due to overlap, this issue has been arised. Your lordship may kindly take page 27 of my counter, my lord. This is the order copy of the Honorable Tribunal, para 14.
Counter of?
This is the order copy of the Tribunal, my lord, in which they have accepted. Your lordship may kindly take page 27 of contempt, my lord. Contempt, page 27.
My ground is not their residential address is also Rangareddy.
Page 27, my lord. Para 14, my lord.
The counsel for the respondent.
Yes, well, at this time, at the time of hearing, the respondents also furnished the report submitted by the Commissioner of Police to the first respondent dated 23/5/2014. According to the said report, one candidate, C.H. Gautam Kumar, has studied in Andhra Jyoti. My lord, in this they have stated last.
1 minute, madam. 1 minute. We are dictating an order, no, please.
In this they have admitted, my lord.
Okay, right. The counsel for the response had contended it the Commissioner of Police has submitted a report in which it was admitted that the area of Hyderabad city and Cyberabad areas are overlapping.
Yes.
When once the area of Cyberabad limits and Hyderabad city are overlapping, the benefit of local status of Hyderabad should be given to the respondents, and the tribunal was justified in allowing the welfare of the respondents, and this honorable court also justified in dismissing the petition. Therefore, there are no grounds. The review petition is liable to be dismissed. This court, having considered the level submissions made to the parties, they have considered. This court has dismissed the writ petition on the ground that that this dismissed on the ground that the Cyberabad police station limits and
It is not Cyberabad police station limits, but it's a jurisdiction, you know, local candidate.
dismissed the writ petition on the ground that the respondents are local candidates of Hyderabad city limits, and the educational institutions in which they have studied are also falling within the Cyberabad police station limits. When once this court has held that the respondents are residents of Hyderabad district and educational and falling within the territorial jurisdiction of Cyberabad police station limits. Therefore, the question of entertaining the review would not arise. Review petition is accordingly dismissed. Moreover, no grounds as contemplated under Order 47 Rule 1 are raised. Review accordingly fails. Review petition is dismissed. Yes. Yes.
101, you should have closed the content. The last observation that we are taking steps to file a writ petition may be deleted.
You have already taken steps, it seems.
That is because the client has, you don't know what client has.
Okay. 101 though. What మీరు ఉన్నారమ్మా 101 though. Case of the petition was rejected, and if the petition is aggrieved, he is at liberty to challenge the rejection orders in accordance with law.
One submission, my lord, contempt is.
Contempt post after 4 weeks.
Yes, my lord. Should be kindly said 2 weeks, my lord.
Who's appearing?
Recently, what we.
Post after 4 weeks. Next, all cases.
Kindly next week.
Post after 4 weeks, right?
We have finished our lunch, madam.
But we did not. No problem. Both these writ appeals are being disposed of by way of a common order. The issue raised in these two writ appeals is one and the same. For convenience, the facts in writ appeal number 1188 of 2024 are hereunder discussed. Heard J. Sudhir, counsel for the appellant, and C. Shiva, senior counsel for the appellant. One more to refer to. Note of a Right, so and then GP for yes, special government pleader for you are also there. Huh? Special government pleader for the
That time, Lord, I happened to have watched.
okay. P.S. Rajshekhar, standing counsel for the first respondent, and special government pleader for the state. It has been contended by the appellants that they have responded to a notification issued by the first respondent on 26/4/2022 for the post of Group 1 vacancies. In all, 503 vacancies were notified, and the preliminary examinations were conducted. Sir, earlier it was cancelled. What paper was leaked? It is preliminary or final? And the preliminary examinations were conducted as the question paper was leaked. That necessitated the state government to cancel the preliminary examination on 17/3/2023 and subsequently no. Subsequently, the preliminary examinations was once again conducted on 19/6/2023, and the said preliminary examinations were also cancelled in pursuance and orders passed by this honorable court in the petition number 15811 of 2023 dated 23/9/2023 on the ground that the biometrics was not conducted on the students who have taken up, not students, on the candidates who have appeared for the preliminary examination. And the learned single judge of this honorable court has directed to reconduct the preliminary examination after conduct the examination by taking biometrics attendance in the examinations. And the Public Service Commission, instead of reconducting the examinations in pursuance to original notification dated 26/4/2022, has cancelled its earlier notification on 19/2/24 without any power and issued yet another notification on the same day, that is 19/2/2024. In all, this time, 563 posts were notified. The counsel for the appellant had contended that the earlier notification dated 26/4/2022 was confined to only 503 vacancies, and the state could not have, state Public Service Commission could not have cancelled its earlier notification and allowed others to compete for the very same 503 vacancies who became qualified after issuance of original notification dated 26/4/2022, thereby marring the chances of appellants for selections. The counsel for the appellant had further contended that when original notification was issued on 26/4/2022, there was no increase of percentage of reservation in favor of ST candidates. Now, the percentage of reservation for ST candidates has been increased from 7% to 6% to 10%, by GMS number 33 dated 30th September 2022. If only the earlier notification was followed, the ST reservation was confined only to 6%. With the issuance of fresh notification, the ST category candidates are being benefited by 4% of reservations in favor of them. The counsel for the appellant has further contended that as per the original notification dated 26/4/2022, only few set of people were eligible. With the issuance of a fresh notification on 19/2/2024, many candidates who were not eligible as on the date of earlier notification have become eligible, and the competition for the Group 1 post has increased multifold. The counsel for the any other contention, Sudhir? Not able to hear. Right. Yes.
My lord, 503 vacancies. My lord, not only 6 to 10, my lord, but I have also stated by virtue of that increase in more number of STs are called for mains, and then that many number are excluded, OCs.
Correct.
That's one thing. And so
counsel for the appellant has further contended that the revised procedure is also being followed by the Service Commission in pursuant to GOMS number 29 dated 8/2/2024, wherein the Service Commission is ensuring that for final examinations for each category of candidates, for each category, the Service Commission is calling candidates in the ratio of 1:50. Thereby, the ST candidates are being more called with the enhanced reservation in favor of them, thereby denying selection opportunities to other category candidates. The counsel for the appellant further contended that the original selection should have been confined to 503 posts only, and in respect of 60 vacancies which were added in the new notification dated 19/2/2024, separate recruitment process should have been initiated, wherein only persons who have become eligible for those posts can be considered. But because of the cancellation of earlier notification, the Service Commission had enlarged the scope of the participation of candidates who were initially not eligible,
and
are now made eligible.
And making
Now,
that's by making.
right?
Yeah, I'm sorry. I'm sorry.
Yeah, man, Ashok.
I'm sorry.
Who are not eligible are made eligible uh, with the issuance of second notification, fresh notification on that is on 19/2/2024. The counsel for the appellants has further contended that the preliminary examination was conducted on 9/6/2024, and all the appellants have participated in the preliminary examination, and the provisional key was published by the Public Service Commission on 13/6/2024, inviting objections to the preliminary key, and the time limit was prescribed up to 17/6/2024, and two of the appellants have submitted their objections in respect of 15 questions. 15 questions, and the objection submitted by the appellants was not considered by the expert body, and the final key was published on 7/7/2024. The counsel for the appellant had contended that the final key finalized by the expert committee in respect of question number 41, 46, 79, 112, 114, and 119 is concerned. The answer as finalized by the expert committee is erroneous, and to demonstrate the same, the counsel for the appellant had relied upon $299.97, Shiva? 297, correct? Relied upon and contended that the answer furnished by the expert body to question number 41, which reads as follows. Page 47, question number 41. In respect of the answer furnished by the expert committee is 216 when it comes to hazardous waste, brackets to management, handling, and transboundary movement, brackets closed. First amendment rules is concerned is totally incorrect. As far as hazardous waste, brackets to management, handling, and transboundary movement, brackets closed, First Amendment rules is concerned, have been framed in 2009. To strengthen their argument, they have filed the Ministry of Environment and Forest notification dated 21st July 2009. A perusal of the same would disclose that the rules were framed in 21st July 2009 but not 2016. Likewise, they have contended that in respect of several other questions also, the answer finalized by the expert committee was found to be incorrect and agreed by the answers as finalized by the expert committee. The appellants have approached this honorable court by filing writ petition number 21239 and 22320 of 2024. And the learned single judge was pleased to dismiss the writ petitions by way of a common order dated 15th October 2024 without appreciating any of the contentions raised by the appellants. Counsel for the appellant had contended that when the answer furnished by the expert body is demonstrably wrong, then courts can intervene and refer the cases, refer the disputed questions to independent expert body. The learned single judge ought to have referred these cases to an independent expert body instead of dismissing the writ petition. The counsel for the appellants had contended that except for two appellants, all the other appellants were not qualified to participate in the final examinations, final main examination. Had the Public Service Commission conducted the exams in a transparent and fair manner, the appellants would have secured a place to participate in the final main examination. Any other contention, Shiva?
My lord, for the interim order, we have demonstrated only one question, my lord. For the purpose of interim order.
Passing final orders, sir. We are passing final orders. No question of interim order.
No, interim order can be rejected, my lord, but
No.
final argument, then we will have to perhaps argue whether all the 6 questions are right or wrong, at least, if not anything else.
We have heard so much, Shiva.
My lord,
No, we began our dictation.
my lord, I leave it to your
No,
lordship.
just listen, Shiva. We began our dictation. Both the writ appeals are being disposed of by way of a common order. For convenience, writ appeal number so and so are here under discussed.
Then, my lord, I'd only suggest one thing, my lord. The other objections which we have raised regarding other questions as contained in the writ petition will also be dealt with by this, your lordship may say. Otherwise, what happens, my lord, it will be only one question that we have debated.
Just follow the court, no? That allow us to fill up those gaps.
Since your lordship asked if this is the only contention, my lord, I thought I'll have to be doubly safe. Because whether it is in our favor or against that,
No,
this may...
one minute, Shiva. What happens if writ appeals are kept pending? Nothing, no useful.
No, my lord. Your
No, no.
lordship, for the purpose of balance of convenience, may not interfere with that. That doesn't mean to say the examination will go on and that a person who is not meritorious will get it. All the cases where the examinations have been asked to be reheld may have been only in the final order, not at the interlocutory stage. Pending finalization of that, kindly ask them to stay their hands off is what we have asked. So,
No, in 2011, Shiva, one second, Shiva. In 2011 also, my lord, the prelims was over, mains were over, matter went up to Supreme Court. Supreme Court redo the...
No, now also you can go to the Supreme Court.
my
No,
lord,
I am not...
we have a constitutional remedy to go to the highest court, my lord. Everybody may be aware of that. But the question is, my lord, if your lordships are, what is it, limiting the debate only to 41, other questions are worse than this. We taught an act, if they don't understand, they will not understand anything. Therefore, I took act and that my learned friend took the constitution.
The counsel for the appellant had contended it. The final main examinations are scheduled to be held on 21st October 2024. If the Service Commission is permitted to go ahead with the final main examinations, then the appellants would put to irreparable loss and hardships. Therefore, the final main examination be postponed till such time that the Service Commission refers the disputed questions to an expert body, to an expert independent body, and only after independent expert body furnishes a report, then let the Service Commission undertake the next process of selection, that is conduct final main examination. Any other arguments, sir? That's all? Right. Okay. The counsel appearing for the respondent had contended it.
But I'm sorry, my lord. I've also argued about that extension of time, my lord. Your lordship can recall.
The counsel for the opponents has further contended that as per the notification dated 19/2/2024, it was made very clear that the last date for submission of application will not be extended under any circumstances, and contrary to the said clause, the Service Commission has extended the last date of submitting applications, which would mean that the Service Commission itself is not following its own, is not complying its own conditions in the notification, thereby by extending the last date for submitting applications, more number of candidates have participated in the Group 1 selections, thereby delaying the opportunity, thereby enlarging the competition, and which would be detrimental to the persons who have applied to the original notification dated 26/4/2022, right? Therefore, appropriate orders be passed in the writ appeal by postponing the final main examinations, which is scheduled to be held on 21st October 2024, and further direct the Service Commission to refer the 6 disputed questions, that is question number 41, 61, 66, 79, 112, 114 and 119 to independent body of experts, and let the independent body of experts examine the disputed questions, and after obtaining opinion from the independent body of experts, let the Public Service Commission proceed with the next stage of recruitment process, that is conducting final main examination. The counsel appearing for the respondents had contended that the Service Commission has got every power to cancel, modify the notification, which 180 18.1. 18 point, which page? 187? 187, I think. Wait. Where is the notification?
Yes. Notification is at page 177.
177 page.
197 is the clause 18.1. 197. In Mr. Sudhir's file, that is WA 1188.
Well, that's a new notification. Cancellation has been done for the old notification. The tracing should be from the old notification, not
That
from
is
the new.
in 106.
The standing counsel for the commission had contended that the notification dated 19/2/2024 itself deals with power to cancel para 18 of the said notification. The commission decision shall be final, and in the said para 18 it was made clear that the Service Commission can withdraw, cancel the notification at any time by duly
I'm
to all the
sorry,
concerned.
I'm sorry, my lord. That withdraw / cancel is in the new notification. What has been cancelled is the old notification. So they have to draw from the old notification.
Here in the old notification,
Page 106, para 18.
There is no word for cancel. They have added now. Because they cannot cancel. And just because they have mentioned in their board doesn't mean that they have power. Power has to be traced to some statute, not to the notification.
the commission has got
It only says withdraw. There is no cancel there.
withdraw is nothing but cancellation.
No, then there is no necessity for adding because they have understood there is a withdraw
Okay.
and
Para 13 of the notification dated 26/4/2022, para 18 of the said notification empowers the Public Service Commission to alter, modify, or withdraw the notification at any time. And that decision of the Commission shall be final. In exercise of that power only, the Service Commission has cancelled the earlier notification dated 26/4/2022 on 19/2/2022, on the very same day, a new notification is issued. That is notification number 2 of 2024 for the post of 563 vacancies. The Service Commission had to cancel the earlier notification in order to include 60 new vacancies in the Group 1 cadre, and in order to implement GOMS number 33 dated 39/2022, wherein there was a change policy of the state government, wherein the state has enhanced the reservation in favor of scheduled tribes from 6% to 10%, and also in order to ensure that each category is adequately represented in the form of 1:50 ratio, in order to implement GOMS number 29 dated 8/2/2024. The counsel for the respondent has further contended that the appellants, having participated in the selection process, and the appellants have not challenged the orders of cancellation of earlier notification and issuance of new notification number 2 of 2024 on 19/2/2024, and the petitioners and the appellants have participated in the selection process, and after participating in the selection process, after participating in the preliminary examination, having not been qualified, the appellants cannot turn around and challenge the cannot challenge the selection process. And in fact, 2 of the appellants are already qualified for the main examinations. The counsel for the respondents has further contended that the Service Commission has published the preliminary key on 13/6/2024, inviting all the candidates to file objections, and the time limit prescribed for filing objection was also up to 17/6/2024, and 2 of the appellants have filed their objections, and it is not that the Service Commission has finalized the answers to the disputed questions on its own. The Service Commission has referred the objections to an expert body, and based upon the opinion of expert body only, the Commission has finalized the answers, finalized the key answers by publishing it on 7/7/2024. Therefore, a transparent method was adopted by the Public Service Commission by referring the disputed questions to an expert body. Only upon the opinion of expert body only, the answers were finalized. The counsel for the respondents has further contended that nearly 31,000 and odd candidates are likely to participate in the final main examinations, which are scheduled to be held on 21st October 2015. That is 2 days from today, and the candidates have also 90% of the candidates have already downloaded their hall tickets. Postponing the examination at this point of time may not be feasible. The entire administration has been involved in order to conduct smooth final examination. Postponing the final main examination would cause lot of prejudice to thousands of candidates. That too at an instance of 6 appellants. 2 of the appellants are already qualified to participate in the final main examination. Therefore, stalling the examination process, which is marked by several controversies in the past. 2 preliminary examinations were conducted, and the Public Service Commission could not conclude the recruitment process consequent upon paper leakage at the first instance, and by not following biometrics in the second instance. If the recruitment process is stalled, several unemployed youth will be put to irreparable loss and hardship. Therefore, the learned single judge has rightly not interfered with the case. and rightly dismissed the writ petitions. Therefore, there are no merits. Writ appeals are liable to be dismissed. Yes, any other contention?
Lord, the extension of 2 days was done because there was a glitch in the payment gateway of the bank, because of which we received representation that time has to be extended. Therefore, my Lord, 2 days had to be extended because there was a
Counsel
payment
for the
glitch.
Respondents has further contended that the last date for submission of application had to be extended as there was technical glitch while accepting the application forms. In order to ensure that everybody gets an opportunity to submit their applications, as a last indulgence, time was extended by 2 days only. On the representations of several candidates.
Yes.
Therefore, there are no merits. Writ appeals are liable to be dismissed. Any other contention? That's all. Sudhir, any other contention?
My Lord, Ranvijay Singh, my Lord, your Lordship may kindly consider.
Judgment in the
Very well.
చెప్పమంటే చెప్తా.
No, my Lord, no, my Lord, the question whether courts can go into the question of question and answers and all, my Lord, the learned single judge put it squarely on that, my Lord. That is why, my Lord, we are pressing. That's all.
Shiva.
I have nothing more to add, my lord.
This court, having considered the rival submissions made by the parties, has considered you. The Public Service Commission has finalized the key answers based upon expert body's report. It is not that the Public Service Commission has finalized the key answer on its own. Therefore, and as far as the contention of the appellants, that this court should examine with proofs whether the final key answer as finalized by the Public Service Commission is right or not is concerned. This court cannot go into that aspect as this court is not expertise to examine as to whether which answer is a correct answer. When once expert body has finalized the key, then it has to be left open to the experts only. It is not for the courts to finalize the key answers. As far as the contention that the
Lord, I'm
Service
sorry.
Commission, as far as
I'm sorry. We never contended that your lordships have to finalize the key. We are only contending that there is some palpable mistakes.
one minute, sir. You are trying to demonstrate 141 question. You are trying to show 297 page number and say that this answer is correct to section question number 41. We can't decide that. That's what we said.
No, our case is not for your lordships to decide. Our case is to refer the matter because there is a doubt. Because we are not experts. We are not saying that your lordships sit as an expert. That is not our case, nor my friend Shiva, if I am not wrong. We are only trying to say,
where is the affidavit? 65.
We have not argued, my lord, that we lordships should finalize.
Correct.
Once there is a palpable mistake, my lord, lordships will see, my lord, if there is a glaring mistake, matter will be referred. Unlike Supreme Court, where the last occasion where they have done it. Because courts are saying if there is a mistake, matter has to be referred. There is no bar.
87,
right?
para 43 is the only ground. Right. Page 87, para 43 of the affidavit of Mr. Sudhir. Page 87.
Read.
Ground D and para 43. This is the only place, my lord, where they say.
Where is the prayer?
Prayer, no, my lord. I'm saying the averment your lordship wanted to know with respect
Not averment. Where is the prayer?
Prayer, my lord, is page 90. Page 90. From 89 onwards, my lord, it's a 3-page prayer starting from 88.
Read.
But call for the records pertaining to web note dated 19/2/24, through which earlier notification number 4 of 22 dated 26/4/22 was cancelled, and the consequential second notification number 2 of 24 dated 19/2/24, and set them aside as bad, illegal, unfair, unsustainable, unconstitutional, besides being contrary to public interest and contrary to the directions of this honorable court in WP so and so, as affirmed by the division bench in writ appeal so and so, and consequently direct the first respondent PSC
There
to
is no
conduct.
question. We have not raised anything about disputed questions, Sudhir. You have not challenged anything.
I mentioned in para E.
Prayer lo lekunda immandi meeru.
Prayer lo,
Right.
I'm telling.
1 minute, Shiva. Where is your prayer, Shiva?
Para E of my prayer also talks about flaws.
65.
My petition starts, my lord, at page number 168. Your lordship may kindly see.
66.
Consequently, cancel the entire preliminary examination and hold the same, duly taking care in both setting the question paper and finalizing the key, or in the alternative, direct that the key be revised if necessary by referring to some independent body like Union Public Service Commission, and further take action including conducting the main examination only after this exercise is done.
What is the main interim relief, Shiva?
In the interim relief, I said suspend it till such time the question is decided.
Huh?
The interim relief in the writ petition is what my lords are asking?
Yes.
Yes, my lord. That your lordship should get at page number 87. Pending disposal of the writ petition, it is prayed that this honorable court in the interest of justice be pleased to direct the first respondent to stay all further proceedings in pursuance of the results declared on 17/7/2024.
Thank you. We have understood.
Grateful to your lordship.
You should have asked interim prayer to refer it to independent expert body. And this kind of stay business will not help anyone.
My lord, if the Public Service Commission was
1
so
minute.
magnanimous in doing it.
1 minute. You should have started interim prayer before the single judge to refer to independent body.
Correct, my lord.
Thank you. Great.
Correct. Hindsight advantages will be there. I can't, then the objection would be, main prayer, interim prayer are same. Your lordships have got rich experience at the bar also, my lord, which
Those
says,
days are gone,
if I say-
Shiva.
they are
Those
not
days-
gone, my lord, they
Shiva,
have gone back to worse, if I may say so, with great respect.
At least
Previously, main prayer, interim relief was the sheet anchor of every respondent.
Yes.
We have not moved miles from that.
22nd court, I am aware of.
Yes, we have not moved
Yes.
away, miles away from that, my
Yes,
lord.
yes.
We are still in the respondent attitude is the same. The entire system may have changed. Councils may have become very wise, but the attitude of the respondents
We are
goes back.
No, we are vanishing. Still, system is continuing
But
with that what to do.
we all owe a duty to bring it back, though not to the past glory, at least to some glory. Our effort is only that. It has gone, therefore let us also leave it, my lord. That's a fatalist theory. And I am sure your lordships do not contribute to that. It is going back, let us give a hand at best. We may
Shiva,
go down along with
Shiva,
them.
try to understand. We are not interfering for one reason. You have understood. You must also look from our angle also.
My lord,
Because
I first, your lordships are aware. When we were in the office, my lord, we were only thinking about respondent and on what grounds the court will reject our case. I still continue that practice.
no, don't.
I still continue that practice. I start from the negatives case. My learned friend Rajshekhar must have told me 100 times that you are a devil's advocate.
No,
When
no.
he tries to discuss with my case, I would say only respondents how the courts will react. My learned friend would say I am a devil's advocate. I continue and I am proud to be a devil's advocate because I know what your armor is. I know what your weapons are. I try to train it with that. I may fail miserably as
No.
usual.
Why do you think that you are failed?
No, my lord, I am
No, just
failing.
listen. One
One
minute.
second, my lord, I am not failing as an advocate.
No.
I may fail to get the relief which my client said because always there are more than one perspective to a problem. Every court and every person need not accept what other man says. But my only endeavor is you should have asked that prayer, my lord, may be a difficult situation in the current standard, quote unquote 25. Nothing more, my lord. That's all. And nothing more than that. 22.
My lord, adding to what Shiva said, my lord, I am not going into those finer aspects. My lord, I only say that the prayer of ours is to, because there are so many problems, to set aside the preliminary examination. First of all, either cancellation should be cancelled, go back to the original thing, or at least set right all these things and then do it. Therefore, we are not asking you to when we are mentioning the
AC meeting also.
We are really sorry.
No
my
issues.
lord.
No issues.
We will not, at least I will not interrupt your lordship. Since your lordship asked a question, I rejected. Otherwise, I was just sitting silent.
Imra Sandal. A perusal of the prayer made in writ petition number petition number 21239 of 2024 is concerned, there is no challenge to the disputed questions and 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 finalizing the key. And as far as the prayer in writ petition number 22320 of 2024 is concerned, no doubt there is a prayer, there is a final prayer that the disputed question should be referred to an independent expert body, but that relief is being asked in the main prayer instead of as an interim relief. Had the petition appellants have sought a interim relief initially to refer the disputed questions to an independent expert body, then perhaps the learned single judge could have explored the possibility of referring the disputed questions to an independent expert body. But the interim relief sought by the petitioner appellants in the said writ petition is staying off all further proceedings, which will not serve anybody's purpose. The council, a perusal of the notification further makes it very clear. A perusal of the notification dated 19/2/2024 would make it clear that the entire schedule of selections were already stated, wherein the preliminary examination were supposed to be held in the month of June, and the main examinations were scheduled to be held in September and October 2024. When once the calendar, when the schedule of selection process has been set out in the notification, the question of postponing the final examination, which are scheduled to be held on 21st October 2024, would not arise, and stalling the examination, which is scheduled to be held in another 2 days, would cause inconvenience to several thousands of students who are likely to take up examinations. And this court can take a judicial note of the fact that the Service Commission has issued the notification way back in 2022, and in spite of 2 years, in spite of several attempts being made to conduct the selections, they have ended up in disputes, and finally the preliminary examination was conducted in the month of June 2024, for which the next process of selection is final examinations, which is scheduled to be held on 21st October 2024. Therefore, this court is not inclined to postpone the final examinations, which are scheduled to be held on 21st October 2024. And as far as the contention of the appellants in writ appeal number 1188 of 2024 is concerned, that they are challenging the notification dated 19/2/2024 on the ground that the Service Commission could not have cancelled its earlier notification and issued a fresh notification. To this contention, the appellants have, having participated in the selection process, having participated in the preliminary examination, and having been unsuccessful in the set selections, the appellants cannot turn around and challenge the notification dated 19/2/2024. If the appellants were agreed of issuance of fresh notification on 19/2/2024, they should have challenged the notification. They could not have challenged after the results published in the preliminary examination. Therefore, the judgment rendered by the Honorable Supreme Court in, what is it, Ashok Kumar? What is it?
Yes.
Ashok Kumar. Would definitely attract, wherein the Honorable Supreme Court has categorically held that persons who have
Ashok Kumar versus State of Bihar, my lord, 2017, 4 SCC 357.
Wherein the Honorable Supreme Court has held that persons who participate in the selection process cannot turn around and challenge the very same selection. Therefore, this court is not inclined to interfere with the orders passed by the direct single judge. both the writ appeals fails, accordingly they are dismissed.
Lord, one aspect, my lord, your lordship said appellants in 1188 having participated and not qualified. In fact, 1 and 3 qualified, my lord. Appellant 1 and 3 qualified, only 2 did not qualify. Your lordship just now said, yes, my lord.
The appellants.
So therefore, the judgment of Ashok Kumar, all that is applicable only for those who are not participated, failed.
Why would anybody
and they
who
are-
has qualified challenge the notice?
So why not? I am not a person failed. I am qualified.
Deeply obliged, my lord.
Because I'm asking for time. If the final exams are postponed, the candidates who would be participating would be put to irreparable loss, and the entire administration has already taken steps to conduct the final examinations in a smooth way, and stalling the final examinations would cause irreparable loss to scores of individuals, that too at the instance of 6 unsuccessful candidates.
Obliged, deeply obliged. Single level Raj. इसको पूछो, सुबह